Behind every crime lies a story waiting to be uncovered, from chilling mysteries to untold truth. This is where the darkness comes to light.
Roaring buzz lights up the air, faces tense as stories tear, truth and lies like a tangled dance. Justice here takes no chance. Gavel strikes, hearts beat fast. Witness takes stand, shadows cast. Whispers loud like wildfire spread. In this game, none's ahead.
Hello, everybody. Hello, hello, hello. Good morning. Oh, good morning, Willa. Good morning, Lois. Good morning, Stephanie, Paula, Denise. Hello, all my lurkers. So how is everybody today? Good morning. It's Friday. It is gonna be a good day. Oh yes, pull a chair and join us, and press that like button as well. All my days, my day, I woke up at normal time, right? But oh wait, my camera is not even on. Oh, there I am, guys. I am here. This has just been one of those days. I woke up rather early, started my day having breakfast with Garden Pot, and we were chilling. I am here. And then I started working on some stuff. I've updated the spreadsheet and chase after some cases that I'm following that I need to do some work on and everything. And then I was like, okay, let's start setting up for the trial and for what we are doing. Good morning, Paula. Oh, it's so good to say that. I am absolutely discombobulated today. Oh, one second. I forgot to do some. Um. So. Thank you very much, Willa, for reminding me of that. I really, really appreciate that. Yeah. Whew. So I did a video, right, last minute thing of this new case of Nikita Kasap out of Waukesha, Wisconsin, because I've been obsessed with it. And I was like, oh, there was a hearing yesterday or the day before or something. And I said, I want to catch up on this. I want to really see this thing, what's going on. So me and our friend Zio jumped on StreamYard. We did a video and everything. We finished, and then I was supposed to edit the video, right? And then just release it. I fell asleep. I absolutely fell asleep, which is, well, not unsurprising, but I did. So I woke up like an hour ago, or even not even that. And I was like, sugar, I need to get this done. So very quickly did the quickest editing that I possibly had done. um and then I put it out, and I finished. Did my nails, because I'm off for a few days, so I did my nails. Oh, hello, good morning, Emily. Learn my last name or else. Oh my days, I haven't turned that off. Hang on, thank you for the reminder. See, this is why I am all discombobulated and I haven't done. Oh my days, honestly. I There we go. It's fixed. Thank you for the reminder. For some whoever pressed the heart button, thank you very much for the reminder. So anyway, we are going to be doing the case, and it is going to be a brilliant day. It's going to be a good day. We have a verdict watch to do. I have the feed on my phone. As soon as they start, I'll put the clock running, and everything will be sorted. I have a proposition for you. Do you guys want, and then we can catch up on that one either. So you remember James Crumbly? Ugh, great. Now the business phone is ringing. I have to take this, guys. 1 second. Give me 1 second. I'm so sorry.
the active ingredients. And the metabolites that are in the urine, which last longer, were explained by the medical records that we just admitted today from the family physician, who prescribed Entex HC, a narcotic for his ear infection that has hydrocodone. Dr. Markey admitted hydrocodone is consistent with taking this cold medicine that the doctor prescribed. So when we're talking about what the evidence represents, like I said, thank God what we say is not evidence. You can rely on your notes and you can rely on the transcripts. Well, you can't rely on it, I can. And also, Ms. Stermer said that Dr. Markey had no opinion as to whether the skull injuries, the lacerations on the head, were related to the ban versus something else, which you're suggesting is a frying pan. Dr. Markey said on page 18 in his testimony, those injuries that you saw to Mr. Stermer are consistent with having been run over and striking various undercarriage components, isn't it? Well, the injuries themselves, as I stated before, very well it could be to being struck and overrun and striking things on the undercarriage of the motor vehicle. That's his actual words, not what you heard he said. And you can look at your notes, because these are the actual words under oath. And it's consistent with Dr. Zacheski, I just call him Dr. Z, who is a renowned biomechanics injury mechanism expert with decades of experience working with brain injuries, who told you all of the lacerations and these skull fractures. It sounds bad, a skull fracture. A depressed skull fracture has been explained as you take your finger through some icing on a cake. It doesn't even hit the bottom of the bone. There's no linear skull fracture. There was no brain injury, as Ms. Zuderveen tried to suggest, Markey said. That's not on the autopsy. These are AIS-2 injuries, Dr. Z said. Moderate injuries. Not related, there's no evidence that it was related to a frying pan. So that's the first one, drugs set them on fire. Number two, crack them with a frying pan, then set them on fire. Except that came from Dardita Gordon, who admitted to so much mental illness and on so many medications normally that she would have been, except she was in jail when she gave that statement. And she said, they don't give me my meds in jail, and I have memory problems. And guess what? She admitted that it was Detective Macioski who suggested, could it have been a frying pan? It was a jailhouse snitch. Yeah, I guess it could have. You look at all of this with a cynical eye, and when you're evaluating the witness's credibility, that's unreliable. That's not consistent with the physical evidence. We don't have to prove anything to you, but we bring you objective evidence, follow the science, follow the objective evidence, and you can't come to any other result other than there's reasonable doubt. And by the way, what devious mastermind who's going to torch the place and kill her husband spends the afternoon packing up Christmas decorations? What, an hour before I'm going to torch my place and kill my husband? None of this makes sense. Starting with all these witnesses who prepped with the...
Hello, everybody. Sorry about that. I just literally shoved Wolfgang talking to you guys so you guys could be a little bit entertained until I returned. My apologies. Like I said before, I also manage Garden Bots business and just had a business call, a call that I had to take. I need to leave that post-it note there for him. And yeah, so it's was just that. My apologies. I really apologies. Good morning, everybody that I haven't seen in. Hi, Sherry. Good morning, my friend. Welcome in. William, hello. Willow, I think I've already said hello, but I say hello again, everybody. Hi. How is everyone doing? It is Friday. It's going to be a crazy day. I don't know where I was even. Oh, yes. We are I was talking about that they're gonna have jury instructions as soon as they start. They haven't started yet. Good morning. Hi. It's been one of those days already. Good morning. How hope everyone is doing good and you have a good day of work. Paula, my friend, I really hope your day improves. Denise, I hope your work as well improves because of your caseload, of your workload, because you would had a day off. And I hope everyone else has a great day. So, yeah. I was saying, because we have this to finish, right? And we can watch at 2 point speed because we don't really want to listen to them anymore, and then be right on verdict watch. What I was thinking is, after that, after this, we can watch the hearing that James Crumbly is having right now, because he's asking a new trial, because I'm still quite interested on that one. Hopefully the court sound it's better than it was. And oh, I'm there. I was thinking, where am I? I'm in there in a little corner. It is so warm in the UK today that I have decided to wear a short sleeve. Oh, I was showing you as well my nails. I've done my nails because yeah, I woke up way too early and got my nails done for the weekend for some reason. It's but anyway, well, yes, the dad from the school pew pewing incident as well. Yeah, that's him, James Cromley. He has a hearing today, so I'm really quite interested to watch. So I think that could be a good thing to watch while we are on verdict watch, because as soon as the verdict starts, I'm gonna put thank you. I did it myself. I'm getting, like, not saying that I'm the best, but I'm getting good at this. Uh, I'm getting good at this. I'm having I really enjoy doing it. Oh, the court is starting, so we'll just watch. Yeah, I want to watch too. So the point is, let's finish these closings that has taken forever and took our minds out of it. Just finish it off because we can put a 1.25 and it will be a lot quicker. And then we can skip jury instructions. I will do a poll about jury instructions, but then we'll see what happens. Yeah, let's get cracking. Oh, carry on cracking because you're already.
With the prosecutor and all of a sudden change your testimony or hear new testimony. So frying pan is number 2. Setting the fire by itself, well, we already talked about that. That's clearly reasonable doubt as to where the fire started. No doubt as to Linda Stermer didn't have anything to do with it. And you didn't hear a single word from Mr. Leroy or the prosecutor that gas on the sweatpants had anything to do with Linda Stermer. Because if they had that opinion, it would have been front and center. It would have been blown up on the wall 10 feet high. No opinion, your notes, you can pull them all. Nobody will find a note that says that. The gas on his pants, which he claims is the whole key to the case, that it had anything to do with Linda Stermer. 4, run him over after you set the fire. Well, you heard testimony from Dr. Z that it's a 5-mile-an-hour impact. And those injuries, you didn't see anything where he was run over by a 4,500-pound vehicle, no broken legs, no broken bones, rib fractures consistent with CPR, no brain injury, no skull injury, no nothing other than icing on the cake and some lacerations, consistent with being run over at a low speed, as Dr. Z said, with a high load. High load is it's 4,500-pound van. And Dr. Z's testimony is undisputed. Because don't you think, with the resources that the government has, if they could find anybody, and I mean anybody, to counter Dr. Z or counter Dr. Markey, that they would have? But this is the same group that's letting Leroy defend himself. They won't even hire Shinsky, because Shinsky's not going to go their way. And finally, the 5th way she tried to kill him that day was to suffocate him. So here she is in this panic state of chaos, fight and flight, and out of her mind, and she's yelling, Todd, stay with me. And what did they say? We think she was laying on top of him. She wasn't laying on top of him. She was trying to hold her husband and keep him alive. And if there's any little doubt that you have that's supported by reason and common sense, that doesn't require you to abandon reason, then that's reasonable doubt. And if there's reasonable doubt, you have to vote not guilty. There's no intent here. Clearly reasonable doubt as to the intent and lack thereof. I'm going to talk a little bit about the inconsistencies, and of course, there were a lot. But you know what they were? They were details after she got to the top of the stairs, when her world blew up. While she was downstairs and calm, everything consistent. I'm in the laundry room, and Todd is upstairs, and that was relied upon by Leroy in terms of finding the area of origin. It corroborated his physical findings. His physical findings corroborated her testimony. Nothing about these witnesses that they're bringing you is being corroborated. We talked about how Mr. Trinkle said how people train so they hope they can combat panic when the adrenaline is high in a stressful situation. And when you're in the jury room, I want you to think of this. A lot of people Monday morning quarterback and go, I wouldn't have done that. I would have jumped on my husband. I would have saved him. While you're having a cup of coffee in the jury room or you're watching TV in 2020, I would have done this, I would have done that. You don't know what you would have done. What you would have done and what you could do in the situation are two vastly different things. So when you're thinking about what she was going through, you have to put it through the lens of this high burden, this presumption of innocence, and that none of us know, unless you've been in a fire and running out in your underwear, what people go through. I'll talk a little bit about their witnesses, not much, frankly. Certainly not going to go through every witness of theirs. We talked about Dardita Gordon. Let's talk about Kathy Ilge, who was the one who said that she talked to me about the coffee cup and the drugs, and that she found jewelry in the van, Linda Stermer's van that she drove, remember, within a week or two of the fire. And in the center console was jewelry, which to a cynic would mean you're just kind of squirreling away stuff, the valuables, because you don't want them to burn up in the fire. Well, look at the objective evidence in this case. First of all, you remember Kathy said, within 2 weeks of this, I'm in the van. And in the center console, there's the jewelry. Do you remember the van was confiscated by search warrant that night and examined the next day? The picture of the center of the console of the van, as Macioski showed, taken on the 8th the next day, there's no jewelry. And Macioski, who's supposed to put a detailed report together anytime you do a search warrant, it's the property you take and confiscate and take into evidence, never mentioned jewelry because it didn't exist. And here's the kicker. This is a murder investigation. What police department in a murder investigation involving a bloody van is giving the key evidence back to the family in a week? Think about that. When you're back in the jury room and you're thinking about the credibility of these witnesses, no police department. This is a murder investigation, and that is a critical piece of evidence. You don't give it back to the family. Oh, the other funny thing, among many, is that she said, let's strike that. I'm going to go to Kate Fox. But Kathy Ilge can't be believed. Testimony's unreliable. And for them to put somebody who would talk that crazy and that to give testimony that is so demonstrably false by the evidence, you have to wonder as you start to think about these weird things, why are they putting up these witnesses to talk about things that would be impossible, that are demonstrated to be impossible? Maybe because they can't talk about the fire. Maybe they want you to dislike her so much you ignore that there's no evidence of a fire being caused intentionally. And nobody can prove it, so we want you to dislike her. We don't want you to think highly of her. She had an affair. She said this, she said that. She treated Todd badly. Because we don't want, in 90 minutes, they talk 5 minutes about the fire, why we're here. And in the 5 minutes, you heard one sentence. Leroy said, it's consistent with an intentional fire. She didn't tell you about the evidence that supported that. She didn't tell you that we don't know how the fire started. We want to give you the why, we want to give you the motive, but we don't want to tell you how, because we can't. Let's talk about Kate Fox. Kate Fox came in here, dressed really nice, and talked about a coffee cup and the drugs, remember? We talked about Dr. Markey, how he blew that apart. But the other thing that struck me is, you were supposedly best friends with Linda Stermer, but because her sons lost their father and she had to take care of them, she had to switch a shift, you felt like she betrayed you? And so maybe you have an axe to grind. And when you look at her credibility, let's measure this against the credible evidence and the objective evidence. Linda Stermer, while she was carrying on this affair, told me to close up her post office box because her husband's going to find out. The federal government allows a stranger to come in and close somebody else's post office box? Really? They want you to believe that? This is who they're putting up as a credible witness to talk about she confessed, she did this? The objective evidence. When you're evaluating credibility, look at what's out there that can't be true. And finally, Trevor Stermer, Trent Stermer, they came on. They both disliked their mom very much. They both only started calling her Linda instead of Mom after she got charged in 2009. And they were both living with Grandma Stermer before the trial and after the trial. Just take that in consideration. I tried to be as nice as I could, but I had to point out all the inconsistent statements under oath, and it probably bored you because every 30 seconds I was going, remember, you're under oath, right? And you swore to tell the truth, and you did tell the truth. And eventually, after you ask so many questions, they go, yes, I was telling the truth when I said Mom was acting normal that day. Which would be consistent with Mom's wrapping up the Christmas decorations and putting them away an hour or two before she's going to torch the place. You can't have it both ways. You can't have it both ways. You can't be this diabolical killer, master planner, so they can say it's premeditation, and on the other side of the coin, you're saying she's going around wrapping up the Christmas decorations. And by the way, remember they said, not only is mom acting normal, but if I'm in Torch's place, I'm not going to tell my sons, all right, see you when you get home. I'm going to say, don't come home for 5 hours. Or maybe you need to go to another friend's after you go to the mall. You don't say, just come home. I'll see you when you get home. That's not somebody who's premeditatingly going to murder her husband. And when you talk about, you're going to get a jury instruction about premeditation, it's going to be, there has to be some time connection involved with premeditation. Everybody has said a lot of things, maybe to their spouse, to their friends, or whatever, that they say in the heat of the moment, or tell their friends in the heat of the moment. But if this happened on January 7th, and she's telling Kate Fox this in the summertime before, that's not premeditation. That's not evidence of premeditation. There was no evidence of premeditation on January 7th. None. Talk about Chief Leach and all of a sudden his sudden memory. Oh, by the way, you do remember that Trevor and Trent also met with the prosecutor and all of a sudden remembered some things that they had never said before. Verge Franks, one of the police officers you saw first on the scene, smelled gas. That's after Matheny's coat is on Todd Stermer. Didn't have a report, never said it before. I'm going to just kind of wrap it up this way. In order for them to obtain a guilty verdict, they have to show that the actions of Linda Stermer caused the death of Todd Stermer. The actions can only be she set the house on fire because he died of burn injuries. I was thinking about showing you the video of the burn of the sweat. You've seen it. You know what happens to polyester pants. And the question was, well, if he was on fire, how did the pants not burn? Since they burn so easily. And you heard Mr. Frankel, who cited NFPA 921, chapter 24, and said, we all know, well, we don't all know, but skin burns at about 110 degrees, 108 degrees. You get 108 degree temperature, your brain cells are burning and dying. Clothes, as it said in 921, ignition temperature, pretty much the lowest, is about 450 degrees. So that can explain the thermal burns, which he said, these were not contact burns. People who die in a fire when they've been immolated, they look like a burnt hot dog. That wasn't this case. This was thermal heat burns, which explains why the pants weren't burned, which also explains that there was no gas on the pants in any amount that could be related to anything with this fire. Because I wear my sweats Friday, Saturday, Sunday, Monday, it doesn't matter. People do that. You can't tell how long the sweats had gas on them the last time they were washed, where he was. If he can't rule it out, it's reasonable doubt. And finally, I told you have rights. Linda Stermer has been fighting this since I've been with her for 6 years now. And Skip and our team. So now, excuse me, I'm going to turn her future to your hands. Follow the evidence, follow the scientific evidence, follow the objective evidence, and understand how high the burden is to achieve beyond reasonable doubt. Clear, convincing evidence, a firm and definite belief that any proposition is true, not good enough. If there is any doubt that's supported by reason and common sense, where you don't have to throw out reason, that's reasonable doubt. You deserve to be on a jury that holds the government to that burden that our founding fathers set forth. You deserve to be on a jury that holds the government to that high burden on every single fact that they need to show to prove those elements. They can't check a single box. Forget 3 boxes or whatever she was talking about. There's no evidence to suggest that this was an intentional fire. It was such a shoddy investigation by the fire sergeant, fire marshal, that there's nothing but reasonable doubt. People can't be 2 places at one time. And finally, they have to rule out reasonable doubt for every single element. You know why we're here, really? Is because Sergeant Leroy mailed it in. And 18 years ago, he destroyed Linda Stermer's life by mailing it in. So when you're deliberating and you have a conviction, and we said you took an oath to not mail it in. You took an oath, if you have a conviction, to stay as long as it takes. And stand up and not be bullied by somebody who maybe wants to go home on Friday and doesn't want to come back because I missed 3 weeks of work already. There's too much at stake. A person's freedom is at stake. Don't mail it in. Todd Stermer mailed it in. Leroy mailed it in. And you know what? He not only did a disservice to Linda Stermer, but to Todd Stermer and to you. Return a verdict of not guilty on all counts. There's a verdict form that you're going to see. I didn't have a chance, we just got it this afternoon. Didn't have a chance to blow it up on a board. Possible verdicts. You may return only one verdict on each charge. Premeditated first-degree murder, not guilty. First box. 2, felony murder, the arson, not guilty. Everything depends on whether there was a fire that was set intentionally and was it set by Linda Stermer. There's no arson, there's no crime. If there's no crime, there's no premeditation. Put this in your hands to do your job and hold yourselves to your oath. Thank you. Not guilty.
Thank you, Mr. Mueller.
Housekeeping time, Your Honor.
Break. Okay.
Right, so now this part, that was the part that really got to me, because he was like, housekeeping, Your Honor. It's like, dude, you don't talk to the judge like that. It's like, Judge, could we have an housekeeping, like a break? No, it's not. Sorry, I did not like that. Absolutely did not. But they go on a break, and then they have the state rebuttals case hearing thingy majiga. So let's pull that forward. Oh, and then after this, I know I said we're not gonna watch jury instructions, but we are gonna watch the spiciness that happened this morning already in court, and then we'll watch James Crumbly. Okay.
Matters to address before we bring the jury in for rebuttal?
No, Your Honor.
Here comes the jury.
Thank you, Your Honor. I'm not going to address 2.5 hours of rebuttal, but I can't get up here and not talk to you about the misstatement of the law that was made by defense. First of all, judge is going to tell you may not let sympathy, bias, or prejudice influence your decision in any way. That means sympathy for anyone, sympathy for the boys, sympathy for Sandy Stermer, sympathy for Ms. Stermer. It doesn't matter. That's not your job. Your job is to find out if the evidence presented checks the boxes and the elements are met. And sympathy does not play a role. I also want to talk to you about reasonable doubt. We have stated it over and over and over. And every crime is made up of parts called elements. Prosecutor must prove each element of the crime beyond a reasonable doubt. Defendant is not required to prove her innocence or do anything. If you find the prosecutor has not proven any element beyond a reasonable doubt, then you must find the defendant not guilty. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of defendant's guilt. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not imaginary or a possible doubt, but a doubt based on common sense and reason. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances. All his charts and going over the different types of burdens of proof doesn't change your burden of proof. It is based on common sense. It's not imaginary, it's not possible, but it's based on common sense. So get back grounded with what the judge is going to give you. He made several statements, I'm going to reference them as I just go through quickly, that all you got to do is just find one thing and you're done, your job's done. No, ladies and gentlemen, that's why we presented all of the evidence. Your job is to take all the evidence, all the pieces of evidence. If you were to take out the fire inspectors, and we just brought in Dardita Gordon that said she cracked him over the head with an object, you found lacerations, you saw the blood on the van, you found the gas on the sweatpants, if you believe that testimony, you could find her guilty. So each individual person that comes into you is but one piece of evidence. Mr. Trinkle is one piece of evidence. Scott Leroy is one piece of evidence. Your job is to evaluate all the evidence. All the evidence. Mr. Leroy didn't do anything wrong. He didn't ruin, I see your face. He didn't do anything wrong by investigating this crime. He wasn't trying to destroy anyone's life. He's just trying to investigate a crime. He got up there, he honestly told you, you know what, I do things differently today. I should have taken more pictures. I should have done more. He's one piece of evidence. But the interesting part about that is that you can still look at all the other evidence to corroborate some of the things he found. And that's what you need to do. You need to look at, Mr. Trinkle didn't even say that there was a different place of origin other than in the living room. Mr. Trinkle was then wanting you to pinpoint a very specific place of the living room and said, if you can't pick that one little spot in the living room, you can't even declare it an arson, ignoring all of the other pieces of evidence that you guys have been presented. The witnesses that were attacked, what you can also do is you can look at the witness testimonies corroborated by other witnesses. So when you have one witness saying something, it's corroborated by another witness, and it's corroborated by another witness, that may start to make you feel that information is credible. Kate Fox identified Chris Williams, told the police about where he lived. They went there and he said, yeah, it's having an affair with her. It's corroborated by more than just one person. Even Tina Benny corroborated that there were photos at the scene. You can look at that to say, maybe what Kathy Ogwa said is corroborated by somebody else in determining your credibility and the credibility of the witnesses. That's your job. Your job is to determine the credibility of the witnesses. The boys explained their inconsistencies. They told you this is really the first time, it is the first time that they've been able to come in and testify under oath. They explained those inconsistencies. And you can take that and you can weigh that in terms of judging their credibility. It's you that decides the evidence. If it were just, we have an arson or suspected fire and we hire an arson investigator and he says it's undetermined, okay, I guess there's no crime, we can all go home. That is false. That is false. This is an entire investigation. This is an entire investigation. Even Mr. Trinkle told you this is not a legal determination. That's why you're here. He is one piece of evidence that you can consider. Just one. All the evidence that we presented ties to Linda's intent. Her actions support murder. Her actions support premeditation. These are things that are supplied to you to be able to determine if those boxes are checked. You're not simply here as a battle of the experts. That's not what your job is. That's not what your job is. Your job is to evaluate all of the evidence. His expert, Mr. Trinkle, told you, well, first of all, he denied that if he'd ever been involved in a prosecution where there was an undetermined fire. So basically, if the arsonist is so good that everything's burned up, you can't prosecute? That makes no sense. That makes no sense because you're not even looking at any of the surrounding facts. He said he was never involved in a prosecution where it was an undetermined cause on a fire. And then when Attorney Blair said, well, what about people versus in this very courtroom? And did you see his demeanor change? Because he got caught and didn't know how to answer it. And then basically said, oh, well, I've never been involved in the prosecution where my opinion's been wrong. Because I'm never wrong. He is one expert that you can judge his credibility and his findings. I never asked you for a pass. I asked you to hold me to my burden. And I told you that I wasn't going to bring in 200 people, anybody who'd been talked to, but I was going to bring you in enough evidence to prove the crime, enough evidence to check those boxes. I never asked you for a pass. I'm not asking you for a pass today. I'm asking you to take the evidence that you got from me, from this trial, from those witnesses that took the stand, in totality, and make your decision. There's no pass here. Like I said, you can completely rely on the witnesses that you believe. So if you believe Dardita, you believe the person who analyzed for the gas, you believe the person who then found the bloodstains under the car, you've got enough evidence right there to make your decision. You determine who's credible. You determine what evidence is credible, and if that meets the elements. He stated, if there's one reasonable doubt, your job's done. You can all go home. No, I wish it was that easy. You have to consider everything and all the evidence. One reasonable doubt and you're done. That's a misstatement of the law.
It's a misstatement. It's absolutely wrong.
I'll give these are closing arguments or arguments of counsel, but I'll give you the instruction on reasonable doubt jury when you go to the jury room, or before you go to the jury room.
If you have reasonable doubt about an element being proven, that's the law. Not if you just have one reasonable doubt about a particular testimony, particular witness. I wish it was that easy. You're not done. Your job is to evaluate all the testimony and all the evidence. He brought up that Linda was in the laundry room. It can't be her. She's downstairs. We talked about that. We talked about how the vapors could have ignited. We talked about a possibility of where that could happen. But you're also then relying on Linda's statements that she was even in the laundry room. A person who only says statements that don't incriminate her. So you can certainly consider that. You can certainly consider her credibility with everything else in all her descriptions, and whether you believe her or not. Counsel's asking you to rely solely on Mr. Trinkle, asking you to forget that you're the jurors, you're the judge of all the evidence. No one person determines the verdict. And I mean by that, I mean no one witness. It's taken as a whole, and what you feel elements are met. Possibilities. Said you can't consider possibilities. Well, you can consider possibilities if they're backed up by other evidence. You consider the possibility that that gasoline was purchased by her because it's backed up that she bought it. You can consider the possibility that the 1 gallon gas can was used by her because it's a possibility, it's on scene. And you can consider it a possibility because there's no other reason that gasoline should have been on Todd Stermer. You have other evidence that talks about all the other clothing that Matheny had put on him did not test positive for gasoline. You have evidence that that duck boat never ever had an engine. You can use other evidence to make your determinations, and what would then lead towards a conclusion. You consider everything. He wants you to believe that Steve Leach came in and relied on Scott Leroy's report, and voila, there was gasoline, and so he smelled it. Well, you have other evidence supporting that there's gasoline on the clothes. You can consider that. Ladies and gentlemen, they lived in this house for 3 years. It took a long time to build, but they lived there for almost 3 years. No reported issues, no reported fires. And in the documents that you received on the building from the building inspector, there's several written letters by Linda of why they're asking for delays before they moved in. And they detail out Todd Stermer's knee injuries. It wasn't that they were saving up and trying to, put in the cheapest materials or buy as they go. Read her letters. The ones to the building inspector are in there. They're her detailing out how Todd hurt himself. And they had to take a break, and then they needed to restart. Either Mr. Stermer is the most unlucky person in the entire world, or all these dots that he talked about lead to the next dot, and lead to the next dot, and lead to the next dot, and show that this is more than just an unfortunate, unlucky series of events. There's been lots of testimony that Linda Stermer becomes overly emotional, only shows emotion when she's pressed. She can turn on the emotion to avoid the questions. Connie is very emotional in that 911 call. What you may be hearing from Linda is that she's scared she just got caught. All she's doing is wailing. You don't hear her talking. She might be horrified at her own actions. Might not have expected everything to go on the way she wanted. Certainly been enough testimony for you to consider. She might be trying to cover her own tracks. Maybe doesn't want to talk to anybody, wants to play the part. She didn't hide baseball cards, wedding ring, gun. All that can be replaced. It didn't mean anything to her. There was a little bit of mistestimony or misstatement. Ms. Fox said that she wanted to go to the house to find the cup because Ms. Stermer had put something in there, I think she said a tranquilizer, you can check your notes, but changed her mind. And she didn't want the police to find it. That's why you didn't find it in the toxicology. I doubt that Kate knew what the toxicology was when she made that statement. Kim Thompson got to that scene and looked at Ken while she was on scene, and she said, something isn't right. Something isn't right. She didn't need to talk to anybody else to figure that out. That something wasn't right. And then as all the pieces of evidence come in, gasoline on his underwear, gasoline on his socks. Yeah, you're darn right. Something's not right. Ms. Stermer, he said, is either the greatest actress or is genuine. Maybe she just got caught. Maybe she didn't expect to have to try to kill him 3 times before it was completed. And that's what caught her off guard, got her upset, and caused her to act the way she did. Mr. Leroy was also a detective. He was a sergeant with the Michigan State Police. He also then approached this for looking at the evidence that he found. This is why he collected the gas can. No matter how hard you try, ladies and gentlemen, you cannot explain the gasoline on Todd's pants, his underwear, and his socks. Mr. Leroy, Sergeant Leroy, also testified that he worked with the insurance company, got all their documents. They talked about a form that they filed with the insurance company. He had access to all their documents. He reviewed all those documents. And when asked by Attorney Blair if he would change any of his opinions after reviewing all those documents, his answer was no. He had access to Mr. Willison, to Mr. Shinsky, and Greg Stornzan's, any of their documentation, any of their pictures, any of their information. He had it all. You, as jurors, can look at those pictures and see if that area of origin makes sense. You can evaluate that with Linda's statements. You can make those determinations. Now, you can use the expert's advice, opinions, because that's what they are, is opinions, to help you make those determinations when you're going through those pictures. But you can look at that evidence as well and say, does it make sense? He wanted you to focus on the fact that you just can't find there's a source, didn't know how the gasoline gets there, but consider it when determining it in his data. And so because he can't say that the gasoline got there a certain way, then you must rule it out. No, you can still consider it in your data. You can still consider it as part of this. I think Mr. Trinkle and Mr. Leroy both agreed that the ignition source could have been the fireplace. A lot of talk about not ever finding what the ignition source was. I believe both of them testified that that was an open flame in that room and was the ignition source. We want you to focus on the contamination. However, if you look at the other testimony that's been provided you, that boat's ruled out, and Mr. Matheny's clothing was ruled out through testing. Mr. Z, or Professor Z as he calls him, he can say that he thinks the injuries came from the van, but he couldn't match where or what part. He didn't even say what part could have caused the symmetrical on the either sides of the head. He's not a forensic pathologist. He didn't examine the body. There's a total separate laceration on the back of the head that I questioned him about. I said, you can't even see it in your picture, can you? Because he's laying on it. You can only see the top laceration. He was speculating. He didn't even concern himself with the other injuries on the body and where that blood could have come from. You're also going to get an instruction on credibility and how to judge credibility. One thing that you can read for yourselves is that the judge is going to tell you can view how an expert answered questions as a way to try to determine their credibility. Mr. Trinkle didn't answer questions directly when it implicated his client. He danced around. He was very happy to answer any questions he felt didn't implicate. Yet he also agreed on many points of Scott Leroy's investigation. He also reminded you that his conclusions are always right. But again, he is not the only person to consider in this case. His opinion is not a legal determination. The defense wants to put all their eggs in one basket. Rely on Trinkle, can't say it's an arson, because ignore all of the other evidence, and if you don't have an arson, you got no crime. That's not what you're here for. You're here to look at premeditated murder, and you're also here to look at the felony murder and all the evidence presented to you. He also went on and on and on about this unfinished living room, yet the boys testified, one said it was 95% done and they were getting ready to paint. He did say there was no carpet. There were just area rugs. But his testimony was that the walls were finished and they were getting ready to paint. Defense read a little bit of the testimony from Dr. Markey, just the sentences that fit his narrative. But look at his report, look at your notes. And when I asked if you can determine if those lacerations came solely from the van, he said, no, I can only say it's blunt force trauma. I said, can you determine if they came before the fire or after fire? He said, no. He said, no, you can only say it's blunt force trauma. And is also in his report, some of those rib fractures were not consistent with CPR. He detailed it out. Doesn't want you to rely on Dardita because of her medical conditions, yet Dardita had some very, very, I would call it insider information. And when police pressed her, you have her transcript, pressed her and said, is it in a frying pan? She said, no, she just said she hit her with an object. Read that. She knew what Linda had told her. He is correct that Todd Stermer died of thermal injuries. But that doesn't mean you can't consider the fact that she ran him over, jumped on his body. You can still consider all of that, especially with premeditation. He died from the injuries inflicted in that fire. If you find that she intentionally set it, then that's where you go to count 2. And count 2 is the felony murder in the commission or the attempt and the arson. So no arson, no crime? It's not true. You have to weigh all the evidence. You have to weigh all of the evidence, all of the elements, and you need to look at premeditation. You need to look at the attempts, the planning, and all that goes towards premeditation. I'm asking you to make sure you read the law and know why you're here. And you're here to evaluate everything you heard separately. You decide what you want to believe. You decide what's credible. And you decide if, based on what you think is credible, if those elements are checked. That's your job. That's your job. It's not to be narrow-minded. It's not to have tunnel vision. It's to take everything you heard and evaluate it. That's why we brought in the people that we did. Each individual piece is important. No piece is more important than another. No piece. You decide what's important. You are the jurors. You are the ones making the legal decision. I appreciate all your time. Thank you.
sorry about this, guys. Again, Garden Bot was annoying me. Sorry.
I had every intention of reading to you
Right.
final
Right. Hang on.
instructions, but I'm looking at all of you.
Right. I need to focus because I am trying to get the two things done. So that was the closings all done. So right now, hang on. I need to watch this. Sorry, I need to keep an eye on the live right now because they are about to start verdict watch, and I need to put the timer on as soon as that starts. So let me just hang on. I need to go to the live one. Hang on. There we go. I need to go back to the beginning of the stream so I can you can see the spiciness. There you go. Those two are, yeah, those two are not playing.
Stermer, Counselor present, Ms. Stermer is present. Jurors are all here for final instructions. Any matters to address before we bring them in?
Yes, Your Honor.
Okay.
The elements of the charges discuss causation. Let's talk about the act. The act, it's undisputed, that caused Todd Stermer's death was the setting of a fire. Ms. Zutterbein in rebuttal yesterday said, you don't have to find arson or anything with the fire, consider the totality of the evidence to find first-degree murder. Everything in every single claim and count talks about the actions of Todd Stermer. The act that caused the death is the setting of the fire. So it was just an incorrect statement by Ms. Zutterbein in a rebuttal. And I don't want the jury going back thinking, we can talk about the man and the motive and everything else, but we don't have to worry about the fire in order to convict. You have to have the act to convict. So I think the jury should be instructed that there was an incorrect statement, not intentional, but an incorrect statement. The action that caused the death is the setting of the fire. That's undisputed through Dr. Markey.
Ms. Zutterbein?
Thank you, Your Honor. I think that's a mischaracterization of what I said. I said that I actually quoted him. I don't have my paper in front of me what he said, and I said you can consider all the things. I was referring to strictly, he kept saying if you don't have arson, meaning Mr. Trinkle arson, you have no case, you have no causation, you have nothing. And I kept saying you have to look at all of the evidence. So I think that's a miscategorization. I think it was very clear in my rebuttal. It's certainly, I was informing them that they can look at all evidence. And he said, if you don't have an arson, you don't have a crime. That's the word I heard, and that's the statement I wrote down, and that's what I was addressing. You certainly can have a crime. You can certainly have premeditated murder. You can have second-degree murder, all of her actions together. So I think that's a miscategorization of my rebuttal.
Your Honor, Justin, she said you do not have to find arson. You don't have to find the setting of the fire in order to find first-degree murder. Yes, you do. It's the action of the defendant, which is the fire, that caused the death. So it's a causation issue, and she misstated. I don't want the jury thinking they don't have to find the setting of a fire caused the death, and you can still find first-degree murder on all the other stuff she said.
Or you can still find a crime when you have creating the greater likelihood of harm and death through a second-degree murder as well, which they are being instructed on.
Every single
Counsel, I've heard enough from
Thank
both of
you.
you. The jury's here. I'm ready to provide them the final instructions. I'm not going to amend the final instructions. They're going to learn from me what the law is, and they're going to be instructed to follow the law as I give it to them right now.
Thank you, Your Honor.
Thank you. Bring in the jury.
Right. That was the spiciness. I know it probably is not as spicy as we are used to, but with this judge of how permissive and how soft she has been, this is good. That she finally, she does has a spine. It does, doesn't she, Stephanie? She finally. Oh, okay, that's fine. Oh, that's cool. So yes, she does has a spine finally, and as you probably have guessed it, a verdict watch has started. So I am keeping the feed up on my phone if anything happens in terms of question or anything. But we are of course, absolutely, no problem. I know you guys like to see this kind of things. So 1 second. So jury started deliberating. What's the time? At 9:39 a.m. So yay, verdict watch, everybody. So we on verdict watch. I have the counters up on the screen. I've got the feed on my phone. I've got X on a window on my computer. So we've got sources. We are sorted. So now I want to go and watch the James Crumbly hearing. So James Crumbly, for those that don't know who he is, I don't know if there's anyone that doesn't. Um, Countdown starts. Whoop whoop. So I know it does not get better than this. I love a good verdict watch. It is the best time of the trial, but it's also the most nervous time of the trial because you never know what the jury is going to do. I mean, the last two trials, we've been having surprises. So I am not putting my eggs all in one basket. Normally, right? Normally, our friend Denise, she's always right when it comes to the verdict, but she's been wrong for the last two trials as well. So that's how unpredictable the jury has been. That or could be hung jury. But my question then is, coming from that, if it is a hung jury, will the state try to try her again a third time? Because she would have been like the time that it would have taken to go back to court and everything. I don't know if the woman would have either first money to um say my name, say my name. Yes, I did just say your name, Denise, because you're a verdict expert. That was wrong for the twice in a row. Hello, my friend. Good morning. I hope work hasn't buried you in paperwork and stuff that you need to get done, my friend. I'm so sorry. But yeah, so I was just talking about how unpredictable juries can be, and sometimes it's the craziness, and they can just throw a complete curveball. I mean, they can surprise us and coming back in within an hour or 2 hours with a verdict and literally surprises everyone to our core. Or they could literally be, we could be on verdict watch until Tuesday. So it could be absolutely a craziness. We'll never know, and it is a fact of things that we need to just, you know take it as it comes. I guess it's nothing much we can do um about it. The one thing that I can do about it is go take some headache tablets because I have a killer headache right now and I don't know why. um exactly, just prove that experts can be wrong. That is true, and that is very very true. But our expert for this case, aka Stephanie, um she's saying guilty. Our verdict expert is saying not guilty. So two of our experts are not agreeing, which is complicated because normally experts, well, they won't agree with which one. So, oh, case one, I think we need forever to recover from Lori. That was spicy, and I was rewatching, right, because I am a nerd and I have no life. Because I was rewatching Kay Whitcock's testimony, but and the question Laurie was asking all day yesterday, that if she saw her conspiring to unalive her husband Charles Vallow, she said no. Right, Laurie said no, but then she said something else. Right, she said, uh, let's watch it again. I can pull it up and show what she said, because I found that very interesting of what she said. So let me go on the feed of yesterday. This is rather easy to find that what she said. So it was Okay, and it was like already towards the end of the day anyway, so there you go. Oh no, I need the other headphone. Hang on, share this one.
But you knew that there was some kind of contention going on with those two for a while. And you weren't really aware of the events that happened that morning, were you, Lila?
Didn't tell me.
Miss Woodcock, did you see or hear or personally witness me conspire with Alex Cox to kill my husband, Charles Vallow?
No, but I saw a ton of evidence that did.
Thank you. No further questions.
That mic drop. That was what I was saying. No, but I saw tons of evidence with it. That mic drop, right? If this was a seasoned lawyer, he would have said, objection, non-responsive, whatever. But because it's Miss Laurie or Crazy Laurie, she did not know. You know, she was just like, yeah, okay, no, okay, fair enough, I'm gone by. So I was rewatching it, right? Because I have issues. And I found that very interesting. I found that very, very interesting indeed, because it's I know I'm surprised that the judge allowed that too. Probably the judge was already like, oh man, I can't have any more chicken enchiladas anymore, because no, I'm gonna be thinking about this cuckoo head every time that I do. But you know what, case when I had planned for dinner tonight to have chicken enchiladas, I literally went this morning to the shop, which is literally next door, um and I bought the wraps for the chicken enchiladas, and now they are ruined because of Lori. Not the wraps. The wraps are still okay, but the chicken enchiladas. Oh, but anyway, that was Cuckoo Lori. That was just the point that I remembered from court. That was actually rather interesting, and I thought that you guys would, enjoy that fact that I've found interesting. So, now, um, I cannot wait. I really like doing chicken enchiladas. It's just one of my favorite foods ever. Um, Yeah, I think so. I think she was afraid of what she was about to say. Oh, something else that I found about Laurie's Vallows trial, right? So you guys remember that we had 21 witnesses from the state for the Laurie Vallow case. Um um so the trial started Monday, 7th of April, 2025. That's the official day, well, that the trial itself started. After before that was the jury selection, but that wasn't televised. But trial started last Monday, 7th of April. Um, I still have to rewatch. I know I haven't watched it. That is not of course, my friend, anytime, Willow. So what I was gonna say is I did not watch Colby's stream yet. I did not have the time. I know. Not good enough of me. I should have stayed up and watched it. But I yeah, I haven't watched it. I haven't had the chance to watch Colby's stream. I saw the one that he did after he left court, not the one after that. I do need to repent. I do know how to repent, guys. See, I'm not like Laurie. She thinks she doesn't need to repent, but I do. I do need to repent because I did not watch that stream of about the case that we're following. I know it's not good enough, and I will improve. I promise. I will make my effort of improving and making sure that I watch everything. So yeah, I'm just joking, but yeah. Um, Oh yeah, I heard about that. I think I saw a post on the YouTube on his community post that he was saying something about sound. I saw that, but not the stream in itself. So I was saying, I was scrolling through Twitter this morning while I was having breakfast because that's what I do, and unless I am on TikTok. But anyway, and I found one of the many news agencies that are reporting about this case had a witness list for the state on the Lori Vallow case. And I went through the list and I have deleted everyone that we already had on, because on that trial we've already had 12 witnesses on the Lori Vallow case, and I went through it, and at the moment we have 10 to go through. I think 1 2 3 4 5 6 7 7 8 9 10. Yes, we have 10 more witnesses to go through on the state's case on the Lori Vallow case. But I've got some bad news. I do. And I'm sorry about that. I have some bad news that I need to report. Out of the civilian witnesses that the state had on their witnesses, that was Christina, Adam, Nancy Joe, Serena, and Kaywood. We already gone through all the civilian witnesses for Lori Vallow. So that means that Lori confronting anybody else that it's a relative or something that could be even more spicy, like a very spicy thing, it's not gonna happen unless she calls in her case in chief. Because I'm gonna open the document that back of whose story, Lori Vallow or Kay Wood, or who are you? Where are we, Nikki? Um. So hang on. So back. So on the witness list that Lori Vallow has, it has Oh, Lori. Oh, you did not know the story about Lori Vallow? Case one. Have you been living in a rock? No, I'm joking. Sorry, friend. I'm just joking. But so on list, right? That's Lori has all witnesses that she has. None of them are detectives or anything. I don't think they are detectives, because the witness for Lori is Brandon Burdo, Summer Sheezelt, I think that's a sister or something, Janice Cox, Adam Cox, Zachary Cox, Barry Cox, Ashlyn Rint, Joseph Pongratz, Gabriel Bonilla, and Vaisia Itanahu. I don't know how to pronounce that name. So no, just say just no, yes, and the rock. I'm glad you are under the rock and you are here with us, and now you can share in this craziness of Lori Fallow with us, because it wouldn't be the same without you. Absolutely. So all the witnesses that Lori has in her list, it's just interesting that I think she will want to just have spiciness with witnesses and not actually court anything. But we shall see if she even puts yeah put a case after all. No. Oh no, what did I do? Oh, sorry. Me pressing buttons. I shouldn't press buttons. I need to stop it. Right. Okay, without me boring you guys, let's start watching the hearing for James Crumley. Let me put that up. Share on here. Do this. And press play. I can actually skip a little bit forward because.
You did something? That should work. Okay. So,
Just skipping forward until I know same case one that I'm surprised.
All right, court is now in session. The Honorable Shirley Matthews presiding.
Good morning, you may be seated. Sorry to make you wait, we're having technical difficulties.
Your Honor, calling People v. James Crumbly, case number 22-279-9989-FH.
Good morning.
good morning, Mark Keith on behalf of the people.
Good morning, Joseph Shada on behalf of the people.
Good morning, Your Honor. Lorna Sharon on behalf of James Crumbly. Your Honor, can Mr. Keith and I approach very briefly?
Well, the problem with that is I have about 5 microphones here, so anything you say to me will be on channels 2, 4,
That's
and 7.
fine. Mr. Keith and I plan on putting it on the record. I just wanted to inform you of something very quickly.
Okay. Okay.
Can you approach?
You can approach, but I can't.
I understand.
Sure.
I understand.
Oh yeah, would you be able to cut the mics for a minute? Because I can't go on that. Right, today is the date and time set for defendant James Crumley's motion for a judgment of acquittal or in the alternative a new trial. As has been this court's practice in each hearing over the past 3.5 years, the proceeding is being conducted in person. In keeping with that procedure, we alerted all parties that defendant James Crumley would be writted from the Michigan Department of Corrections. Ms. Sharon then indicated to my chambers that the defendant did not wish to be brought here for these proceedings, as is his right. Ms. Sharon also requested that her client be permitted to participate by Zoom. The court indicated that there would be that we would make that request to the Michigan Department of Corrections. We also obviously have more ability to control that at the Oakland County Jail. But we were unsure about whether the Michigan Department of Corrections would accommodate a Zoom hearing with the defendant that can potentially be lengthy. The Michigan Department of Corrections has accommodated that request to the extent that Mr. Crumley will be able to see and hear these proceedings. And Ms. Sharon, I think you've indicated that Mr. Crumley, although he has the right to be present for this hearing in the courtroom, that he's willing to waive that right to be present in court.
Absolutely, Your Honor. As the court has correctly indicated, it was our request that he appear via Zoom, so I would waive his appearance for purposes of this hearing.
All right, thank you. I wanted to indicate before we got started that I'm not in the habit of issuing late opinions. I tend to keep up with my responsibilities, so I wanted to let you know that I thought it would be appropriate to not issue an opinion on the remaining issue in the Jennifer Crumley matter until hearing oral argument in this matter. So I will get back to you as soon as possible with regard to that.
Thank you, Judge.
All right. So I'm going to ask you to all please be mindful that I've read and thoroughly reviewed the motion filed by the defendant, the response filed by the Oakland County prosecutor, and the reply filed by the defendant. In fact, I read the entire guidepost report as well. I think it'd be helpful if we went issue by issue with Ms. Sharon giving her argument, the prosecutor responding, then Ms. Sharon providing any reply. All right, so Ms. Sharon, it's your motion. You can address each issue raised in your motion in any order you see fit. All right.
Your Honor, before I begin, when I typically argue in front of the Court of Appeals, I don't always touch on every issue that I've briefed, and I did not intend to do so today.
I'm so relieved.
I'm glad I could make your day, Your Honor.
Yeah.
So as long as that is acceptable to the court.
Oh yeah, I have read everything more than once and have pulled the cases and read the cases. I think oral argument is important, but I would appreciate hitting the highlights. You did an outstanding job on your brief, and it is very detailed.
Lengthy.
But it is Friday, and I don't want to be here till 10 o'clock at night. So.
I understand, Your Honor. So I will proceed as I had planned.
Okay.
But of course, if the court has questions on any of the other issues, I'm always more than happy to answer those. Again, Alona Sharon on behalf of Mr. Crumbly, Your Honor. Mr. Crumbly is entitled to a new trial for a number of reasons, the least of which is the concealed proffer agreements. And so, Your Honor, I want to start off this morning by talking about the court rule, the discovery rule that's at issue here, which is, of course, MCR 6.201B5. Your Honor, the prosecution would read the court rule so that the phrase, quote, for testimony modifies all terms of that subsection. So it would modify any plea agreement, grant of immunity, or other agreement. But the prosecution's suggested reading of the court rule does not comply with our rules of statutory interpretation, rules of grammar and punctuation, and perhaps most critically, Your Honor, it does not comply with the purpose of the court rule. First, Your Honor, the court rule is not ambiguous. The use of commas in B5 separates each clause such that the rule requires the prosecution to disclose any plea agreement, 1, 2, any grant of immunity, or 3, other agreement for testimony in connection with the case. But if Your Honor does find that the court rule is ambiguous, then it should look to the rule of the last antecedent. And under the rule of the last antecedent, Your Honor, the clause for testimony modifies other agreement and not the first two phrases, plea agreement or grant of immunity. Under the rule of the last antecedent, Your Honor, and just general rules of punctuation, a comma would have to be inserted after or other agreement to reach the prosecution's reading. So essentially what the prosecution is asking Your Honor to do is read a comma into the rule that isn't there. And we're told by our case law that we presume the drafters of these rules are familiar with rules of punctuation and grammar, Your Honor. But the most compelling reason, Your Honor, that the prosecution's reading of the court rule must fail is because it's not supported by the purpose of the rule. MCR 6.201B5 is born out of Brady versus Maryland, Your Honor, 373 U.S. 83. That case requires a prosecutor to, quote, disclose any information that would materially affect the credibility of his witness. In People versus Atkins, 397 Mich. 163, our Supreme Court stressed that the focus of requiring disclosure in such situations is to reveal factors that the jury may consider in weighing a witness's testimony and which may motivate the witness to give certain testimony.
Well, let me ask you this.
Yes.
I don't want to mess with your mojo because you're sort of on a roll.
Don't worry. I've got more mojo than I can handle right now.
So what if I agree that the prosecutor violated the rules with regard to discovery? What if I agree with that?
So where does that take us next?
Yeah. So,
sure.
So you're telling me about a Brady violation, but
no.
What is the remedy? What is the remedy if there's a violation of the rules of discovery? Just plain old 6.201B2.
Sure, Your Honor. And I will answer that question in 10 seconds.
Okay.
I do just want to point out, because I feel like when the other defendant's case was argued, there was this sort of conflating of discovery violation versus Brady violation.
They're separate.
But, okay, and I believe that Your Honor understood that concept. I just didn't feel like it was super clear on the record. So right now, I'm addressing the discovery violation. So as to your question of what is the remedy, right? What is the sanction?
Well, because then you started telling me about Brady, so I agree with you that they're separate.
So, Your Honor, I referenced Brady because 6.201B5 is drafted in the spirit of Brady. It is drafted in the spirit of protecting a defendant's right under Brady, but they are two different claims.
Okay.
As to the sanction or the remedy, Your Honor, so we look to 6201J, right, that talks about violations. And under the court rule, as well as the applicable case law that's cited in the brief, Your Honor has wide discretion to grant an appropriate remedy or sanction. And Your Honor should be guided by a variety of considerations. First, if you just look at the plain language of 6201J, it lists several examples of remedies that Your Honor could use, except none of those would be helpful in this case because the prosecutor didn't disclose until following conviction. So then you keep reading, or enter such other order as it deems just under the circumstances.
And you're saying that would be a whole new trial?
Absolutely, Your Honor, because it is the only way to make Mr. Crumbly whole. It is the only way to correct the violation of the court rule. If someone could suggest to me some other sanction that could remedy this wrong, I'm happy to hear it, but there isn't one, right? And that's why the prosecution has to keep hounding this argument that they didn't have to disclose this immunity proffer agreement, Your Honor. Your Honor, I guess I would ask you, if you are at the point where you feel like this was a violation of the discovery rule.
I likely do.
Okay. I can take the message that Your Honor is telegraphing, Your Honor. I do want to remind the court that back on January 31st, when Jennifer Crumbly's case was being argued, Mark Keast argued to this court that his office did not have authority to grant immunity outside of statutory immunity. That's a direct quote. The only way to grant immunity is to petition the court. It now seems
You're talking about oral argument on Mrs. Crumbly's motion.
Yes, Your Honor.
Okay.
And I do cite to it, I believe in the brief.
Oh, yeah, you're talking about this year, not talking about the trial. Yeah.
Correct,
Okay.
Your Honor.
Right.
So it's remarkable, and it should be remarkable to this court, that it appears at this point in time they've abandoned that argument, Your Honor. It's nowhere in their response brief. I don't know what Mr. Keast will argue today, but they absolutely do have the authority to bestow immunity outside of statutory immunity, and that is what this argument was. So to go back, Your Honor, to the remedy, I do want to talk a little bit more about that. According to our case law, when Your Honor determines the appropriate remedy for a discovery violation, you must consider and balance the interests of the courts, the public, and the parties in light of all the circumstances, including the reasons for noncompliance. Your Honor's paramount interest is that the discovery should facilitate the search for the truth. The public's interest, Your Honor, is that when a trial concludes, it can have faith in the outcome of the trial, and obviously a party's interest is that it be able to properly prepare for trial. And the court should also consider whether the objecting party was surprised. Every single person in this courtroom, with the exception of 4 people, were surprised, Your Honor, by the existence of these proffer agreements. In People v. Taylor, 159 Mishap 468, the court instructed that the first question for Your Honor to answer when fashioning a remedy is whether the party's interest in preparing his own case or his opportunity to test the authenticity of a witness or the authenticity of evidence has been prejudiced, which it has been here, Your Honor.
Can I ask, I want to ask you about Taylor, but
Yeah.
can I ask you what kind of immunity you say that they conferred? Because it's not transactional, right? And with regard to use immunity, doesn't use immunity protect a witness against compelled testimony? There was no testimony compelled by either EJAC or Hopkins. I think your brief says pocket immunity. I don't know. So what flavor are you alleging of immunity?
I don't know, Your Honor, that there has to be a specific title to the type of immunity, but the case law is cited in the brief that references, right, pocket immunity is one of the phrases, informal immunity, but the case law is clear that where a promise is made in exchange, even just for cooperation, that is a form of immunity, Your Honor. And here, obviously, the plain language of the proffer agreement promised Hopkins and EJAC that any evidence or information that was provided to the prosecution during these proffer meetings could not be used against them in the prosecution's case in chief.
Okay.
So that is, I do agree. I guess I respectfully disagree that it's not use immunity, but even if you don't want to give it that proper title, it certainly is a form of pocket or informal immunity, which would still be required to be disclosed under Brady and under the court rule, Your Honor.
Yeah, but I don't know, I think use immunity is when the testimony is compelled. Ejak and Hopkins still don't have to testify, right?
No, they certainly were not required. I mean, they were subpoenaed. Mr. Keese indicated that at the last hearing. So obviously they were required to appear, but I think everyone agrees that they probably could have asserted the Fifth Amendment.
They probably would have.
Correct, Your Honor. The second consideration under Taylor is that what remedy may be appropriate giving due regard to the competing interests of the party, the court, and the public. And Your Honor, I want to take a moment here to address the Dickinson case that's relied on by the prosecution in its response, because the procedural facts of Dickinson are very different here. So in Dickinson, we have admittedly a discovery violation that comes to light during the trial. And instead of asking for a sanction under the court rule, the defense counsel in Dickinson simply moved for a mistrial, which is a different claim. And the review of the Court of Appeals in Dickinson is a review of a trial court's authority to grant a mistrial and whether the granting of a mistrial is appropriate. That is a different set of law. That is a different analysis. So Dickinson is really wholly inapplicable to the case that's before Your Honor today.
Well, you mentioned Taylor, but in Taylor, U.S. Supreme Court case, the Supreme Court affirmed the trial judge's exclusion of a defense witness not included in discovery, and there was some other
I was just going to get to that case.
That happened.
Yes.
Right, but that was kind of the easy button there, right? Because it was that witness was going to commit perjury. There was some underhandedness, and the witness wasn't disclosed at all, right? And the witness was going to perjure himself. In this instance, we don't have a witness that's undisclosed, right?
Correct.
Ejak and Hopkins were on the witness list from the beginning. They testified at the preliminary examination, right? So Taylor's a different scenario, isn't it?
Your Honor, and I don't use Taylor for the purpose of the facts being necessarily on point, but what the case stands for. May I address that?
Sure, go ahead.
Okay. So, and Your Honor has touched on this a little bit, but just to kind of reiterate the basic facts in Taylor, the defendant, defense counsel at the first day of trial moved to amend his witness list to include two witnesses, one of which he said was much more critical than the other, and reason that he didn't provide the name in a timely fashion and pursuant to the discovery order was because he had trouble locating him, so he didn't have an address, and that the witness had seen the entire incident from which the criminal charges stemmed.
And both of those things were lies.
Correct. Mm-hmm. That is correct, Your Honor. So the judge tells the lawyer, bring your witness in tomorrow, I'm going to make inquiry, and I'll make a decision. But what is remarkable in Taylor, Your Honor, is that you have a defendant who has a constitutional right, a due process right to present a defense, a constitutional right under the compulsory process clause to present evidence that is favorable to him. And despite those guarantees under the United States Constitution, the United States Supreme Court affirmed an incredibly severe sanction, Your Honor. Incredibly severe, okay? So what do we take away from Taylor? If the violation is intentional, okay, if there is bad faith behind the violation for the purpose of gaining a tactical advantage, a severe sanction is warranted. That's what we take away from Taylor. And Taylor said that the court can consider whether compliance with the discovery rule is onerous or relatively simple. Your Honor, Mr. Keese provided discovery to defense counsel 34 times. 34 times subsequent to the signing of these proffer agreements. On 34 separate occasions, he consciously decided to continue to conceal these proffer agreements that he was required to disclose under Brady and under the court rule. It was intentional, it was willful, and despite the fact that I frequently forget to attach things to my emails, it was an easy thing to comply with. It would have taken 5 seconds, Your Honor, but he didn't do it. So because the violation is intentional here, and willful, it is deserving of the harshest sanction. But Mr. Crumbly isn't seeking the harshest sanction, Your Honor. He is seeking the one and only sanction that can right the wrong, that can make him whole, and that is a new trial, Your Honor. Anything short of that, and there is no correction to the misconduct, Your Honor. So again, the court is to consider the reason for the failure. So what does the prosecutor's office argue? One, they first argue that it's something that they didn't have to disclose. I really hope by now the court is not taken by that argument. The second reason that they initially argued was that it was never an immunity agreement because they can't bestow immunity, which, Your Honor, the case law cited in my initial brief clearly dispels that argument. The reasons put forth by the prosecutor are incredible, and they should not persuade this court to conclude that the misconduct was unintentional. Your Honor, the prosecution team consists of 83 years of legal experience. Karen McDonald, 26 years, and a former judge. Mark Keast, 19 years. Dave Williams, 29 years. Joseph Shada, just under 10 years. 83 years of legal experience, Your Honor. Your Honor cannot really believe that 83 years of experience and this team did not know that they could bestow immunity on Hopkins and Ejac, that those agreements in fact bestowed immunity, and that they were required to disclose them. Your Honor, I want to turn now to the prejudice issue. So if you look at Davy, which is companion, it's Davy and Obispo. So they have an evidentiary hearing in that case when the, do you have a question?
No, it's incredible to me and Davey that the defense attorneys had to go to the Detroit Police Department to get their discovery.
I don't know that that's so unusual, frankly.
Well, no, but I mean, completely. It seemed dark ages.
Oh. Oh, you mean that they didn't receive it via email?
Or, no, not email, just, I don't know.
Well, Your Honor,
I'm sure you called the Detroit Police Department,
So to turn to the prejudice,
there was no discovery there, though. No, zero. None.
That is correct.
Right.
But if you look at Davy, Your Honor,
it's prejudice, capital P, right?
I don't know what you mean by that.
Well, they weren't given any discovery.
Correct, but the court in Davy, never makes a finding that the failure to produce the discovery was outcome determinative. All it does is the trial court took testimony from trial counsel who testified that their ability to prepare was compromised, and that was enough prejudice. That is the prejudice that is required, Your Honor, under the discovery claim. And so let's talk about the prejudice in this case, Your Honor. James Crumbley was prejudiced because he was unable to effectively cross-examine the witnesses as to their bias and motive. He was unable to fully prepare his case. But perhaps what's most compelling, Your Honor, is that I reference in the reply brief the audio from Mr. Hopkins' initial interview, right?
I listened to it.
The day of the shooting.
Mm-hmm.
When you listen to that audio and compare it to the testimony that he provides at trial, subsequent to the proffer agreements, there are distinct differences, Your Honor. Nothing in his interview to the police expresses frustration with the Crumbleys' unwillingness to take their son home. There is no mention that they refused to take EC home because they needed to return to work. He explicitly says, Your Honor, in that audio, the parents were absolutely on board to get him help within 48 hours. And he also tells the officer, look, these parents, they know that their son has a tremendous amount of anxiety when it comes to missing class. So much so that he tells the officer that James Crumbly told him he wanted to plan a family vacation and EC was going to have to miss class for it, and told his dad, I don't want to go on the vacation. I cannot miss school. I cannot miss class. So you go from these statements that he makes, right, within hours, of the shooting, where he does not express any frustration with the Crumbleys, any concern about James Crumbley that he is disinterested, that this meeting ends abruptly. And when you compare, Your Honor, those statements to the officer shortly after the shooting and his testimony, where he talks about the meeting ending abruptly, the parents not acting appropriately with EC, and I detail it all in the brief. I don't think I need to repeat it. But not disclosing the proffer agreements, Your Honor, it robbed him of the inference that this gentleman's testimony shifted as a result of the proffer agreements, Your Honor.
Okay, well, this meeting was 12 minutes long, right?
I believe it was 20, but 12?
Mm-hmm.
Yes. But the officer asked him repeatedly about the meeting, about the parents. How was the child doing? Were they willing to get treatment for their son? And Mr. Hopkins expressed no concern about the parents, not one shred of concern, not one observation in that interview about their conduct during that meeting, about their attitude during that meeting. Your Honor, we know that without the proffer agreements, Hopkins and EJAC would not have testified. That is a reasonable inference given their lack of cooperation with the Guidepost investigation. They had no interest in transparency, and their interest was self-preservation.
Okay, but the prosecutor would say that everybody's interest is self-preservation, right? So they were incentivized to shine themselves up before the proffer agreement, during the proffer agreement, and after the proffer agreement. No one, everybody, any reasonable person avoids being charged with a crime, right?
100%, but not every person is a witness in a criminal trial. Mm-hmm. That's what matters here,
okay.
Right? What gives them the bias and the motive to have that shift in the way he characterizes his interaction with James's interaction with EC, their willingness to get this child help. Here's the distinction, Your Honor.
He talks about it when he's being interviewed by Joe Bryan at the jail too, right? There's an interview with Joe Bryan at the jail.
Between
Mr. and Mrs.
and the child.
And the two defendants. And a lot of those things are stated there.
Are you talking about the exhibit that's attached?
It's Exhibit 2.
Yes, Your Honor. I reviewed that twice. Okay. There is nowhere in that interview where the Crumbleys indicated that they had to leave to go to work. That is not in there. There is nothing in there.
They do leave to go to work, right?
Your Honor, the point is that the prosecution tries, but the reason that they leave, Your Honor, and they leave EC at school, in that initial interview with Hopkins, he makes clear that those parents wanted EC to stay in school, Your Honor, because they had serious concerns about the amount of anxiety he experienced from missing class. And that's confirmed by Hopkins. He talks about in great detail how much the students have struggled because of COVID, and that EC seemed to struggle a lot from not being in school. His grades had declined a bit from that, and his parents confirmed that not being in class was incredibly anxiety-inducing for him.
Wasn't he sleeping in class at some point?
I believe that is a statement that he might have made to the CFP, and a teacher might have reported it.
It's fine.
But regardless of that, I don't think it's disputed that EC reported and his parents acknowledged that not being in school was incredibly difficult for him, and that he wanted to stay in class. So you go from Mr. Hopkins telling the officer these parents were on board, they wanted to keep him in school because they knew he would be upset if they took him out of school, to this shifting narrative at trial that no, they didn't want to take him because they didn't want to be bothered and they didn't really think he needed help, and so on and so forth. That is a remarkable shift in the characterization and the narrative of the Crumbleys, specifically James Crumbley and his conduct in that meeting, Your Honor.
Okay, but regardless, that doesn't change. Whatever EJAC and Hopkins say doesn't change the facts. It doesn't change what happened. The parents came there. There's texts, there's videos, there's all kinds of things that happened before and after.
Your Honor, I don't dispute for one moment. They came
She
there.
didn't want to come at first, Mrs., right? And said she couldn't miss work, and then she comes, then they're there 12 minutes, they leave without him. Like, nothing Ejack and Hopkins say changes that.
Your Honor, the facts might not change, but the way that they're characterized and the narrative that's given around the facts, right? That's what's important, and that's what the prosecution used Hopkins for, in part, was to give testimony about how they conducted themselves in that meeting. The fact that they seemed almost irritated about having to be there. The fact that the meeting, quote, ended abruptly. And then this assertion that they really didn't seem to think getting help for him was important, which is the total opposite of what he says in that meeting immediately after the shooting. His exact phrase was, they were on board. That's it. So how do we go from there to portraying these parents as not caring, not knowing their son? It's just, they don't coincide, Your Honor. They are distinctly different.
Well, she wasn't going to come at first, right? She said call the dad.
Your Honor, she's not my client.
Oh, I know she's not your client.
Mr. Crumbly
But you
is.
said the parents, so... You know.
I apologize.
Yeah.
But when you look at globally his statements, to be fair, I mean, he talks mostly generally, right, about mom and dad. You know, he tells him, no, they came to the school, we had this meeting. He even talks about them telling him about the grandmother passing away, about the loss of the dog, about the friend moving away, so on and so forth. So there is this exchange of information, and there's never a characterization at that time that they're somehow inappropriate.
Well, they're going to say there wasn't an exchange of information.
Well, I understand that that's what they say, except that Mr. Hopkins' interview says otherwise.
No, the prosecution's going to say there wasn't an exchange of information. If there was an exchange of information, the prosecution's going to say this wouldn't have happened if there was an exchange of information.
Your Honor, at that moment in time, Ejack, Hopkins, James Crumbly had no reason to believe, and this kind of dovetails into the legal duty argument, that EC was had a propensity for violent acts. Okay, under the law, and I yes.
What about that picture?
Yeah.
They had the picture before they came to the meeting, right?
100%, Your Honor.
Yeah.
Your Honor, children draw pictures of things. It doesn't mean, if every person who drew a picture meant that that was their intention going forward. I mean, people, I don't want to call it a doodle because I don't want to undermine the significance of it. But to suggest that because he drew a picture and has never had a history of violence that his parents knew of, specifically his father, it wasn't foreseeable. It simply wasn't. I mean, when you look at Hopkins, he saw the same picture. But what did he say? What did he tell the officer? This kid's never been in trouble. I barely know him because he's never been in trouble. He comes to school, his attendance is solid, he's never got into fights, he's never been suspended. Why is that? Because he's never doing anything wrong. You're taking a kid who has no history of behavioral problems, of misconduct in school, and...
Well, there was a phone call the day before about... There was a phone call... They both were aware of the phone call the day before.
I don't know that
about
there's...
researching bullets.
Right. And, Your Honor, I don't dispute that that happened, but the fact that someone researches bullets, no one disputes that this was a hobby of his. It was a hobby that he enjoyed and that he did with his parents. And in some communities, that's a totally normal hobby for a 15-year-old child to have with his parents. And I think the testimony at trial very much confirms that in this community, that is nothing unusual, Your Honor. But when you look at the narrative that's put forth and how it shifts, James Crumbly did not have the ability to cross-examine these witnesses about why their testimony shifted, why the information that they gave shifted. And it would have been a reasonable argument and a reasonable attack on their credibility, Your Honor, to point to the proffer agreements for the reason in that shift. But again, Your Honor, even under Davey, the prejudice prong is whether or not the defendant's ability to prepare the case has been hampered right? And that's exactly what you have here. That meeting and their alleged conduct and disinterest in that meeting was a huge part of the prosecution's case.
Okay, so you're talking about materiality. Do you want me to let the prosecution respond, or?
It's your courtroom, Your Honor. Whatever's easiest for Your Honor.
Well, I think it'd be best to issue up by issue. I guess I shouldn't presume that you're done talking about this part.
About the proffer?
Yeah, I
am.
Okay, well, I'm going to let them respond,
100%.
and then I'll let you reply.
Thank you.
Okay?
Thank you, Judge. I think the court, some of the court's questions, I think, correctly exemplified part of our argument, and that is the amount of evidence that was presented to the jury that is both uncontested and proved at trial that showed, irrespective of these witnesses, the guilt of the Crumbleys.
Okay, but you're jumping to the end. Mr. Keese, you agree that a prosecutor is under a duty to disclose any information that would materially affect the credibility of a witness?
Yes, Judge, the Brady obligation,
If I had
of course.
$1 for every time I said credibility is always at issue, I could retire right now,
Yes.
right? Credibility is always at issue, right? And so wasn't the defense deprived of a robust cross-examination?
No, Judge, and I do want to point out that the interview that counsel is referring to, that was turned over to defense. Defense counsel had that
Are you
first.
Are you talking about the audio tape she sent me, or Exhibit 2 to your brief?
The interview of Mr. Hopkins from November the 30th of 2021, along with the narrative statement summarizing that.
Sure.
So counsel had opportunities, if counsel saw it at trial, to try to cross-examine on any inconsistencies. I don't believe there to be any material inconsistencies, and I'll get to that, Judge.
Okay.
I do want to highlight just a few things. I want the court to recall that the evidence showed that it was approximately 1:10 p.m. on the afternoon of November the 30th, 2021, when the active shooter alert went out to parents of Oxford High School students. Those parents raced to the high school in hopes that their children were unharmed and alive. But James Crumbley didn't. He went home. He went home to look for the gun that he bought his son just 4 days before. He went home because he knew his son was the shooter. James Crumbley is the person who bought the murder weapon. He's the person who didn't lock it up, even though he was given the cable lock and an easy way to do so. James Crumbley knew his son had lost his only friend just the month prior. James Crumbley knew that his son's only hobby at this point was going to the gun range, and that his son had voiced signs of mental distress months prior. It was James Crumbley who wrote to his wife, "My God, WTF," when he was shown that math worksheet. This series of choices that I've just outlined led directly to the deaths of Hannah St. Juliana, Madison Baldwin, Tate Muir, and Justin Schilling. And those series of choices had absolutely nothing to do with Ejac or Hopkins. But not only that, I dispute that the crux of the testimony of Hopkins and Ejac was not uncontested, because it was uncontested. No dispute that Hopkins called the parents to the school. No dispute that math worksheet was sent to both of them. He provided a list of mental health resources to the defendants at that meeting. We know that because that's on video. He said he wanted them to get their son help that day if possible. He never testified, and he never told anybody that he had threatened to call the school resource officer or the police. It's uncontested the length of the meeting. We know that because it's on video. We know the shooter went back to class. We know that no discipline was handed out. We also know that neither Hopkins nor Ejac voiced that they thought at that time that the shooter was a threat to anyone else but himself. That uncontested evidence was used in part by the defendant to try to cross-examine those witnesses. This isn't testimony used to stretch or to impress the prosecution. That was just what happened. This is not evidence of somebody who is trying to curry favor with the prosecution judge. And that's important because ultimately, if the court has already made this decision on discovery violation, ultimately the decision is remedy. I don't think you should, and I would like to go through that discovery violation briefly, if I may. Okay. As much as I believe that our position is correct and the law is clear, I don't want to leave the court with the impression that there was an effort to hide evidence or gain an unfair advantage. I understand and appreciate the knee-jerk reaction that occurs when it's learned that a proffer agreement wasn't disclosed in discovery. I've done dozens of them. I've petitioned the court for immunity dozens of times. So I understand that knee-jerk reaction. When a co-defendant flips, they proffer, they're given a plea agreement, and they provide testimony. That always goes to the co-defendant, always. The same as someone is given immunity to testify, and the court correctly identified this. We petitioned the court for immunity to compel testimony. That's what use immunity is, Judge. And whether or not there is some sort of other name for immunity out there, that is not what was included in the proffer agreements.
Well, I think what Ms. Sharon said is they got something.
They got the opportunity to tell us what happened in the first meeting and first meeting only, with a promise that we wouldn't use what they would say to us should they be charged later on.
Well, there's an incentive there, right?
Judge, to the extent that they had any incentive to tell us what they wanted to or tell the police, that would have existed irrespective of the proffer agreement or not. They were sued in, I think, 1 week after the shooting. Multiple lawsuits, they're sued personally. That was not a secret. The civil depositions occurred post-exam, pre-trial. Trial counsel had copies of their depositions. Sean Hopkins testified 4 times. Nick Ejak testified 3 times, each without protection.
They testified before the proffer in the civil case?
No, civil case was post-preliminary examination, pre-jury trial.
Where were the depositions in the civil case in relation to the proffer?
Post-proffer.
Post-proffer.
Yes, proffer is 2021.
Okay.
I don't know the date offhand of the civil depositions.
Okay.
I do know that it occurred because we obtained the transcript, as did trial counsel. The prosecution was not a party to that. Now, I say all of this because I appreciate the advocacy for a defendant as well as that knee-jerk reaction. But it is one thing during the appellate process to argue the interpretation of a court rule and quite another to assign ill intent. And I think that's important for the court to know when reviewing remedy.
Okay, but you're not telling me that it was a boo-boo, right? It was intentional. That it was. There was a willful non-disclosure.
No, Judge.
You guys decided you didn't think you had to turn it over, right?
Thank you for bringing that question up, Judge. And I want to go back to the Nick Ejak statement because I think this is a perfect example of this. At the last hearing, the co-defendant's hearing, we talked about the recorded statement of Nick Ejak. That occurred in 2021, and when it was decided to have him testify for the prosecution in 2024, we should have gone back through and identified that as a statement under the court rule. That was a mistake and was made without malice. It's not being argued here today because there's nothing exculpatory about it.
Well, I did think it was interesting that I wasn't provided with it. That means no one really cares about it, right?
Correct, because there's nothing exculpatory about it.
Oh.
Now, in the same vein, the proffer letters in 2021 were put in the work category box. They were not revisited in 2024. The law supports, as much as I firmly believe, and that's why we briefed this, and this is why I'm arguing this to the court, that the law supports my position that the reading of the court rule does not require that. It does not mean that these proffer agreements were shoved in the back corner of an office and decided to conceal evidence from the defendants. It wasn't turned over, Judge. That's a fact. But it would be an error to ascribe ill intent to that.
Well, it was intentional that they weren't provided. I mean, it was.
Right, but I don't want to.
You guys didn't forget they existed, for sure.
I don't want to paint the picture, Judge, that we had a roundtable discussion about this to talk about whether or not to disclose the proffer agreements or not, because they were very quickly identified not to be discoverable, Judge. Okay. We went through items, we went through statements of witnesses. Do we need to redact this? We went through body-worn camera. What portions do we redact? What portions are relative to the case and fit the court rule? That sort of analysis didn't occur with this evidence, Judge. And I don't want my advocacy here regarding the court rule and the interpretation of the court rule to be mistaken for an admission that we tried to hide anything from the defense. So that's the point I make, because that's very different. That's an important distinction, Judge. I want the court to know that from the prosecutor's intentions throughout this case, from deciding whom to charge with what crimes, discovery process, trial preparation, and trial itself, were just. And I want to highlight something that is, I believe, the perfect example. This court recalls how we came to have separate trials to begin with. Trying this case twice was a logistical nightmare for a number of reasons, Judge, as this court knows. Our witnesses had to testify twice on international TV. Most importantly, we had to put our victims through this twice, and they had already endured 2 long years of seemingly endless litigation at that point. But it happened because...
torture for everyone.
It was, Judge. Mm-hmm. And the reason it occurred is because we listened to jail calls We interviewed witnesses on Jennifer Crumbly's witness list, and we learned of Jennifer Crumbly's desire to present antagonistic defense. We reported that to counsel as well as Your Honor at a status conference, as I'm sure you recall. We did that to ensure the integrity of the proceedings as well as protect the rights of the defendant.
I think that was inevitable anyway.
Either way, Judge, we didn't have to. We learned of it on our own, Judge. Trial counsel did not ask for that. Whether or not the court was going to grant it or not, I can't say. I can just relay to the court what happened to make sure the record is clear. In addition, we created waivers to make sure the defendants knew the dangers of joint representation. We created waivers when the trial counsel split to make sure they knew about how to protect prior client safeguards. We made sure and we requested that independent counsels were appointed to interview these witnesses in the jail, these defendants in the jail, so they understood the dangers of proceeding. Every time a question was asked of the co-defendant during the trial that might elicit prejudicial information, we asked the jury to be removed from the courtroom, and the defendant herself was voir dire to understand that was knowingly happening. Way back in the preliminary examination, when trial counsel was in danger of conflating the evidence as to each defendant, it was the prosecution who stood up and made a point to notify the judge and trial counsel we have separate defendants, separate pieces of evidence. Judge, again, we do this to protect the rights of the accused, and it would be wrong to ascribe ill intent to any real or perceived discovery violation. But let me talk about the court rule. So 6.201B5 says, upon request, the prosecution must provide each defendant with any plea agreement, grant of immunity, or other agreement for testimony in connection with the case. I do not agree with counsel's interpretation of the rule that for testimony does not apply through all three phases here, and I certainly do not agree with counsel that these proffer agreements were immunity agreements. I talked about this the last hearing, Judge. If the court has questions regarding that, I can certainly go through it again, but I'm sure the court recalls. I adopt those arguments here today. As much as counsel or the court cannot inject a word or phrase into a court rule, at the same time, we can't make an agreement something that it's not. We met with these witnesses to prepare them for trial multiple times. The proffer agreements never came up again. Their attorneys didn't even show up for those prep meetings most of the time. That is not a situation that we commonly think of as a proffer agreement that must be turned over. So that is an important distinction, Judge. Let's talk about prejudice now. We briefed that extensively. Judge, we also briefed extensively the whole last antecedent series modifier rule. If the court has additional questions on that, I'm happy to answer, but I think counsel, as well as the prosecution, briefed that extensively. Judge, even assuming that these proffer agreements would fall under the court rule, the defendant must show actual prejudice. And that's where we look at the same standard as Brady materiality. And that is why I started off with all of these series of choices that James Crumbly made, irrespective of those two witnesses. Evidence is material.
This is Chanel 495,
yes, Judge.
142, 2014, Michigan Supreme Court case.
Yes. And Judge, going back to, I described what happened with the proffer agreements and their non-disclosure. Counsel did make a point to say that I disclosed discovery 34 times and each time chose not to turn that over. That's not true. It was the first time, and it wasn't revisited. That's an important distinction. It's not splitting hairs, and again, it's something for this court to keep in mind when determining remedy. I'm sorry, I interrupted you regarding Chanel.
No, I just wanted to.
Right. I think that's a that's a great case to review because of what happened in that case compared to what happened here, Judge. Sean Hopkins and Nick Ejak were not needed to identify the defendants. They weren't needed to, didn't have motive to put a case on somebody else. The evidence that convicted James Crumbly occurred wholly distinct from anything that Sean Hopkins or Nick Ejak were involved in.
Well, the prosecution certainly wanted them here, right? Even though it was only a 12-minute meeting, there'd be a small hole in the trial, right? If they weren't here.
Well, Judge, as a matter of trial strategy, we try to give the jury as much context as we can. It does not mean all of the 20 witnesses were essential to the case. Honestly, we could have convicted the defendant with just Detective Rogowski and Lieutenant or Under Sheriff Willis's testimony, Judge, because the bulk of this evidence came through Facebook accounts, text messages, video, as well as the evidence that was sent to James and Jennifer Crumbly. We didn't even need these witnesses for a foundation for that math worksheet. The fact of the matter is, and we made a...
I agree with that.
thank you, Judge. We made a point about talking about this in the opening, throughout the trial, and closing. Hopkins and Ejack knew this much about the shooter and about the Crumbly household. That's nothing we ran from. The counsel just argued in support of her position that he didn't know about the shooter because he wasn't in trouble. That's true, and we never tried to argue anything to the contrary. He knew this much. James Crumbly knew this, and that's the point. That's the point. It takes a rare set of circumstances to convict a parent of involuntary manslaughter for the intentional acts of their son. That's why it doesn't happen very often. It takes causation, it takes gross negligence, and it takes foreseeability, Judge. And everything else that James Crumbly knew, that's what convicted him. There just weren't very many factual disputes in the trial. That's the crux of prejudice and materiality. I'm with the court.
What do you think about Taylor and Davey, though?
Davey is cited by Dickinson, Judge, in support. It's cited by Dickinson. And the crux of Taylor is that the objecting party should not be put in a better position. This would put James Crumbly in a better position. Dickinson's test of outcome determinative prejudice is the guide for this court. And that is why it is the same test for materiality, Judge. Evidence is material if it creates a reasonable probability of a different outcome. That's the standard. What is material is all of the evidence uncontested that James Crumbly knew about his son, all the evidence that was proved by a number of different witnesses, not named Hopkins and Ejack, proved by forensic downloads and cell phone, towers, GPS data, that proved that James Crumbly was grossly negligent, that proved that he was both the proximate and factual cause of death, and that this was foreseeable to him. We did sort of get into the argument on the Fifth Amendment aspect of it, not Fifth Amendment, regarding the duty. Thank you. If the court would like me to.
Do you want me to let her respond to you, and then we'll talk about duty? I issued a ruling already on inconsistent theories and duty and unanimity, right? So.
Not in this case, Your Honor.
Wait, not with regard to this case, but there's plenty of overlap. So I know I'm just stressing that so that you hit the highlights, and I know there's some things in your brief that were not in the brief presented on behalf of Mrs. Crumbly, but yeah. So can she reply to you? Or?
It's whatever the court would like, Judge. And there's just one other thing that the counsel mentioned that I neglected to bring up earlier. Only four people in the world knew about these proffers. That's not true. I mean, Hopkins and Ejack both had their attorneys. We never asked for an NDA. We never told anybody to keep it quiet. I have interviewed gang member witnesses before where their safety would be in danger if things got out, if they didn't testify. That's not the case here, Judge. And I keep bringing this up, the difference of what we commonly refer to as proffer, just because I want the court to contextualize what actually happened. I just want the court to be aware of that. And the only aspect on duty I want to bring up is that essential part of duty is foreseeability, which was instructed to the jury. That was part of the jury instruction, so that's all on that part, Judge. Thank you.
Thank you, Your Honor. A couple things. It's always difficult because I can never read my own handwriting. But when Mr. Key stands before Your Honor and says that these proffer agreements were identified as not discoverable, frankly, Your Honor, that's terrifying. It's terrifying to think about potentially how many other cases they haven't disclosed similar agreements. It's terrifying that a prosecution team with 83 years of experience doesn't know that they have to disclose this under Brady. My reaction is not a knee-jerk reaction. It's a reaction that is born out of the Constitution, out of defendant's right to due process and to present a defense and to cross-examine the witnesses against him. So if our Constitution wants to be called a knee-jerk reaction, then that's fine. But my reaction, and I think the reaction of a lot of people, Your Honor, stems from constitutional guarantees that a criminal defendant has. And I'll knee-jerk react to that all day, Your Honor. Your Honor, he made a comment and sort of went through this litany of events that speak to the virtue of the prosecutor's office. That because they did the right thing in one instance, it means that there was no bad intent here. Your Honor, I'll tell you what the difference is. The difference is those instances that Mark Keese talked about were instances that were on the record in open court, not in a closed room at the prosecutor's office where they could shove a proffer agreement into a drawer and not revisit it for 2 years before this case moves to trial.
No, I don't think he's talking about instances that were on the record. We had a combined pretrial conference in the jury room, and that's when the prosecutor raised that there were jail calls from Mrs. Crumley, basically indicating she was going to flip on her husband. So,
right, but that's known to the defendant. It is known to a defendant. Jennifer Crumley knows that she's planning on flipping.
Yeah, Mr. Crumley didn't know that.
I understand that, but she knows, her attorney knows, it's not something that's clandestine. It's not something that the parties aren't aware of.
Mr. Crumley and his attorney didn't know.
I understand that, but Your Honor, if one defendant knows about it and that defense counsel knows about it, quite frankly, I'm not sure why the prosecutor's patting itself on the back, because defense counsel would have had an obligation to disclose it anyway. So it's not as if they were, well, I'll just leave it at that, Your Honor. Again, I want to stress the distinction between discovery violation and Brady violation. The tests are different. The tests for materiality are different. The discovery violation, Your Honor, is the stronger argument for Mr. Crumley. I believe he wins under both, but with the discovery violation, that outcome determinative language is not required to impose the sanction. And I 100% agree with Mr. Keese that the case law says, right, that the sanction or the remedy should not be a windfall to the defendant. 100%. The defendant should not be in a better position after the remedy. But to argue that Mr. Crumley would be in a better position, I mean, that's illogical. That's illogical. If you grant a new trial, you are putting him in the position that he should have been in when his trial started. He should have known about the proffer agreements. His attorney should have been able to cross-examine Hopkins and EJAC about their bias and motive stemming from the proffer agreements. So I really struggle to understand how he would be in a better position. He would have his day in court that he should have had when he first went to trial.
I don't know. I guess one of the problems with that in Mr. Crumley's case is, regardless of whether Mr. EJAC or Mr. Hopkins testified or not, I mean, Mr. Hopkins wasn't going to say, it was me, I was the straw man who purchased that gun and gave it to the shooter.
Sure.
I mean, you can't, right?
And I was just going to reply to that, Your Honor. So the prosecution keeps saying that there's this tremendous amount of evidence that's uncontested and uncontradicted. And I really think there has to be a qualified statement to that and context to that statement, because it was uncontested because EC didn't testify. It was uncontested because his medical records couldn't come in at trial. Because if there's one thing my brief makes clear with citations to the CFP report, is that this child told the Center for Forensic Psychiatry that he never told his parents he needed help, specifically his father. That when he was feeling suicidal, he did not tell his parents. He put on a happy mask, a happy face. So when you look to the CFP, there is plenty to contradict the prosecution's theory. It just wasn't allowed in at James's trial.
Okay, well, there's good reason for that, right? It's hard.
I would respectfully disagree.
Well, I guess that would be for the Court of Appeals of the Supreme Court.
Agreed.
I guess I would say to you that we thought long and hard, researched. Everybody involved in the trial spent a lot of time. And there is no allowance at all for those records not to be privileged. Those records are privileged. I don't know what to say. Can I say that some of it is unfair? Maybe. But I think you're supposed to get a tape next week of the hearing we had under seal. But to be honest with you, I think you're going to figure out that when you get that sealed record, it's anticlimactic.
Your Honor, so the sealed record, of course, is from Jennifer's trial, not
right.
There was no separate
right,
sealed
but
record.
It's a reference. It talks about references to mental crisis by the shooter.
Your Honor,
we're getting in the weeds, right?
Yes, Your Honor.
I guess I understand your concern about not having the records from the Center for Forensic Psychiatry, but both sides, all three sides in this matter, researched, looked at the law. So did I for many, many hours and many evenings and many times when I should have been sleeping. And there is a feeling of unfairness potentially about that, but there's no question in my mind that those records are privileged, and the privilege is held only by the shooter. So I don't know that there's a way around that.
And I know that this isn't an issue before the court, but certainly there is authority that privileges must bend to a defendant's right to present a defense, his constitutional right to present a defense.
I've seen those cases, yeah.
And because those records didn't come in, Your Honor, the jury is presented with text messages, right? Not even direct testimony from EC that he allegedly told his parents that he was suffering mentally, and you have a complete 180 when he's interviewed at the CFP. A complete 180.
I'm not positive that the prosecutor wouldn't also like those records to come in.
That's right.
Oh, Your Honor, the records are relevant. First of all, the records in their entirety are not relevant, right? Because there's a lot in that report that deals with information that James Crumbley knew nothing about. And that's never been contested, right? Certain disturbing actions by EC, right? There's no evidence that James Crumbley ever knew about those activities. So that would be completely irrelevant in a trial against him, and it would be highly prejudicial. But what is incredibly relevant, okay, and what prejudiced his defense was that the jurors were never told that EC repeatedly told the CFP that he did not tell his parents he was struggling. He did not tell them he was suicidal. And he specifically explained that he didn't do it because he didn't want his parents to think he was not normal, or he didn't want to make them worry. So, Your Honor, that is incredibly exculpatory for Mr. Crumbley. So what I don't like is this suggestion that there is uncontested evidence. It's uncontested because the evidence wasn't allowed in, not because it doesn't exist, Your Honor.
We're talking about the fact that he bought his 15-year-old son a gun, left it laying around unsecured, and was presented with that picture in advance of coming to the school.
So, Your Honor, and now we're kind of getting into the duty, so can I kind of transition?
Sure. Well, I know you responded to Mr. Keese, but yeah, so you want to talk, I'm going to let you make a record about duty, for sure.
Okay.
Okay.
Your Honor, so first of all, I would say that additionally, EC, reported that the gun was hidden from him. He went into his parents' room knowing that they were sleeping and removed that gun at a time when he knew that they would be sleeping and that they had hidden it from him.
They did a bad job.
Not all parenting is perfect, Your Honor. They kept it from him, and they were not legally obligated to lock it at that time. Your Honor, as it relates to the duty issue, so it's undisputed, I don't think the prosecution contests this, that there was no evidence at trial that James Crumbley knew of any prior intentional tortious acts by EC. There is no evidence of that. Without this knowledge, Your Honor, he cannot have a duty. There is no legal duty, and there is no ambiguity in the case law. In its brief, the prosecution cites from the Muma case, which is a case that I cite, and they cite the following language. Since the law, as stated above, stresses foreseeability as a prerequisite to a finding of actionable negligence in cases of lack of parental supervision, and we find no such foreseeability here, we hereby affirm the lower court's judgment. That's the quote in the prosecution's brief. But if the court looks to just the preceding paragraph, right, you would see that also in the Muma court, it talks about the child in the Muma case, right? He takes his parents' car and he gets into an accident and inflicts injuries. And the court says that the child did drive the car the day before the accident, but this was after his parents had left for the weekend. Therefore, the defendant parents could not have anticipated or foreseen that their son would take the car while they were away, since he had never done so before. Mm-hmm. Foreseeability, Your Honor, is born out of a parent's prior knowledge of prior tortious intentional acts. That is what makes that child's acts foreseeable and what gives rise to the legal duty. There is no evidence of that in this case. What also strikes me, Your Honor, is that the prosecution asserts in its brief that the cases on which I rely do not include this requirement. And frankly, it's as if they didn't read any of the cases cited in the brief. Your Honor mentioned well, I took it as a comment on the length of the brief, which is fine. I mean, it was long. But it's long because 51, that's even longer than the Court of Appeals accepts at this point. But the cases, Your Honor, that are cited, I don't just give the court the name of a case. I explain the facts, the holding, why it applies. And what's amazing is that they make a blanket assertion that none of those cases stand for the proposition that I use them for, and give you no analysis of how those cases are wrong or how they don't say what I say they say by way of copious direct quotes from the case. So if you remember, they criticized defense counsel in their brief, not me, trial counsel, about abandoning an issue, right? Because you can't just make a claim and then completely fail to develop it. That's exactly what they do when it comes to this duty argument, Your Honor. They just want to say to Your Honor, hey, Judge Matthews, what she says the cases say, they don't really say that. Okay, now let's move on. Let's not engage in any meaningful analysis to persuade Your Honor of that point. The case law is the case law. Prior knowledge by a parent is what gives rise to the legal duty. There is no evidence of that here.
Don't you think that the Court of Appeals sort of touched on this?
Yeah, I do think that they did. And frankly, I don't.
They talk about
I'm
this
trying
being
to
an
be
extremely unique set of circumstances.
Your Honor, different.
You don't want to call out the Court of Appeals on the record?
Oh, no, that's fine. I think my reputation there is good enough. But different lawyers will raise issues in different ways. Sometimes lawyering from one lawyer may be more persuasive than the next. I wasn't there. I didn't read the briefs. You know, that's not really necessary for my representation here. But what I can say is, where there is no prior knowledge, there cannot be a duty. And if you look, a case that came out after Crumbly, it's People versus Aish, it's AIYASH, it came out maybe within the last 8 to 12 months. It's that horrible case in Detroit where the clerk locked the people in the store and they got into a fight, and then one guy who's locked in there shoots and injures and I think kills one of the other people in the store. Your Honor, you know, one of the reasons why the clerk there wasn't held responsible was because he didn't know this person. He didn't know any prior instances of violence. And that is the same here. That is absolutely the same here. The prosecution has never argued that James knew EC was violent, that EC was ever violent before. And we know from Hopkins, he was not a kid that got into trouble. He didn't get into fights at school. He didn't get into fights in the neighborhood. Nothing. There is no evidence.
Why did he have to know that there was some prior instances of violence?
Because that's what the case law requires.
Didn't he just have to know things about him, like all the things that were happening in his life, including the friend, the fact that there was an unsecured gun at his house. He had access to his Instagram. Okay.
Your Honor, just first of all, just because someone has access to Instagram doesn't mean they're constantly trolling it. But to answer your question, Your Honor, if you followed Your Honor's...
This kid had silhouettes all over his room, right?
It was a hobby that he did with his mother. That's not... Okay, shooting a gun is not in itself violent. If you're going to the range, I mean, that's essentially saying that anyone who goes to a gun range as a hobby or to practice is violent.
No, of course not. But he knew that his son was... And then there was the phone call the day before about him looking up... He was so upset. He had to be at school while he was at school looking at bullets and things like that. Like it's not just one thing.
But the law requires, and I'm sorry, I didn't mean to interrupt.
Go ahead.
But the law requires knowledge of prior intentional tortious acts. Otherwise, there cannot be foreseeability. That's what the case law. I mean, Your Honor, you have cases that I cited where the parents had some knowledge that the children were engaging in sort of somewhat nefarious conduct, but because there hadn't been explicit acts of violence, then the parents don't know about the propensity of that child. You have a child here who engages in a hobby with his parents as a way of spending time together. That is not an act of violence, okay? And to suggest that just because he may have been struggling and feeling sad, which is what Hopkins described him as, right? He just seemed sad. To suggest that that somehow gives foreseeability of someone committing a mass shooting, okay? In today's climate, 80% of us are probably sad the majority of the time. That doesn't mean we're gonna go commit a mass shooting, and it certainly doesn't make it foreseeable. The standard is prior knowledge of prior intentional tortious acts. Without that, Your Honor, there is no legal duty for the parent to act. Your Honor, that is my argument as to the duty part. Okay. That concludes the duty portion of the program. Does Your Honor want to give Mr. Keys an opportunity? I don't know.
Would you like to respond to the argument?
Sure. Just briefly. Okay. This has been before this court before, so I'm not going to belabor the point. I believe the court is correct. The Court of Appeals did touch upon this as well as the court.
I should say that I'm definitely interested in and required to consider each defendant individually.
Of course. Thank you for making that record, Judge, and that's absolutely true. I bring that up only because the issues are so similar, and I believe the court can draw from that. It is, again, a unique set of circumstances, and the Court of Appeals made this point, as did we in the Court of Appeals, and to the jury. A unique set of circumstances where a parent could be held responsible for the acts of a teenage son. Foreseeability is key. I agree. Foreseeability is an essential part of this, Judge, and that was argued to the jury. That's a jury question. Those are the aspects that were put forth to the jury, and the jury made that determination. There are multiple ways. So Alvin states clearly that the law in Michigan is that a parent is under a duty to exercise reasonable care so as to control his minor children as to prevent them from intentionally harming others or from so conducting themselves to create an unreasonable risk of bodily harm if that parent knows that he or she has the ability to control his children, and two, knows of the necessity and opportunity for exercising such control. Of course, should James Crumbley have been made aware that his son was shooting at people in the past or engaging in some other sort of violent, tortious acts, that would be evidence of foreseeability, but it's not required. It's just simply not required. So regarding the duty aspect of counsel's argument, I'm asking the court just to refer back to the first motion to quash that we had. That was what was appealed to the Court of Appeals. In the Court of Appeals opinion, I believe it's clear in that aspect. I do want to go back and make one quick point. When counsel talked about the forensic report, as this court sort of alluded to, and counsel's a bit of a disadvantage because she wasn't here for that argument and it's still sealed, but the court did find...
I think you're going to get it this week.
That's fine, Judge. Yeah. And the point I wanted to make is just so the record is clear that the court did find that there was nothing exculpatory in that. In the court,
was one section, though. I should point out that was one portion of the Forensic Center report that was specifically requested, and we had the closed hearing.
That's correct, Judge. That's correct. And also, Judge, there's no criticism of trial counsel in not pursuing this issue. She removed the shooter from her witness list, probably for a good reason, because it doesn't stop with just questions defense counsel asks. We have a whole lot of questions they ask too, and there are a lot of information.
Are we going somewhere else now?
No, I was just responding to counsel's argument regarding the forensic report.
Yeah. Yes. Okay. Yeah.
Thank you, Judge.
All right.
Your Honor, I'm not going to address the duty issue anymore. I think it's been well covered. The last issue I intended to address was the Fifth Amendment issue. I do just want to just briefly say a little bit ago, Your Honor mentioned that you had already previously ruled in Jennifer Crumbley's case on some of the legal claims that I think on their face or on the surface kind of overlap, but I do just want to stress to the court that as it relates to the inconsistent theories, there is no overlap between Mr. and Mrs. Crumbley's arguments. They are extremely distinct. They rely on different law Well, the law is similar,
Well, you know,
but
you told me this in a pretrial, and that is specifically why I did not rule on everything with regard to Mrs. Crumley, because you did persuade me that it wouldn't be fair to not read your brief and listen to your argument. So.
Thank you, Your Honor. So I just wanted to point out, especially when it comes to that issue, the arguments are very much distinct. Your Honor, as it relates to the Fifth Amendment, I don't have a ton to say here. I do just want to point out that the prosecution's argument in its brief really doesn't make sense from a chronological standpoint, because they criticize trial counsel for not filing a motion back in 21 or 22 about EC testifying.
No, I think what happened is that we were all here, and Miss Smith said, in Mrs. Crumley's case, this is when they were together, Mr. and Mrs.
Yes, Your Honor.
So she said something to the effect of, "I'm going to need the shooter as a witness," and knee jerk, I said, you can't take the Fifth in front of the jury, so
of course,
you got to send up a flare if you think that's going to happen, because he can't take the Fifth in front of the jury. So I pointed that out, and I encouraged a motion on that issue. And at that time, both of the defendants were together. So Ms. Smith was here and Ms. Lehman was here. So I think that's what the prosecutor is alluding to. That's back when they were together, and I was sort of surprised to hear that, because that would be a whole thing, right?
Surprised to hear what, Your Honor?
That she said, that Ms. Smith said she wanted to call the shooter, and then later made it sound like I was required to compel the shooter to testify, right? So that.
Okay, so I
said, bring. This needs to be, if you think that you can bring the shooter in and I can compel the shooter to testify, and this was directed to Ms. Smith, you better file a motion, because that is not how I read the law. And so the prosecutor's point is that Ms. Lehman was there. So anything brought in this case caused a little tidal wave, and everybody to start scurrying around and researching and setting dates for pre-trials and hearings and all that. So everybody in the case knew, if there's an issue, you need to tell us what it is.
So Your Honor, to respond to that, my point is that in 21 or 20, so that hearing happens, I believe it's June 27th of 22. Mr. Keese, if I'm wrong, feel free to. Okay. Is that at that point in time, there had been no invocation. No one on behalf of EC, and EC himself, had not invoked his Fifth Amendment right against self-incrimination. What had happened at those
Correct.
time periods, thank you.
At that moment.
Correct. So there was nothing ripe to bring before Your Honor in terms of filing a motion to compel testimony, because he hadn't invoked. The very first invocation happens, I think it's 1 day prior to Jennifer Crumbley's case, which is January of 2024. So
I think there was a feeling of shock when she said that, because I think everyone at that time truly believed that calling the shooter as a witness would be tantamount to dropping a bomb in the middle of the courtroom.
Well, Your Honor, and okay, I don't disagree, because Your Honor is entirely correct that you can't put a witness on the stand knowing that they're going to invoke. But no one knew whether or not he would invoke. That's number one, because he hadn't invoked. And then once he does invoke, respectfully, Your Honor, that imposes certain obligations on Your Honor. The case law is clear that when an attorney or a defendant makes a blanket invocation of the right against self-incrimination, there must be inquiry, right? The court, respectfully, is not free to simply accept that blanket assertion. So when does that assertion happen? Late January 2024, like a day before. Well, it kind of starts the day before Jennifer's trial. Then it's solidified, I believe, the first day of trial.
Well, the state court defender's office sent a letter and then sent an email.
Right, but the letter respectfully wasn't a valid invocation, because in that letter she concedes that she had not met EC yet.
But the next day she...
Correct, 100%, Your Honor. But once that happens, right, what had to happen under the case law is that EC had to be brought here for a hearing outside of the jury. 100% nothing could have happened in front of the jury. But the court is required to make a finding that the invocation is valid and that he understands it. Your Honor, given the facts in this case, I think it is, I don't want to say highly likely, but a distinct possibility that EC would have testified in his parents' trial.
The prosecution would have loved that.
I don't know that, because then all of his statements to the CFP, Your Honor, about never telling his parents that he was struggling that is the center of their case. These text messages to friend B that he is having hallucinations, which by the way, the prosecutor's own expert says he never had, okay? I mean, that goes to the inconsistent theory.
She questioned.
She said, Your Honor, very clearly that people don't share hallucinations. And every time he talked about hallucinating with the doctor, the expert at the CFP, he talked about sharing that his friends saw the same hallucination he was seeing, which led Dr. Anaker to give the opinion that he was not experiencing hallucinations.
Okay, so you're saying I didn't correctly handle the Fifth Amendment issue because I didn't bring the shooter here in his bulletproof vest and put him on the stand and ask him if he was going to take the Fifth. But, so you say the Fifth Amendment was not invoked, but I think it was invoked over and over again by his counsel.
No, it was invoked. I don't dispute that it was invoked. I dispute that in 21 or 22 that it was invoked, which should have led counsel to file some type of motion. It wouldn't have been ripe at that point because nothing had been invoked, and I think Your Honor agrees with that. But once he invokes, Your Honor is required under the case law to make a finding if the invocation is valid and to make sure that he understands the invocation. And that didn't happen here. And yes, I do argue that he did not have a valid assertion under the Fifth Amendment because counsel could have asked questions, Your Honor, narrowly tailored his questions, her questions, excuse me.
What question? What question would not be covered by the Miller hearing, the fact that the Miller hearing and the resulting sentence was being appealed? I think everyone in the courtroom at that time was surprised when Mrs. Smith said she was interested in calling the shooter. I can't imagine a way to call the shooter.
Because if the questions asked of EC are confined to information that is already known by the prosecution and by the sentencing judge, how can there be additional incrimination?
I don't know. I can't imagine a question he could have been asked.
Your Honor, I go through a list of 17 of them in the brief.
Saw them. Did you go on a camping trip? I don't think that he could have answered any of those questions. A lot of those questions are from a Miller hearing because his background...
No. That information is lifted from the CFP report. That's why I specifically tailored it to that.
That's separate, though. That's separate. Just because he answered questions in a forensic center interview doesn't mean he can be compelled to testify under oath about those questions, when they would also be the subject of the Miller hearing, right?
They were already the subject of a Miller hearing. They were
still on appeal
already, 100%. Those facts were already known to Judge Rowe. The CFP report was made an exhibit at the Miller hearing, which means the prosecution and Judge Rowe were already made aware of all those 17 facts that I list in the brief that are all helpful to James Crumbley because he is portrayed as some disinterested, negligent father, and the fact is that EC statements at the CFP do not support that. They don't support that.
I know that's your position, but try as I might, I couldn't do anything about that.
I understand that, Your Honor, but it was required that Your Honor make that inquiry. Counsel does not have to ask for it.
I didn't bring the shooter in and ask him. I didn't.
And, Your Honor, the only way to remedy that is with an evidentiary hearing.
Okay, so you want me to bring the shooter in and ask him?
I want the court to make sure that it was a valid invocation and that it was appropriate. That's how you correct the mistake.
I guess I would have to say that I'm satisfied that he invoked his Fifth Amendment rights.
That's not the question.
Okay.
The question is whether or not the blanket assertion is appropriate. Respectfully.
I'm feeling confident, respectfully.
Your Honor, that's all I have to say on the Fifth Amendment issue. I did just have one other, and I don't know if Mr. Keese wants to respond. I did have one other sort of point that I wanted to make to the court that kind of culminates everything,
Okay.
but I can certainly wait, or Your Honor can just tell me to sit
I'll
down.
let him respond. And
Thank you, Judge.
One or both of you might not be happy with my ruling, but you won't say I didn't let you say everything you wanted to say.
Thank you, Judge. I'll be brief because I believe the court recalls the June 27, 22 hearing, and I do want to point out that we do assert that Ms. Lehman abandoned the issue, but that's not critique or criticism. That's just appropriate to point out for the appellate posture of the case, Judge. And she abandoned it likely for good reason, as the court has already indicated and read that for instance. Now, the fact of the matter is that the shooter's own expert at the Miller hearing called him a feral child. If that information were all to come out, Judge, like you said, it'd be tantamount to dropping a bomb in the middle of the courtroom. Judge, the fact of the matter is that the information that would come from the shooter, every question would be an issue for him. There's an opinion yesterday from the Michigan Supreme Court regarding juvenile lifers, Judge. This is an ongoing issue. We're in the middle of the appeals right now. He asked for a new trial or to withdraw his plea already. That was denied. That's on the appeal currently, Judge. Anything that would have been asked by either party would be an issue for him in the Miller hearing. I think the court is understanding that. So if the court has any other questions, I'd be happy to answer. But I do just want to refer for the record back to the court's soon-to-be unsealed record regarding the forensic report and its non-exculpatory nature, and the fact that, again, we never stood up and said privilege. We just said, as the court correctly pointed out, he does have a privilege, and all parties research that issue. Thank you.
Well, I did a lot of research about that because, obviously things that he said, the shooter said, would be of interest and relevant to both Mr. and Mrs. in their hearing, in their trial. But there's no support for the release of it. I looked for it because there's just no support for it. The privileges belongs to the shooter and no one else. So, what else did you want to say?
I just wanted to kind of close out. I do want to address one statement made by Mr. Keese.
I'm going to let you both say whatever you want.
Thank you, Your Honor. You've been extremely patient this morning. Mr. Keese mentions that that EC's own expert referred to him as a feral child. The prosecution's own expert said that EC was not mentally ill, that he was hopeful at the times preceding the shooting, that he was engaged in hobbies that he found enjoyable. So to the extent that you want to start putting out there what different experts said, it's the prosecution's expert who portrayed EC at his Miller hearing as hopeful and engaged and spending time with his parents and generally had a very good childhood without negligence and abuse. Those are, Your Honor, direct quotes. They are in the brief, and I've attached her testimony from the Miller hearing. So I am not playing fast and loose with the facts, Your Honor. Your Honor, I wanted to just sum up. Every time, Your Honor, that I've seen this topic of the prosecution's misconduct is discussed, whether it was when Jennifer Crumbley's motion for new trial was being arguing, whether it's in the press, the prosecution pivots. It pivots from the attention on its misconduct to the absolutely horrific murders that happened in this case, rather than focusing or even acknowledging their own misconduct. And Your Honor, it is, in my opinion, a very blatant attempt to distract the court and the public from how they failed to give James Crumbley a fair trial, how their misconduct robbed him of meaningful cross-examination and a chance to expose to the jury the biases of Hopkins and EJAC. This case, Your Honor, is gut-wrenching. It is heartbreaking, and it is traumatic for an entire community. But our rules and the court's obligation to ensure due process and a fair trial and full and fair cross-examination cannot bend to emotion, Your Honor. If it does, then our justice system has no integrity, and the rules mean nothing, and the Constitution means nothing. The parties must adhere to the rules, and you must enforce them equally to sympathetic defendants and to defendants who garner the most visceral of reactions, Your Honor. In this room, the law must reign supreme regardless of pain and trauma. And I can just see the headlines now, Your Honor. Callous defense counsel doesn't care about the pain of the families in Oxford. And that is not true. Your Honor, and it's funny, it's ironic because Mr. Keese just mentioned, the movement in juvenile lifer cases. When Miller was decided in 2012 and made retroactive in 2016, our courts repeatedly acknowledged how painful this change in the law was going to be for families, right? Families of victims who for decades had maybe reached a point that they could put this pain and trauma behind them, but we still changed the law. The United States Supreme Court required that mandatory life without parole be reversed, and that all these defendants come for resentencing, despite the pain that they acknowledge it would cause. In civil cases, Your Honor, sanctions are imposed to punish and deter, and all you're dealing with is money. This is a criminal case. This is a man's liberty. It is his freedom. It is his ability to live outside the prison walls. If Your Honor does not grant a new trial, you send a message to Karen McDonald and to her office that you will, and that the courts will, tolerate this type of misconduct, this type of constitutional violation. And perhaps even more troubling, you send a message to prosecutors throughout this state that failing to disclose Brady material, information that is critical to a defendant's meaningful right to cross-examination, will not be sanctioned, Your Honor. Mr. Crumbly is entitled to a discovery remedy. The only remedy that can make him whole is a new trial, Your Honor. Thank you.
Thank you. Anything, Mr. Keese?
Just briefly, Judge. Judge, throughout today's argument, I feel that my responses have been measured, and I've said over and over again that it is one thing to argue the law, it is quite another to throw around unfounded allegations. And I sincerely take issue with the fact or the allegation that we prosecute for headlines. We prosecute for victims, Judge, for victims. That's why we're here, and that's why we do this job. James Crumbly was convicted because of the choices that he made, the choices that led directly to the deaths of Hannah, of Madison, of Tate, and in Justin. It was James Crumbly's gross negligence. It was James Crumbly's causation and his foreseeability that was the reason for his conviction, Judge. The evidence in this case was overwhelming. I simply ask that this court review the law, follow the law, Judge. Our brief is detailed. Our argument, I believe, is clear. Thank you.
Thank you. I don't think you can expect something from me in less than a month, probably. I'll do my best, but I've been being very careful, and sometimes I think some of my other 550 cases have taken a back seat to these two cases in the last 3.5 years. So I will do my best to get back to you as soon as possible. All right?
Thank you, Your Honor.
Thank you.
Thank you, Judge.
All rise.
All right, so we did not get a decision from the judge. I will try to hunt down the decision whenever that decision comes. But yeah, so James Crumley is asking for a new trial because it would make him whole and because of the prosecution made errors. Well, that's what all they say. That's literally what they say at all times. That is my days absolute. I don't think it should really. I think they did a very fair trial. Did watch this trial live. Oh, what? Are you kidding me? Hang on, I'm gonna share something with you guys that is just on my days indeed. Um, this has no sound, and the only thing that says is small plane crash in Florida. So we're looking at some breaking news out of Florida, of a small plane crash. What I'm thinking it is there in the middle of the dual carriageway. Yeah, Boca Raton. Thank you very much. Lois coming in Oh my days! I hope everyone is fine. What is going on with things falling out of the sky? Planes, helicopters. Sherry, I'm like afraid that like I just said that on chat, and I said like as a joke kind of thing, but when I'm gonna be coming for America, I'm walking. I don't care. I'm walking or taking the car or boat or swimming. I ain't taking no plane crash, no plane. My days. This is absolutely indeed, William. Indeed. I mean, wow. I hope everyone is okay. I mean, I don't know. Let me see. Let me rewind to see if there is like any other like views. It's only started like 5 minutes ago, so there's no much. Yeah, as yeah. Well, you can see that is there. Wow. Um. Well, yeah, true. Thank you very much. Yeah. Thank you, Paula, for ruining my boat thing. Howdy, hello, GSD Dogs Mom. Good morning. Hello, good morning, everybody. Um. Oh wow. Yeah. Was that Selena? Um. Is it? I don't know. It is very bizarre indeed. It is very bizarre indeed. I mean, this is just absolutely insane. Another plane crash. I know it's a small plane, but it is a plane. It's a crash. It is Oh wow! But Paula, thank you very much for ruining my hopes and dreams of going by boat to America. So I think I'm gonna walk. Is that okay? Is walking a safe option or not? Because I don't know what to do. It is very sad, case one. I mean, I was just like scrolling through to see like what we're gonna do next. And I just saw this, and I was like, no way, another plane crash. This just crazy. And hey, we are almost hitting 2 hours of deliberations. Whoop whoop. One second. See you in a bit. I'm sorry. So well, Paula, I can walk until the border, and then swim, and yes, exactly. I definitely need the life jacket. That would be true. Oh my days, that is absolutely crazy. Well, I honestly will probably like come back here because there's no sound, no nothing. Um, I know, Lois. We definitely need the verdict to come. All right. So I was like, because there's no sound. There's no like kind of point being in here. But I just wanted to show you guys what's happening while I am trying to see what else is going on. I know what we could do. I know what we're gonna do. I want to cover that thing, but um, I want to cover some other stuff. There is a case that there is going on. Next 3 hours definitely. Um, that's the Madeira. Hey, that's the Portuguese island Madeira. Right. Okay. So let me refresh this. Oh, GSD Dogs Mom, I actually fell asleep. I need to go watch it. I definitely need to watch it. I haven't watched it yet, which is very sad and not very unlike like me. That I haven't watched it and definitely need to go. Oh, I'm hungry too, Paula. Oh wow, everything is reporting the Boca Raton plane crash. Um, there is just flight but I don't really want a court hopping at the moment. I mean, just flight is good, is amazing, but I'm just looking if there is any other hearing going on while we are on verdict watch. So it doesn't seem like there is, but we can watch another hearing anyway. Oh, Denise, sorry. TC, if you want to walk on water, to get here, just send Looney Laurie Daybell an email for tips. I mean, Denise, yes, I think I'm gonna send an email to Looney Laurie for sure. You're amazing. I'm for sure we'll do that. Yes, of course, because it is 20 to 5 here. 20 to 5 here. It's already 20 to 5. I can almost drink. No, I'm joking. I'm not gonna be drinking today. I've done that yesterday. Um, no, I haven't watched it yet, so I need to watch it. Or is it the about the Laurie one, isn't it? The Laurie ones. Definitely, we need to watch that. I mean, we could all. Do you guys want to watch Kathy's videos? And then you still go and watch it personally because we can give her the views, but we can watch all the Kathy's videos. I don't think she's gonna strike me, but I think the daughter is in hospital at the moment. I always with her daughter in the hospital. They suspect either appendicitis, kidney stones, or a cyst, a variant cyst. I think that's the other thing. So she's just getting checked out. So but we are hoping and praying that everything is fine and everything is going to be okay. And I think she's on IV fluids at the moment and waiting for a CT scan. So did I say it correctly? I hope I did too, because we really hope that your daughter will be good very, very, very soon. So definitely, for sure. Um, yeah. So right, we are on verdict watch. There is no motions in court whatsoever. There is nothing happening. Yeah, it is painful as everything. So I really, really hope that everything is okay and it's just a very big, big scare. But better to get checked out than anything else. Indeed, for sure. I was gonna say, do you guys want to see Kathy's videos? I don't know if how I feel. I don't know. Because I want you guys to go to her channel as well, too. So I really want to watch it. I really want to watch. I don't know how I haven't seen it. Why did I had um Oh no, that one, it was a rewatch. I can try to find where that one is. I know Trial TV Live is doing a Corey Richards hearing, but that was already happened on the 7th. Give me a second. I can try to find where that one came from. Hang on. Because yeah, it's not live. It was the change of venue one that she had. Hang on 1 second. uh, mhm. 1 second. Oh, hang on. There is movement in court. I just saw the judge going into her seat. Hang on, I need, oh my days, what am I doing? Quick. Come on. So I just saw some movement in court in the Linda Stermer case. The judge is literally, oh, it's all right, no worries. Believe me, I'm on almost on everything. I'm on it. I'm scouring. Uh, so Oh, that's good. Well, at least I hope it's gonna like be quick and everything. I'm very, very pleased. I think there's movement in court. I don't know what it is. Maybe jury question. Um. Oh yeah, definitely. Okay, we'll do that. She is the dog's mom. I'm sure Kathy will be fine. Us using her video and talking about it and everything. She's amazing. She's a great, great person. I highly have her a big regards for her. She's absolutely amazing. She has helped a lot the channel, so I definitely owe her a lot. So, yeah. Yeah, maybe a jury questions. I don't know. I literally just saw the judge. I'll show you what I saw because I still have the. Come on, like, don't tell me that I've seen things again. I swear I did saw the judge. It's not like the other time that I say I saw the judge and then nothing happened and then there was nothing. I swear I did. Are you kidding me? It was not that long ago. I swear I did see the judge. I swear I did it. Oh yeah, I will watch it. We'll watch it, and then I'll post the link, obviously. But I think half of people are, or if not even half, I think everyone here is subscribed already to her. But she's awesome. She's amazing. She's absolutely amazing person. But like then obviously it, like you can watch Kathy more than once. I do. Just still go to her channel and give her the support there, obviously. um I think I am saying things again. I swear I did see the judge. Guys, I promise I did. I Oh my days, if I'm saying things I'm gonna like literally unfollow myself. See, I told you I see it. See, I did not see, there we go. Oh, hang on, you might not see because the fucking thing is did you guys see that? They've been deliberating 2 hours and 1 minute. Did you guys see that? Please tell me you've seen that. So she is the dog's mom. Lois. Okay, I'm gonna take my ticker and gone, and I'm gonna rewind. Okay, I'm gonna rewind again. And okay, thank you, Kay. Thank you very much for that. But I'm just replaying for Lois to see again. See, there we go. I told you I saw her. I told you. I told you that I saw her. So yeah, there is the the count, the clock there is on the screen. It's the time they have been deliberating. We always do that because of the verdict game. Yeah, I saw that piece of forehead. Oh, that's hilarious. Yeah. So I saw her. So I don't know what's going on because I don't know. It's like. Don't know if it is a question, if she's just gathering people. There is no movement on X. There's no nothing, no things to say. That if there's a question or nothing. So I don't know. I absolutely don't know because I don't want to stay here too long and then not do anything and just like talk out of it. But yeah, so the Corey Richards thing, yeah, why is it in here? I don't want to watch this trial. Well, I would, but oh wait, hang on. Core TV, where is it? Oh, no, I was gonna say Core TV just went live, but no, they didn't. They literally just went. So oh, the judge is going again. Oh, sorry, I had feed paused for you guys, so nothing was indeed happening. I think the judge left the chair again. So I don't know what's going on. I absolutely have no idea. I know there's a lot of movement, but I have no idea of what it is the movement from or of. Um, well, let's keep moving. If anything else, we come back here. See what's going on. Right. Let's go back and see if there is anything starting new, unless. Hey! Oh, thank you very much, KM. Thank you very much. Welcome. Welcome to the Green Gang. Thank you very much for your support, girl. I really, really appreciate that. Sorry. Just keep looking at the feed because I've got the court feed on my phone here, so if there's any movement I can see. But thank you very much, I really really appreciate that. You're amazing, thank you. You can take a sneak peek of the members videos that there is, and I'm actually don't know what I'm gonna do this week, because I have a rather busy weekend, and we are on baby watch, so I still have to think about it, but that's my own problem. But thank you very much, and welcome to the gang, to the green gang, to the green gang. I can't even speak, and I hope you do love it here. So now, without further ado, we are going to watch Kathy's Lori Daybell videos. Do you want to watch all of the three of them? Because it does make sense, because it started from the beginning of the trial, or do you want to just watch the newer one, the one from today? Because all of them are amazing anyway. So what do you guys do? All of them from part one, from first, from part one, or is just part three, the today's video? What you guys would like to do? There's still nothing, no movement from court, no nothing. Oh, you're waiting for. Oh, are you doing your toes? All. Okay, all of them. Okay, indeed. Let's go. Let's put that. It's not sharing this. No, it's not. There you go. Excuse me, sorry.
Hey, true crime friends, how y'all doing? Have you been waiting for this day? I have been waiting for this day for so long. The state of Arizona? I think it's Arizona. I affectionately refer to it as South Idaho, not to be confused with North Idaho, where she was convicted of the unfortunate unaliving of her children. Just please know, anything west of like Ohio, it's all, it kind of blends together for me. So I affectionately refer to that part of the country as Idaho, because it's just all over there, and I don't know nothing about that. Anyway, opening statements in the Lori Vallow Daybell case. I feel like it's like opening day of a sports ball season or something. Oh, I'm so excited. Okay. I'm going to calm myself down so we can talk about it. But first, you know what you need to do. Please like this video and subscribe to the channel. That helps other people find us. Also find me on Instagram. I never remember this. Instagram, Facebook, and Blue Sky. Okay, so look. I did an overview video a couple of weeks ago so that you could get all caught up on all things Lori Vallow Daybell. Today, I'm just going to talk about the opening statements. The history of this case, my entire Lori and Chad playlist will be in the description box of this video. So go find it there and start wherever you want to start, child. I have over 100 videos on these crazy people. Anyway, so the state of South Idaho is charging Lori, now she's Lori Daybell, in the unfortunate unaliving of her fourth husband, Charles Vallow. Are you following this, child? You might need a chart. It's complicated. Okay, so we get to court, right? I mean, I was watching it on my phone, but we show up in court and I'm like, okay, we good to go. And they were like, wait. We have a juror who's lost. I think he's late. We don't know. Is there bad traffic in South Idaho? I had no idea. And then they had this other juror who was like, I have a note from my employer. I don't know if I can do all this because I owe child support and alimony. And he went on telling his tale of woes. I was like, sir, we don't care. We want to hear the crazy lady represent herself. So can you just go and be quiet, sit down someplace. And then Lori was like, Your Honor, Brandon is here in the courtroom. And those who don't know were like, wait, who the heck is Brandon? Brandon Boudreaux, y'all. Okay. This is Lori's former nephew-in-law. She's just like, I have him on my witness list and I might need him. And the state was like, Your Honor, well, I think that Brandon should be able to stay. He's a family member. He can sit here and observe the court if he wants to. And the judge was like, okay, Lori, what is the relevance of Brandon being excluded? And she's like, well, I want him to testify to things. Ma'am, I understand that you're pro se and you may not understand how like the court system and laws and stuff work, but that's that saying somebody's going to testify to things is not a thing. And so you can't do that. What we're not going to do is that. And so they went on sidebar, and then the judge was like, okay, go on, take him out in the hall and talk to him for a minute and then let him come on back in. So the court was like, okay, we are going to strike him from your witness list. So now he's no longer a witness. But if you decide you need him, then we will usher him on up here because, we're not starting with the foolishness and the shenanigans. And there in the courtroom was all of Charles Vallow family, a bunch of Lori's family. Everybody was there to see this heifer hang. I mean, represent herself. Please know, in my opinion, the stakes on this case are relatively low. Now, it's high for the family of Charles Vallow. Hey, Kay and them. Oh, I love the Woodcocks. Anyway, the stakes are high for them because it is their family member who has been taken off the playing field, which is terrible. But in terms of like the judicial system and will Lori be punished, she's already serving life for the unfortunate unaliving of her children and her fifth husband's wife. But there's a lot of complicated families in this story. Oh my goodness. But my blood pressure was not up. I was not like, is this evil heifer going to be on the streets? Is she not going to be on the streets? That's not the question here. The question is, will Charles Vallow's family get justice because he was unfortunately unalived by this evil trollop? I mean, she's presumed to be not a trollop until found. I guess she's still presumed to be. I presume her to be a trollop. She's presumed to be not guilty. And we're going to give her that. Okay, you're not guilty of this crime yet. Anyway, so the state finally gets up and says, okay, roll your mind back to July of 2019. And I was like, oh, this took place that long ago? It doesn't seem like that long ago, but this was a long time ago. Lori Vallow was married to Charles Vallow, but she wanted to be Lori Daybell. So that you get a visual, right? Lori used to be a beautiful woman, blonde hair. She had a little cash in the bank. She was raising her kids. She was just like, oh, I'm a hairdresser and I'm gorgeous and I'm just out here living my best life. And I have a gorgeous former professional ball playing husband. He's all jacked up and built. We are like Mormon Ken and Barbie. Don't we look terrific? She has fallen in love with a man from North Idaho, Iowa, who's broke and looks like a thumb. What she saw in this man child, I will never understand. But okay, it's not my business. So the state opens up and it's just like, opens by quoting Lori's text messages. And I was like, ooh, dramatic. And the text messages are like, I'm going to need you to stay close to me this week because we about to unfortunately unalive some Mama Luke's over here. I mean, again, not a quote. I'm just giving you the spirit of what was said. She's like, I'm going to be Nephi and you're going to be Laban. And I was like, who? I don't know if you know, I'm not LDS. Hey, Mormon friends. But apparently in the Book of Mormon, Nephi was a good guy and Laban was a bad guy and the good guy killed the bad guy. And so Lori is like, I'm going to be me and you, brother Alex, we're going to be the good guy who kills the bad guy. The bad guy is my brother, it was her husband, Charles Vallow. And I was like, okay, Okay, so she thought she had like biblical authority to unfortunately unalive her husband so she could marry that thumb-looking Mama Luke over there from North Idaho, Iowa. Okay, girl, this don't sound like a good plan to me, but what do I know, right? And so, according to the state, long before she unfortunately unalived her husband, she was just out here giving up the whole game to her friends, right? She was married, everything was going good, they had 5 kids between them, and she was just like, this whole marriage thing, it's not working out for me. So she commits to running her mouth, Lord, another person who has failed shut up classes. So she was just like saying to her friends, I might have to take him off this mortal coil. I'm going to send him over onto the endless heaven buffet and he can have all the creatine he wants over there. But here in my house, nope, I'm not going to do it no more. And so she told her one girlfriend, I've been crushing up. She has a son, Lori and Charles had a little son, JJ, who was autistic, right? And he took all kinds of medications for that. So she opened her mouth and told her girlfriend, I've been crushing up JJ's pills and putting them in Charles's protein shake. And the girlfriend was like, I'm sorry, what? I'm your church friend. Now, what you should maybe not do is confess to poisoning somebody to your church friend. I mean, keep in mind, these are people who don't drink coffee, but they gonna drink. It's okay to poison your spouse. Oh, okay. I guess it's no caffeine in poison. Unclear. So the friend was like, hey, Lori girl, come here. Look. If he comes up dead, I'm gonna have to go to the police. I just want you to know. Good on that friend for being like, I know this heifer did not. Don't be confessing to no unfortunate unaliveness to me. As an unrelated aside, friend, don't confess no crimes to me. Because I too have failed shut up class. Oh yeah, I'm a shut up school dropout. I'm gonna be like, oh really girl? How you think you're gonna do it? Speak directly into this flower on my lapel. Like, but hello, police. You're not gonna believe what this heifer done said to me. I'm gonna report you. I'm gonna turn you in, just so you know. Anyway, so the friend was like, "Girl, if he come up dead, I'm telling." And Lori was like, "Oh my goodness, I was just kidding." And then 3 weeks later, dude was dead. Yo. So I was just like, okay, good on that friend for telling, because caffeine is a sin and so is poisoning people, according to them. I mean, according to everybody, poisoning people is a sin. But anyway, so Charles, meanwhile, was like, okay, I'm going to be in South Idaho, Iowa, and I'm going to see my crazy wife, and I'm going to try and visit my beautiful, precious child. Meanwhile, let me just get on like J-Date. M-Date. I don't know where our LDS friends go to date, but he went on some like Mormon dating site because they were LDS. He went on a Mormon dating site and he met a nice lady. And he was like, hey, nice lady, let's go to dinner. Look, did you see how big my muscles are? Aren't I a good looking guy? I have a lot of money and I'm a really nice human being and I have a beautiful, wonderful family. And the lady was like, oh my goodness, this is so wonderful. I would love to be your 5th or 6th or 7th wife. Not clear how many, but sometimes, it takes a couple tries to get it right. So they go on a date, and during the course of this date, Charles overshares. He tells everything. He's like, I married a beautiful woman. Everything was great for a lot of years. Then she got super duper religious, and she went from being like a regular funeral potato Mormon. She slipped over into being a better than you Mormon. And I mean, it was okay. She was better than you Mormon, but then she became a zombie Mormon. For those who don't know, there are 3 levels of Mormonism. According to me, look, this is strictly the gospel according to Kathy. Regular, beautiful, wonderful neighbors, those are funeral potato Mormons. We like them. They are very, very nice people. They make good friends, good neighbors. They don't drink no caffeine. They don't poison people usually. Everything is great. But sometimes they're like, I want to be more devout. And then we have the better than you Mormons, right? The better than you Mormons, they're more Mormon-y than you. But please know, this is not limited to our Mormon friends. It's a better than you PTA mom. It's a better than you block captain. It's a better than you secretary down at the job. There's always a better than you level at everything. She's like, I'm so pious. Now, what happens sometimes is these better than you folks, they slip over into the zombie stage. Now, in this context, when Lori went from a better than you Mormon to a zombie Mormon, she was like, Jesus told me I could kill people and it don't count for me. Now, see, look. We don't mind. We love our regular funeral potato friends. The better than you level, we are annoyed by, but we will tolerate. The zombie folks, no. We don't mess with them zombies, child. They will unfortunately unalive you. You will never have seen it coming because you was like, I just thought she was better than me. I didn't realize she was a zombie. Anyway, so Lori has slipped from being a better than you Mormon to being a zombie Mormon, right? So back to this date, Charles Vallow told his little date on the first date. My wife we was just regular LDS. I'm funeral potato. She's funeral potato. Everything was cool. Then she became a better than you. And now she done lost her whole mind. And she's out here just like doing all these strange things and saying Jesus is her boyfriend and all this other stuff. The heifer's crazy. I don't know what's going to happen. And the girl was like, wow, this is our first date. Girl, I hope he took you out for like a steak or something nice. Cause like, I cannot imagine hearing all this on the first date. Hello, Captain Overshare. You are team too much. Anyway, so she was just like, okay, I know you sell life insurance and stuff, and you have a big life insurance policy on your life. Why don't you just tell her that she's not the beneficiary of the life insurance anymore? And then maybe she won't unfortunately unalive you, and then you can divorce her ass and take me out to more nice restaurants like this one here. Oh, I hope he didn't take her to just like Taco Casita or something ridiculous like that. And so So the lady said it as a joke. And then the next day she couldn't reach him. And she's like, I know this Mama Luke did not take me out and then totally ghost me. Okay, let me go back on M date or Moroni's or wherever they date. And I'm just going to keep going, right? So it was months later where she was just like, reading the newspaper, letting her little Google fingers do the walk. She was like, oh my goodness. That crazy lady done unfortunately unalived her husband. Hello, police. Thank goodness all these people called the police and told their story because this is crazy. Okay, so this is still opening statements, y'all. All this came out in opening statements. So then what happened was, okay, sorry, I'm getting a text message. I really should turn off the do not disturb. Anyway, Alex Cox, Lori's brother, was just like, yeah, Charles is gonna come over and I'm gonna get my pew pew and I'm gonna apply some lead to him, and then the zombie is gonna be no longer on this mortal coil. Y'all, Alex, Lori's brother, killed Charles just right there on the living room. The man came in the house, they pew-pewed him up, and then they staged the scene and did all this other stuff. And I was like, oh my goodness, I do not understand what is happening, right? And so they staged the scene so that they took a baseball bat and they put it by his right hand so that Alex could say, ooh, Charles hit me in the back of my precious little head with a baseball bat. It is terrible. Oh my goodness. And then according to the state, there's plenty of evidence of everything. There's text messages and calls and all kinds of stuff, emails that show that Lori and Alex worked together to unfortunately unalive poor Charles so that Lori could hopefully get the life insurance money so that she could live happily ever after with a thumb from North Idaho to Iowa. Now Lori gets up and she's just like, hi. Now listen, Lori, she of many faces, was like, I'm going to use my softest, innocent girl voice, and I'm going to tell you what happened. My name is Lori Daybell. I don't know if she said her last name because I feel like her last name implicates her because she used to be Vallow and now she's a Daybell, meaning she unfortunately unalived the hot guy, and she did, after all, marry the thumb. And so she was just like, now see, if there's a conspiracy, which they say I'm guilty of, there has to be a plan. There was no plan. We were a blended family, and the evidence will show that I was very pretty, and the evidence will show that I have all this gorgeous hair. I was a hairdresser for 20 years. Do you know I've been able to figure out how to do my hair here in the prison? I'm doing the hair of the other ladies. Everybody looks fabulous back there, but that's another story for another day. The evidence will show that Charles was a life insurance salesman, and he always got the maximum amount of life insurance for both of us. And I was like, okay, that actually makes perfect sense to me. And she's just like, the evidence will show we were married for 13 years and I was really pretty and really shy, so demure, so mindful. And I was like, okay, all of this is perfectly reasonable. And then she said, we had a blended family. I had 2 kids, he had 2 kids, and then we adopted this baby together. My daughter, my biological daughter from like one of my previous marriages, she was really, really great with Charles, but then they started fighting when she became a teenager. And I was like, child, that tracks. I have lived with 4 teenagers and it is, make you clutch your pearls. Anyway, so she was just like, Tylee started fighting with Charles and I was trying to keep them apart. And so like, I just told Charles, we need to take some space. Don't come to my house. But then I may or may not have lured him to my house. These are not the words she used, honey. I'm just giving you the spirit of what she said. She was just like, I invited him over to take JJ to school, but I made sure that my brother Alex was nearby so that we could unfortunately unalive him and I could get all that insurance money because there was a hot thumb waiting for me up in North Idaho to Iowa. And so Tylee was just like, oh, I'm mad that you're here, Dad. And so Tylee was swinging around a bat or whatever. And then there was a fight over the bat. And my soon-to-be ex-husband was chasing me with the bat because he was very, very mean. And in all the melee, Charles tried to hit me with the bat. Alex took the gun and pew-pewed my husband up, and I was just like, oh, this is terrible. Just like any normal person would do, I'm gonna have to take the kids and go to McDonald's or Burger King or wherever it was. She took them to fast food because usually I think the traditional meal when you have recently lost a parent is the Burger King drive-thru for chicken fingers. Okay. She goes on to let us know that 5 months after the unfortunate unaliving of my husband, my poor brother passed away from blood clots. It's not suspicious at all. He didn't go to Mexico the day before his untimely death. He didn't buy any medications that may have caused him to die in a way that looked like natural causes. None of that happened. What I personally had not realized was that there was only 5 months from the time Charles died until the time Alex died. That's a lot of, and so what you need to understand is in that 5 months, if you know this case, then you know, in that 5 months, Charles died, Alex died, JJ died, Tammy Daybell died, and then Lori and Chad got married. They wiped out all these people in a very short period of time. That is crazy. I knew it was a condensed timeline. I thought it was over the course of a year. I had no idea it was only 5 months. I was like, girl, you are going to jail. But I was like, you know what? You have stood up here and you've given a good opening statement. I'm going to give you the benefit of the doubt. And she closes her opening statement by saying, this was a tragedy. It was not a crime. Family tragedies happen. And I was like, is she ripping off Chicago? It was a murder, but not a crime. Okay, you gonna do a dance too? Girl. So I was just like, okay. And then she sat down, so mindful, so demure. And then the state was like, okay, Heifer, let's see how this goes. So please hold. The state calls up the first police officer, right? The first police officer was just like, I was there on the scene. Alex was very calm. The dude was dead like a carp on the floor. What you want from me? Here's the thing you need to understand. Alex shot up the dude. Now, normally if it's something terrible happens like this, you're like, oh my goodness, this is terrible. Hello, 911. That's not what he did. He shot, Alex shot Charles and then waited 50 minutes. 50, nearly an hour to call for help. I guess he was like, let me just make sure you have fully exsanguinated, bled out there on the floor. Meanwhile, during that 50 minutes, he called his sister twice. I think he's still twitching a little bit. Let's give this another 15. I don't know what he said on the phone. I'm surmising what he said on the phone. He was like, yeah, chest is not rising or falling anymore. Can you call your thumb up there in North Idaho to Iowa and confirm that he's really dead and not just like appears to be dead? Because they believed in all kinds of freaky stuff. They might have seen him dead on the floor and be like, I don't know if he's really super duper dead. He's only like super dead. Okay, so Lori probably called and checked and was like, yeah, according to the thumb, he's like super duper dead. So go on and call for help. And I was like, okay. All these people are shady. And then Lori gets up for her cross-examination and she said, you said Alex was nonchalant. And the cop is like, that's not what I said. I said he was calm. And Lori was like, I thought you said he was nonchalant. Should he have been chalant? You don't know about his level of chalantness. Sometimes he's chalant, sometimes he's nonchalant. I don't know how many more times I can say nonchalant, but I think you have mischaracterized his chalantness level. And the cop was like, okay. Are there more questions, Heifer? That's not what he said. That's the spirit of what he said. And so she asked a lot of clarifying questions and then repeated his answers back. And I was like, what are we doing? What are we doing right now? I was like, okay, she's nervous. We're going to let her get started. Then the second cop came up and was like, that Alex, he was real calm. And Lori was like, well, maybe that's just his demeanor. You're calm. I'm calm. Everybody was calm. And the state got up and was just like, hey, officer, let me ask you a quick question. Are you calm here today? And the cop was like, And she was like, were you calm there on the scene? And he was like, I'm a cop. I see all kinds of craziness. You know what you want from me. And the state was like, right. But had you just shot somebody? And he was like, no, ma'am, I had not. I was like, ooh, very interesting distinction. Okay. And then in this case, the jurors get to ask questions. I was like, ooh, the way I love a juror question. Yes, please. And so the jury got up. I mean, one of the jurors had a question. I don't remember what it was. It was of no consequence to me. And I was just like, okay. Then a firefighter got up and the firefighter was like, they told us on the radio somebody had given this man CPR. Clearly, nobody had given him CPR. We got there. We was like, we tried for a couple minutes. We were like, nah, save your breath. He's super duper dead. And it's very tragic. This heifer gonna go to prison for a very long time. But her hair gonna look good while she goes to that face. Child, the glow down is so real. Anyway, that's all that happened on the first day of court. I will be reporting on this case breathlessly. So stay tuned, like this video, subscribe to the channel, and I will see you soon.
Absolutely do that. Subscribe. I will share her link in a second. But I'm sure everyone is already subscribed to Kathy anyway, because you all have good tastes of subscription people. So definitely yes. So now I know I love her too. I was like literally I watch her videos like pronto as soon as they come out because normally I'm home when they come out. I'm literally like she's there. Oh my days, it's always. So the second one, but to be fair, she does make me think, and I like it because she really like explains things very easily, and she's just it's my type of person, and the way that she speaks, she's amazing. Yeah, exactly. And oh, can you imagine listening to her 2x? You know what? Let's try to see how she is in 2x. I want to see it because even on a normal speed, I'm like slow down, but on like let's try. Oh, you were 2 hours in the. Well, you 2 hours. I can't. Lol. Hello, Jason. Uh, I'm just saying to Jason now. That in 2 hours, I'm saying hi. I'm saying hi to you. So yeah, so hang on, so then I'm gonna rewind because probably will not catch anything that she's saying at. Let's try 1.5 because I think in 2x would be too bad. Hang on, let me add this to the stage. Oh yeah, that's the one that we're gonna see today. No, I think that is the one he.
Good morning, true crime friends. How y'all doing? Lori Vallow-Daybell, honey, she has not disappointed. This trial is giving us everything, every single thing. Please know, this is not the news. You are not here for the news. If you want to know like the facts and stuff of what happened in the case, go on over there to the East Idaho News with Nate Eaton, or go talk to Gigi over at Pretty Lies and Alibis. Us over here, oh honey, we are here for the gossip, the rumor, and the innuendo. So, first, you know what you need to do though. Like this video and subscribe to the channel. That helps other people find us. Also, find me on Instagram.
That is our 1.5, right? That's our 1.5, Kathy at 1.5. Now let's try to see on 2x, on 2 times the speed.
Facebook and Blue Sky, and play Lori Vallow-Daybell Bingo. The links to that are in the description box of this video. So look, over in the court there the other day, down there in southern Idaho, Iowa, there was a bunch of first responders on the stand, and Lori was very, very guilty. And I was like, oh, this is how she gonna play it. Okay, I got it. She got a whole bunch.
I cannot do it on 2x. 2x is way too fast for her. So let's go back. 1.5 should be fine. Sorry, it's funny. I'm sorry. I am not making fun of Kathy. I am just showing something. I would never make fun of her. Never, ever would do that. I'm just demonstrating something. I highly respect her, and just a disclaimer. Just in case.
Men on the jury, and she's gonna be like, oh, I'm cute and I need you to rescue me. Hey there, first responders, did you respond first? You did. Oh, that's so wonderful. Okay, also, how does CPR work? Do you push on the chest and then you breathe, or you don't breathe? Oh, and how do bullets work? She asked a whole bunch of dumb, really, really obvious questions, but I was like, okay, maybe Miss Lori is just getting warmed up. She's just starting with the first responders so she could get this show on the road. Okay, cool. So after a whole day of first responders on the stand, I was like, I'm kind of bored with this trial. I don't know if I'm gonna keep following it. And then it happened. They had this one guy who was a police officer, detective or whatever, but he's also a gun expert. And he got on the stand, and I was just like, okay, here we go. So the state asked a bunch of legally law questions or whatever about the gun expert. And Lori was like, I object to this man being an expert. He's known about this case for too long, and I don't think he's expert enough. And the state was like, what? And the judge was like, no, girl, that's not at all how this works. And she's like, well, I mean, I don't really care for him, but okay. So when it was her turn to ask questions, she was like, did you swab Alex's hands for gunshot residue? The pew-pew dude, the brother who confessed to doing the pew-pewing. And the gun expert was like, no, because he said he did it. And she was just like, right. But did you swab my hands? Did you swab my daughter Tylee's hands? And the guy was like, no, because Alex said he did it. And I was like, ma'am, where are we going? Where are we going with this? And she's just like, there were 2 shots, right? You said there was two pieces of lead put in him. You know, I can never remember what we can say over here on YouTube and what we can't. And the expert was like, yeah. And she was just like, okay, but one of them was like a front on shot and the other one was from at a different angle. But you said that sometimes certain fabrics can slow down a bullet. And the guy was like, If it's a tight-fitting spandex shirt, sometimes in certain instances, maybe a little bit, that could happen. So Lori's like, did you know he was wearing a $200 bamboo shirt? And the gun expert was like, yeah, it didn't matter. It had to be tight-fitting, and that the shirt was not tight-fitting. And she's like, well, did you call the manufacturer of the shirt? I mean, this was a really strong shirt. And I was thinking to myself, now look, maybe Miss Lori is confused. The gun expert has said that Charles was laying on a solid surface. So maybe she's thinking bamboo, the shirt was made out of something solid. I don't know what's wrong with her. We know her brain is real super duper ticklish. So I'm like, okay, Lori, I think you might be a little bit confused, but keep talking because you sound real crazy.
Sorry, the interruption. Sorry, Kathy, I interrupted you. But see, this is why I love Kathy. I just emailed her just to make sure, like, I'm telling her that I'm showed her videos on here and everything. And she was like, oh, don't worry, it's always okay to show my videos. She's just the sweetest person ever. She's amazing. But I will also give us an update. Still waiting on a CAT scan. I moved the vehicle closer to the ER entrance, which is near the helicopter landing area. No traptors anywhere nearby. Glad to be here. Oh, glad that you are here as well. But I wish you could be at home with not in the ER. But yeah, I really hope everything is okay pretty soon indeed. Oh, sorry, not a good image to
And
stop.
I'm loving.
Hang on. There you go. Probably not even better, but anyway. But yeah, I really hope that everything will be better fast and soon. Iowa. Okay, let's get real.
Every single moment of it. So the gun expert did his thing, and then Lori was like, Your Honor, I would like all of his testimony stricken. And the judge was like, oh, dear Jesus. Why? What is the legal grounds? And she's like, I think all of his testimony should be stricken. And the judge was like, for what? In judicial language. That's not like exactly what he said. That's the spirit of what he said. And he was like, okay, can you tell me what? She's like, I don't want to argue. Ma'am, did you? I don't know if you noticed, you're here in court, and this is where the arguments happen. Oh, right. You're defending yourself, and your brain is not quite right. Okay, I understand that your act right is a little loose, not fully installed, so we gonna let this go. And then the gun expert got off the stand, and I was like, oh, all 3 rings of the circus have showed up today. All 3 rings, and I, for one, am loving it. And then the state did this amazing thing. They called Miss Nancy Joe to the stand. And I know you're saying to yourself, well, who is Nancy Joe? This is what you need to understand. Charles Vallow was ready to move on from this. Dog, don't you start that barking today. You see me talking to the people. Charles Vallow was on dating sites because he's like, look, my wife is clearly out of her rabbit ass mind, and I'm gonna have to get me another heifer up in here to like make my dinner and keep me warm at night or whatever. I'm just assuming that's what he was thinking. But he wanted love, he wanted companionship, and who doesn't? So he was on a dating site, and so he met Nancy Joe. Oh, and they liked each other, and they were texting back and forth, and he was good with the banter and everything. So after a week of like talking and texting, they decided to go on a date. So the night before he was unfortunately unalived, he went on a date with Nancy Joe, and Nancy was like, oh, we met down at this restaurant down by the mall. Oh, he was charming, he was kind, he was calm. I really liked him. And I was like, ooh, there's nothing better than a good date. I love it so much. And so Nancy is like, I am a funeral potato Mormon. For those who don't know, there are 3 levels of Mormonism. According to me, this is not facts. I mean, the Mormon church has not designated these levels. I personally, Kathy from the Gossip, the Rumor, and the Innuendo, have designated the 3 levels of Mormonism. And I'm going to go through them quickly because I've done this before. Number 1, the funeral potato Mormons. Those are the regular, run-of-the-mill, average Mormons. We love them. They make good friends and neighbors, lovely people. Level 2 is better than you Mormons. Those are the ones who just study a little bit more and they more Mormon-y than you. They closer to Jesus than you and all of that, right? Level 3 of Mormonism are the zombie Mormons. That's when a better than you Mormon just takes it too far and they think they're allowed to unfortunately unalive people because Jesus told them they could. We here at Gossip, Rumor, and Innuendo adore the funeral potato Mormons. Lovely people. No, we do not want a free Book of Mormon. Don't send me one. The better than you Mormons, they're fine too. Like, they're a little bit annoying, but they're fine. Them zombie Mormons, no, thank you. You can't come to my house. Don't come knocking on my door. I don't want to know nothing about you, right? Okay, so we're clear. Miss Nancy Joe is a funeral potato Mormon. Charles Vallow, a funeral potato Mormon. Lori and her ilk is a combination of better than you Mormons and zombie Mormons. And to that we say, ew. That's our official stance. Anyway, so funeral potato Mormon, Nancy Joe is a mother of 5, grandmother of 15. She's like 61 years old. She's out here dating. She's divorced. And so she's just like, okay, I would like to meet a nice funeral potato Mormon. So she went on funeralpotato.com and she found herself Charles, and they went on a date and they have a really lovely time. So they start talking. And during the course of the date, Charles starts describing Lori's beliefs. And Miss Funeral Potato Nancy was just like, that's strange. I've been a member of the church for a long time. I raised my family in the church. Some of the things that she's talking about, I've never heard nothing like that. But see, Miss Nancy probably didn't know about the zombie level because she only knows like other funeral potato people, like she should, because she's a decent lady, right? And so, but she was like, okay, this dude seems really nice. He seems real funeral potato-y, and this is gonna go good for me. Please hold, my throat is already dry. So She's describing the date. They had a lovely time. They chatted for a really long time. They closed down the restaurant, and she knew that Charles was very, very excited to see his son JJ, and he was going to take JJ to school tomorrow. And he just was like over the moon with excitement. They also talked about life insurance. Now, Nancy found out that Charles sold life insurance. Okay, that's his job. Good for him. And then while they were talking during the course of their conversation, Nancy was like, baby, your wife sounds real unhinged. I mean, I don't know what she's dealing with over there. She seems like a better than you, but she's past the better than you level. These are not her words. It's the spirit of what she said. And then she said to Charles, you should maybe tell her that you changed the beneficiary on the life insurance. It'll keep you safe. But they were just like, giggling and talking or whatever. He's like, oh, girl, you're probably right. I definitely should. And then Charles ghosts her. And she's like, wait. How have I misread this date so wrong? We had a beautiful evening. We giggled, we talked, we laughed. It was a first date. It was very, very appropriate. Miss Nancy Joe is a very nice lady, but then she never heard from him again. Cut to 5 or 6 months later, she's watching the news and she's like, wait, isn't that dude that I went on that really nice date with from funeralpotato.com? And so she was just like, wait, he's no longer on this mortal coil, and that crazy ex-wife he was telling me about has unfortunately unalived him. I knew that he should have told her that he changed the life insurance, but this is terrible. So those are all the questions from the state, right? The state sits down, and I was like, okay, we have a very clear and lovely picture of Miss Nancy, and we like her a real lot, right? Y'all, then Lori Vallow stands up. First of all, Lori was salty. She was very heated. She was thinking to herself, how dare you date my husband? And so she said, and I quote, you dated my husband? And Nancy was like, he was getting a divorce. And Lori was like, no, he wasn't. And I was like, okay, is this going to start a slap fight? Is she going to be up there like trying to windmill on this lady? Ooh, can they shock her with the shock belt? I was so excited. I was really, really, really hoping she would get shocked, but she didn't. She sort of kept it together a little bit. And then Lori was like, do you normally date married men? Nancy Joe was like, wasn't you cheating with a thumb up in North Idaho? And Lori was like, did you ask if he was a good kisser? I was like, is this the Real Housewives of Southern Idaho? Is this the Real Housewives of murder trials? I don't understand what you're talking about, but okay. And then Lori was like, so you spent all your date talking about me? And Miss Nancy lets us know. She was just like, don't flatter yourself, heifer. We talked about a lot of things. And Lori, who was very, very in her feelings, this is why you don't need to be your own lawyer, because in your mind, you want to have a whole slap fight with a witness, but in reality, you should just keep your cool and act supremely unbothered. Lori, girl, you have participated in the unfortunate unaliving of this man. Now you're mad that he went on a very platonic date with a lady like 6 years ago? Girl, your act right is clearly missing in action, not installed. It's not that it's loose. It doesn't need lubrication. It's just gone. So Lori was like, did he mention that he had children? And I was thinking, objection, relevance, but okay, I'm not involved. I'm just, a bystander. And Nancy Joe was like, yeah. She's like, did he mention the tensions with Tylee? What else did you talk about? And the judge was like, whoa, wait. We need to go to sidebar. But then the sidebar equipment didn't work. So the judge sent the jury out and he was like, girl, again, not a quote, but he was just like, girl, you sure you want to ask that question? Because you opening a big old door. She can say anything. She can say anything at all about you. You sure you want God and all the world, including this jury, to know all your dirty business? Because this not going to go good for you. I promise you it's not going to go good. He said that in like judicial language. I'm just giving you the spirit of what he said. And Lori was like, yes, I want to ask her questions. Child, she went into the demon voice. And I was like, wait, what happened to like the so pure, so demure, so kind Lori talking in the baby voice that we saw yesterday? Now Heifer is big mad. Her hackles are up. Her shock belt is probably tingling a little bit. And I was like, I want to see every single thing. And so she was like, I'm gonna have lots of questions for this heifer. We gonna need a meal first. Let me go get my slice of bologna casserole there in the back, and then I'm gonna come back and I'm gonna ask her every single thing. And I was like, oh, this is what I've been waiting for. So I waited a whole hour. I could barely contain myself. And then when we came back, somebody must have pulled Lori's coattails during that lunch hour. Or maybe bologna casserole calms her down. I don't know what they serving her down at the prison, but in my mind, it's bologna casserole because ew. Anyway, so when Lori comes back, she was like, hey, listen, did you reach out to my sister-in-law, Kay? And I was like, wait, I thought you was gonna rake her over the coals. I was waiting for the coals and the raking, and you changed your mind. Oh, I was a little bit disappointed. But I was like, you know what? Lori is crazy enough to still make this good, and I'm here for it. So she was like, did you reach out to my sister-in-law, Kay? And I was like, wait. In Lori Vallow's mind, this Nancy Joe is some sort of fan of hers who wants to insert herself in the case, when really Nancy Joe is just a nice, decent human being who's trying to be kind to the family of this man that she really liked. And Nancy Joe was like, yes, I reached out to offer my condolences once I realized that he had passed. And Lori was like, did you know my brother? And she's like, yeah, I met him recently. And Lori was like, where did you meet him? And And I was like, okay, why is she all bothered? A girl. Clearly, Miss Nancy Jo has gotten under your skin, which I love that for you. But she's just like, where did you meet my brother? And Nancy Jo was like, one of my grandbabies, remember I said I was a funeral potato woman with 5 kids and 15 grandkids? One of my 15 grandkids plays the pickleball, right? And so we was down at a pickleball tournament. P.S. Since when do kids have pickleball tournaments? But what do I know? And so she was just like, I was at a pickleball tournament and your brother was at a pickleball tournament. And I just said like, hey boy, hey, but that was it. Lori, open her mouth and said, do you know what perjury is? I was like, Heather. The state was like, objection, rude. And I was just like, yes, she was very rude. And I was just like, this case is delivering. It's delivering every single thing I needed. And so the judge, sustained the up. He was like, yeah, that objection was right. Sustained. I couldn't think of the word. And so Lori was like, are you dating my brother? Girl, don't nobody want to date your evil family. Also, isn't your brother married? Like, you trying to make it like this lady is a home wrecker. She looks like a normal human being, and your act right is clearly missing in action. So what are you doing right now? Clearly, you do not have the ability to reflect and see how you are. I get it. That's probably why you was out here, unfortunately, unaliving folks, but that's another story for another day. And Nancy Jo was like, no, I was not dating your brother. So Lori was like, when you were dating my husband, I didn't realize that he was on dating sites. And Nancy was like, but wasn't you out there cheating with that thumb, the broke down thumb of North Idaho, Iowa? I was like, Lord Jesus. Then Lori asked the dumbest question of all. Was Charles in contact with you after that date? Nancy Jo was like, well, no, because he was dead. See, also you killed him, Heifer. That's not what she said, but that's, you know that was in her mind. Miss Nancy Jo had no time for the mess. She was not abiding any foolishness at all. I was living for it. Nancy Jo is a hero, in my opinion, mostly because she got to go toe to toe with this evil trollop and push her buttons. And it was like regular lady against regular lady. I would really like to see them in an episode of The Real Housewives of Prison. I don't know where they would ever meet again, but kudos to Miss Nancy Jo for pushing all of Lori Daybell's buttons and not allowing Lori Daybell to score not 1 point against her. And I was like, yes. And then the jury had questions and I was like, right. Oh, how I would love to be on a jury where the jury got to ask questions. Do you know the number of questions I would have? So many. Would they be related to the trial? Probably not at all, but a question. I love a question. So the jury was like, did Charles seem stressed about any of this or was he just cool and calm? And Miss Nancy Jo was like, he was very stressed. And then that was the end of it. I was like, can she stay? Can she stay out there? We like her. Are you going to stay in the gallery? Can you go get interviewed on the East Idaho Iowa News or with that Ashley Banfield or somebody like that? Oh, can she come to this channel? Nancy girl, if you're watching this, Nancy's kids, Nancy's 15 grandkids, hey y'all, hey, Nancy Jo family, please come on, gossip, rumor, and innuendo. Anyway, the next witness the state calls is this lady, Christina Atwood. And I was like, who this lady? Who's she? Why we know her? So Christina Atwood was like another lovely, lovely funeral potato Mormon, right? She met Lori down to the church back when she thought Lori was merely a better than you Mormon. And so she was like, okay, I joined a prayer circle. We went to Zulima's house. Y'all remember Zulima from the other trials, right? Zulima's that heifer who thought she could control the weather. Crazy. Anyway, so she was like, oh, prayer, you say? I love prayer. And I was like, this is nice. These women have made a nice community. They get together. They support one another. They strengthen one another. They pray for one another. This is so lovely. So they go on over to the prayer meeting. And I was like, okay. They just said nice prayers and then had some sandwiches and some iced tea or something like that, right? During the course of like the chatter, the pre-prayer meeting chatter, Lori was like, so, my husband Charles is dark. He's possessed of evil spirits. I mean, what exactly does that mean? I would have had questions. I would have questions. I would be like, you mean like he don't load the dishwasher right and he don't put the toilet seat down? Like, what kind of evil spirits are we talking about? I need to know more about the evil spirits, right? And so she's like, so I'm going to need all y'all to help me cast out the evil. What? Listen. I don't know how you do with your friends, but let me tell you something. If you got the devil in you, that's between you and the devil. I don't want no parts of it. I'm not casting nothing out. I'm not calling nothing in. I'm not casting out the devil. And let me tell you something. If you got the devil in you or your husband got the devil in you, how do I know that the devil didn't jump from him and onto you? You're not bringing the devil to my house. I'm not shaking your hand. I'm not giving you a hug. I'm not saluting you with the holy kiss. How do I know the devil is not catching? What you're not going to do is devilation up my house and my children and my pets and stuff. No, the heck you not. So if you got the devil, you and the devil can stay over there. Leave me out of it. That is just a public service announcement from me to you. We're not messing with the devil over here. P.S. I don't even believe in the devil, but if you say you got the devil, child, I'm going to believe you got the devil and I'm going to need you to leave me alone. Anyway, but this Christina was real nicer. She was way nicer than me. Like, we're going to pray that the devil gets out of him. run, Christina, run. Anyway, so she was just like, okay. And so they were speaking and chitty chatting. And then Lori overtalked herself. See, also her act right was not fully installed. She was just like, I've been crushing up JJ's pills and putting them in Charles's shake because, I guess the poison calms down the devil. I don't know how that works. And Christina was like, oh, that's nice. Listen, hey girl, hey, can I speak to you privately? Can I speak to you in another room? Listen, if this man ends up dead, I'm telling the bishop, I'm telling the police, I'm calling the FBI, I'm telling every single body. You think I'm crazy like you crazy? I thought you was a better than you Mormon. Clearly you're a zombie Mormon. I'm a nice funeral potato lady. I'm telling. And so Lori was like, I was just kidding. Oh my goodness. It was a joke. It was a joke. Gaslighting much, y'all. So Miss Christina now is like, I don't know about these heifers. They over here trying to get me to catch the devil. We casting stuff out. Okay. I mean, prayer is lovely. Clearly that heifer need more prayer than the rest of us. But okay, we gonna see how this goes. And then Lori continued to open her mouth and spew crazy nonsense, including, but not limited to, she was talking to the circle of ladies, and she was just like, this is Lori, according to the testimony of Christina Atwood. I've known all of you in prior lives. Nope. No. Girl, you got the devil. I don't want to know you in this life. I certainly don't want to know you in prior life. But clearly some of these ladies were like, oh, prior lives, you say. Tell me more. These are the same heifers that was also excited for the end time. I'm talking to you, Melanie Gibb. Miss, we were excited for the end time. For what? Y'all gonna have to sleep in tents and stuff? No, if the end time comes, I need to be at the Four Seasons. I can't be fire festivaling it up in the end times. Sleeping in a white tent, eating beans, you cooking over a camp stove? No. Take me in the first round. Let me die. Let me go. No, I am not gonna be in no end times in a tent. The low threat camera, I can't. Anyway, sorry, I went off on a little bit tangent. I just dried my throat out. So Lori was also telling folks, I'm a translated being. Does that mean you're bilingual? You're a polyglot? Do you also speak like French and Spanish? Wait, translated being. In as it relates to the church, in the context of LDS, you being a translated being means that you like a god or goddess or something like that. Okay. Christina was like, where is my handbag? I know my handbag is here someplace. The chick got the devil in her. She said she knew me in another life. She casting out. Nope. It was so nice to see y'all. Thank you so much. No, I don't want no sandwiches or cookies to take home. No. They might have the devil in them too. I would have been out. And then Lori finally hit Miss Christina with the coup de grace. Oh, I no longer need to repent for all this crazy. You just called me here for a prayer circle and a sandwich, and you're going to talk about the devil poisoning people, killing people you translated, and now you don't need to repent of your sins? Girl, I think you got the devil in you. Your brain is clearly all the way gone, y'all. And so I was like, this was such excellent testimony. I'm dying to hear what Lori has to say. And Lori Vallow Daybell opened her stupid mouth and said, no questions, Your Honor. None, not any. Can the jury ask questions? I have questions. Girl, what you think when she started talking about the devil? Y'all, I am living for this trial. Living for it. Okay, look. There's going to be more testimony today. I will be there. I will be perched. I will be watching. I will also be watching Miss Gigi over there at the Pretty Lies and the Alibis. Listen, every single night, Miss Gigi from Pretty Lies and Alibis does like a 30-minute breakdown with all kinds of facts and stuff. You are not here for facts. You are here for gossip, rumor, and innuendo. And that's what I give you. I will see you tomorrow. Bye.
Ow. Sorry, just that went into my ears. Seeking Justice, thank you very much for becoming a member. Hello, welcome to the Green Gang. I hope you enjoy it. There's a lot of videos in behind the scenes. Hope you enjoy it. Oh, Kathy is amazing. We love it. We absolutely love her, and we are just rewatching the videos that she has made so far from Laurie Daybell. So we are just rewatching it again. Guys, please just make sure, I need to grab the link again, that you check out their Discord server of Seeking Justice. There are a bunch of great people that have something that I haven't seen it, which I was obviously deep diving into it the other day. They have like the law of some states, like a lot of information, a lot of links, so there is a great info there. So I'm just copying the link and posting. There you go. No, who went on break? Pickles. Where is it? Where's the comment? Nah, there we go. No. Dumbbell. Okay, we can call her Dumbbell, Dingbell, whatever it is, but definitely It is amazing. Oh, I know it is Friday. I don't know if we're gonna get a verdict today. Um, I mean, it was a long case, so I don't I like I appreciate you. I appreciate you. Um, so we still on verdict watch, pickles. They are not on break. They normally don't go on break while on verdict watch. They just carry on deliberating through lunch, or if they go to lunch, we won't know. We'll know when they break for the day. There's a jury question or a verdict. So I guess we're gonna be here until they have something going on, until either they dismissed or something is happening. So you get to put up with me a little bit longer. So um yeah, so now we're gonna go to the third part and, well, final part so far of the Kathy's videos about Lori Dingbell Dumbbell person. Oh, sorry, I keep seeing people walking in court and that keeps scaring me, but I won't go there. Oh, thank you very much, Pickles. Really, really appreciate you that. I really appreciate that. I really appreciate you. And I appreciate every single support that you guys give me. It's incredible. You guys are amazing. I still want to see that Nikita Kasap hearing. I did a video on it this morning, actually, with Zio about the criminal complaint about that case. And but there is a hearing that I was watching, but the quality wasn't good, that I did not want to do a video on it. But we can do a stream on it, because we can pause and watch it. So I think maybe after having a little bit of a laugh with Kathy, that's what we're gonna be doing while we're still on verdict watch. So yeah, so let's. Oh, sorry, I moved my mouse and something moved. So let's crack on. And yeah. Oh, I am gonna put. Yeah, that should be fine. Oh, that's good, Iowa. Oh my days, that is so good. Yes. Ooh, we keep you on our thoughts for sure, friend. Please. Oh, fingers crossed. Fingers crossed. Good vibes only. Let's listen to Kathy for good vibes.
How y'all doing? There is a lot of ground to cover today. This Lori.
Oh, hang on. She's going way too fast. I need to. That was only on 1.25. Let's put Kathy on on normal speed, because
That little
otherwise.
Daybell case is fire. It is fire. Okay, but first, you know what you need to do. Please like this video and subscribe to the channel. That helps other people find us. Also, find me on social media, Instagram, Facebook, and Blue Sky. And look, in case you didn't know, we playing Lori Vallow Daybell Bingo over here. I have official Lori Vallow Daybell Bingo cards, and how to play bingo. All those links are in the description box of this video. Let's go. Let's talk about what happened in court yesterday. Adam Cox is Lori Vallow's brother, right? He's 56 years old. He's a nice Mormon man. Professionally, the prosecutor was like, okay, so what do you do for a living? And he's like, I'm a professional pickleball player. We could have stopped right there. I had so many questions. There's a professional pickleball circuit? I have so many questions, but we gonna leave it be. But Adam, can you come and talk to us about pickleball? I don't know nothing about no pickleball. I thought that was that game old people play. Anyway, he's also a coach. So, excuse me. He was just like, so Lori's my sister, and she was a little bit ticklish of the brain, and I was real worried about her. And the state was like, okay, so can you give us an example of some of the things that made you worried? And he was just like, she said she was married to Moroni. Say what now? Look, I know our LDS friends know exactly who that is, and people who have followed this case, they're like, oh, Moroni, I know Moroni. Non-LDS people, lean in. Let me put you up on game. Moroni is like the angel in the Book of Mormon, right? Now, look, I'm not Mormon. I don't know all like the little details and stuff, so I'm just giving you the broad strokes, right? So basically, Lori was out here in these streets telling people that she was married to like the king of the Mormons, right? Moroni, the angel, who's not a real person. And so her brother was like, say what, girl? He was like, heifer what? And so she was just like, I'm married to the angel Moroni, and I have more authority than other people. Also, Jesus is my secret boyfriend. She had a lot of real crazy ideas. So Adam was like, Mama, did you hear what this crazy heifer's saying? And the mother was like, she's just delusional. What? I mean, look, maybe everybody has like the alcoholic uncle, the crazy aunt that they keep in the back room. Only she was in the front room telling people this. No, this is not how this is supposed to go. But her mom and them was like, she's just a skosh crazy, but isn't she cute? Did you see her cute bouncy blonde hair? I'm sure everything is gonna be fine. And so Adam was like, this is craziness. So he's like, boop, 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 boop. Hey Charles, Lori's husband, did you know she out here saying she married to Moroni? He was like, oh my God. I was waiting for somebody in the family to recognize that she was crazy. Please know, this is not the news. You do not come to a channel called Gossip, Rumor, and Innuendo for the news. For that, you go to Reuters or to Pretty Lies and Alibis, the East Idaho News with that cute little Nate Eaton over there. I'm telling you my sense of what happened in court. That's the only disclaimer you're going to get, so govern yourselves accordingly. So anyway, Charles is like, boy, you have no idea she's crazy. Crazy. So what we're going to do is we're going to take away her temple recommend. Non-Mormons, the temple recommend is like a little piece of paper that you get, that your bishop, like the main preacher, gives you. It's like, you can go on down to the temple and baptize dead people. I don't have time to explain all that. You're going to have to Google that part. Anyway, so she was going down there every day and she was doing like temple work and getting married to Moroni, furthering their deep connection. I don't know what she was doing in the temple, but it was scary. But most people go like periodically and from time to time, and she was going every day. And Charles is like, this is what we're going to do. We're going to take away her temple recommend. We're going to have the bishop withdraw her temple recommend. Then she can't go down to the temple as often, and maybe the crazy will go away. And so Adam and Charles was like, this sounds like a good plan. This sounds like a plan that two men would come up with who don't know what's what. I don't think the temple recommend removal is going to affect the ticklishness of her brain, but okay. And so they was making a plan, and Adam came to town, and Charles was like, okay, I'm going to be in town. We're going to meet. I'm going to go pick up JJ. It's going to be great. And then we're going to record her being crazy and show it to the bishop. And they're going to say she can't go to the temple no more. And then she's going to be magically healed. This was a really stupid plan to start with. But okay. So then all of a sudden, Charles drops off the radar. And Adam was like, wait. Hello, it's ringing through. It's going to voicemail. I don't know what's happening. And so the next day, Adam is talking to his friend, and he was like, I don't know what happened to Charles. And so they got to Google it, and they was like, wait. Charles is over at the Endless Heaven buffet. He's no longer on this mortal coil. Oh my God. My brother Alex has pew-pewed him up, and he has unfortunately unalived my brother-in-law. Oh my goodness, this is crazy. I know Lori had something to do with it. I knew her brain was ticklish in all the wrong ways. This is terrible. And so that is what the state brought out from Adam on the stand, according to me. Anyway, so then Lori gets up and she's going to give her cross-examination. And I'm like, oh, here we go. Because you know this heifer is still super duper crazy, right? She was crazy like 8 years ago when she conspired to have her husband unalived. Now she's real crazy. So she stands up there. Her hair was all in nice ringlet curls. I was like, oh, look, she did her hair. She's still an evil trollop, but okay, whatever. So she was just like, hello, Mr. Cox. And I was like, why she make it sound like it's an insult? That's the man's name. But okay, please hold, child. You know I done talk my throat dry. She's like, when was the last time you saw me? And he was just like, I don't know. It's been a while. I'm not sure. She's like, you didn't go to my son's wedding? And I was like, heifer, I'm going to need you to focus. That's not what we're here for. And he was just like, no, I didn't go. And she was just like, do you remember the last family gathering we were at? And he was like, I don't remember. She's like, was it at the house where my son's wedding was held? And I was like, can I object here from my house? Ma'am, I'm going to need you to make a point here. I see you circling around a point, but please land on a point at some point. And Adam was like, I guess I saw you at the house where Colby got married. And she's like, were we having my famous green chicken chili enchiladas? And I was like, So now we just talking about food. We just out here in a court of law talking about your probably nasty food. Probably gave the whole family diarrhea. Girl, you don't look like you can cook. First of all, you too skinny. The way I could go off on this crazy murderess's cooking skills. Y'all, don't get me started. You know how much I love food. It is very sacred to me. So anyway, he was like, no, I don't remember them. Let me tell you something. I can guarantee you right now, Lori Vallow is more insulted by the fact that her brother did not remember her famous nasty dish than she was at the death of her husband. She was like, oh, I never heifer. Anyway, so, she was like, you remember, I always made them. I know that was my world famous dish. And he was like, I don't recall. That was a sick burn. You know, she was like, in her cell last night, she was like, no, he remembers my enchiladas. I'm about to write a strongly worded letter to the judge. And so, I was just like, this thick creamy soup, this bisque is crazy. And so, Lori was like, okay. Did you see with your eyes or hear with your ears or witness me making a conspiracy to unfortunately unalive my husband? I can't believe you don't remember my chicken chili enchiladas. And he was just like, no. And she was just like, good day, sir. I said good day, sir. And I was like, this heifer is crazy. I could not love it more. Now listen, this is a terrible and tragic case. It's awful. But when seen through the lens of what the crazy gossip lady saw, yo, this trial is fire. Then I was like, okay, Serena Sharp is called to the stand by the state. And I was like, who's she? Is she one of Lori's little acolytes, one of these little fangirls who was just like, oh, I'm friends with Lori Vallow Daybell, ma'am. Okay. So Serena Sharp comes up on the stand. She's cute. She's blonde. She's pretty. How come Lori ain't have no ugly friends? I'm asking for myself. I'm just like, okay. She's like, I'm from Connecticut and I was a big fan of the end times. What is the deal with these people and the end times? I'm telling you, in their minds, right? The end of the world is going to come. You're going to have to camp. You're going to have to sleep in a tent. And they like stockpiling beans and other canned goods. Ew! Everything about that sounds nasty. If the end times does not have room service and high thread count sheets, I don't want to go. Cast me into the lake of fire. I don't want no part to no end times that includes camping. I bet you I'm not. You can't have an end times at a Marriott? I have points. Do my points count for anything in the end times? No? Okay. Send me straight to wherever you go if you don't make the end times right. I don't want the end times. Anyway, sorry. I get so distracted. So hang on. So Serena comes to town. And she was just like, I was friendly with these ladies. And this one lady, Melanie Gibb. We know from previous trials that Melanie Gibb is garbage, but child, we don't have that kind of free time today. Otherwise, I would explain it all to you. Anyway, so she's like, my friend Melanie Gibb was picking me up at the airport and she had said I could stay at her house. But then after she picked me up, she was like, oh, my house is really full. So you're going to stay in my other friend's house. Lori, a bunch of people are staying over there. You know what I'm not going to do? Number one, I personally do not enjoy a house guest. That's just me. I don't enjoy a house guest. I don't enjoy having house guests. I don't enjoy being a house guest. I mean, you could come to my house for like under 3 days and it's a maybe, but you say I can sleep at your house. Okay, great. And then I get to town with my little suitcase in tow. I'm ready to go. And you're like, you're not going to stay with me. You're going to stay someplace else. No. Where is the Ramada? Drop me off. I am a Marriott Rewards member. I'm telling you right. That would have pissed me off. I would have just turned around and went right back in the airport. I'm telling you right now. But you know, I'm a little precious like that, so don't go by me. Anyway, so she was just like, you're going to be staying with my friend Lori. She's quite lovely. She's a fan of the end times too. She's very much looking forward to camping. Ew. And so this little Serena goes over and she's just like, oh, hey, ladies. Oh, everybody in here is pretty. Why is there a thumb standing in the great room? I don't understand why it's a thumb standing over there, but okay, whatever. So Serena meets Lori and Chad. And everything goes well. They find out all the latest beans and all the ways you can like soak them and cook them in tents over camping stoves. Anyway, So then that went so well, which I can't imagine that it did, but according to them, it went really, really well. And so Serena gets invited to a girls' weekend, and she's like, "This is great. We could go and pretend to be homeless again. This is going to be terrific." Okay, so all the girls, all like the end time fangirls, they all get together and they're going to talk about like the best ways to skin a deer. I don't know what you do with these little gatherings. Anyway, so they're like, "We're having a girls' weekend and we're hanging out and we're having a lovely time." And then I noticed that Lori, the real pretty one with the curly hair, oh, she's bouncy. Everybody loves her. She had some odd beliefs. And the state was like, "Really, girl?" I'm summarizing. The state was like, "Really, girl? What kind of odd beliefs did she have?" And she was just like, She was telling us all that we no longer had to repent anymore. And Serena was like, "I might be crazy and super duper into the end times," but I was like, "Oh, I don't think that's right. I don't think that's what my minister said." And then Lori was like, "Yeah, we're gonna also cast out some evil." What? This group would not be for me. They into a whole lot of things that I just cannot wrap my mind around. We're going to cast out evil, you say. If you got evil in you, don't touch me. I'm not eating your food. I don't want to know about it. That's between you and the devil. Leave me out of it. Why I got to cast out your evil? Cast out your own evil. I would not blend with these people. I just would not. Anyway, so she gets up there and tells
1 second, guys. Very, very, very quickly. Apparently, there's a verdict in the Monica Sementali case. I know we have not been following it, but that case has been crazy, and it's a verdict. I always like a verdict. Do you guys want to watch it? I want to watch it. Oh, hang on. The James Cromley is going to come back also in 10 minutes. So hang on. Let me try to go to the Sementali case first. Cromley's coming back in 10 minutes. Oh my days, there's a lot going on right now. And our case, still nothing. I need to go to Sementali. Where's Sementali? There we go. Apparently there was one, so I'm just looking. Yes, let's watch. Okay. Hang on, because Katya Ruson just texted. It looks like we have a verdict on the Sementali case, so I'm just double checking that it's still going. I still have the feed for the trial, so don't worry, we are on it. Yeah, the verdict clock has finished. So sorry, Kathy, we'll come back to you. Don't worry. Here you go. Yeah. No, Denise, it's verdict for Sementali, not for our. Yeah, sorry. This is a case we have not been following, but it's been going along longer. But hey, Emily, for sure. Hi. I know. I'm so sorry, Jid. I'm so sorry. I know. Sometimes it does get a little bit hard, and especially with everything that we cover here, definitely gets heavy and everything, and it's absolutely crazy. And yes, we always need to laugh. Absolutely fantastic. We do need a laugh and a decompress and everything. But I hope that we were able to help out a little bit, and I am sending you the biggest hug and support ever. So hi, Emily, welcome back, my friend. It's great to have you back. You come back just right on time for Sementali. So then after this, we're gonna go back to James Crumbley because is back on court in 10 minutes. So we'll finish James Crumbley, and then eventually we'll finish Kathy, and hopefully by that time we'll have our verdict. Oh my days, it's not crazy at all. So but don't worry, I still have the thing here, the feed for our yeah. So yeah. So on the phone, so we can watch that together. There's still no movement. Apparently, it looks like they have deliberated for 8 hours and 45 minutes and 31 seconds. So this case has been wild because he's been gone for like what? It was like 41 days of this trial. Closings were of the prosecution was like 4 days. It's just been one of the wild cases I have seen in a long time. Yeah. Oh yeah, no worries. It's absolutely fine. That's what we're watching right now, William, is that there's a verdict on a Monica Semenchal, even though we did not um we watched it or anything. It's a verdict. I always like a verdict. Verdict is one of those things that I will not ever pass on. Definitely. So that's what we're waiting on. And they were as well on a half an hour delay. uh so yeah, this court is wild. This court, I've been keeping tabs on this trial for sure. Even though we've not covered, I still keep tabs on other trials, and I like to watch the verdicts as long as we can. Obviously, if we were in the middle of a trial, I would not stop, you guys know that, but we are on ourselves on a verdict watch for another case, so definitely we're going to be watching that. So yeah, so we like, should I play the music? Oh, no, that would be mean because it's not our trial, right? That would be mean because that would be meaning like people that are lurking and stuff that would think that it would be a verdict for our case, and that would not be nice. Probably not. I don't want to play with people's emotions, and that is not right. Um, so I'm still checking in just to see if our case has gone. Oh, Garden Bot just got home again. He forgot to do a job. We had to go back out and do it, but now he's back in, I think, hopefully for good, and so he can rest a bit and just chill on his Friday evening while I'm still hanging out with you guys. So I don't know, Linda Stermer case, I think they're still gonna be on verdict on deliberation for Monday, because you guys know my theory. My theory is an hour per day plus a little bit extra to do paperwork and everything. There was 9 days, well, 8 days of trial. So I would assume about 8 hours of um 8 hours of deliberation plus like one or two, like about 9 hours. I will tell them. I'll tell them. Case one, garden bot. Case one is saying that she can go and plant his flowers if you want to. He was like laughing and saying, "You'll get on it." Eventually. No, I feel bad. He's been so busy. When gardening season starts over here in the UK, it's absolutely madness. He gets so busy that it's incredible. He goes from, the winter not having any work, or like barely having any work, to being slammed and having everyone and everything to do, which it's absolutely crazy. So he definitely, yeah, deserves a relaxed evening, with just doing nothing and doing just the bare minimum. I was hoping we would have had a verdict early on this trial, um so I could have a little bit of a day off. But it's okay, because if we have a verdict today, that means that on Monday we have a late start in the day for verdict watch. So yeah, but well, we'll see what happens, because yeah, being self-employed, I think that's everywhere. It's hard. That's why one of the things that, not now, obviously, when if the channel grows, I don't think I'm always going to do this 100% full time, because the scariness of self-employment and just gives my anxiety a run for his money, for sure. It's feast or famine, yes. There is no in between, indeed, case one. I absolutely agree. It's either feast or famine, indeed, my friend. So, and that, like, the insecurity of that just scares me. I know there's probably always going to be trials, but it's just, I don't know. I think it is scary for me, being self-employed and just having to rely on that it is very, very scary to me, and my anxiety would have a feast with that. But then again, on the other side, I don't think I can do both at the same time for much longer. I'm not I'm, I'm not getting young, and so Oh yes, indeed. I sometimes like with garden bot when it is the winter is very very scary. We don't know how sometimes we're gonna survive the winter, um, and then obviously all the things happen during winter, car accidents, insurance, having to get a new car and everything because someone run over to a pole, or something. So yes, definitely, indeed, is very very uh yeah, crazy. So yeah, but like I was saying, I don't know if I can see myself doing both at the same time, because it is a lot, it is a lot draining and um hard at times, like with the time differences and everything. It's like especially with Laurie Vallow's trial, I think that one has been the hardest because of the craziness time difference. um but I don't know. I mean, there's always a possibility of me only working 2 days at the supermarket um and then do the rest of the time this, because then that would mean only having to go to bed rather early or something one day. um so that could work, but it's just not something right now possible. I don't know, I'm just talking, guys. Literally, I'm just talking out of my of the things while we wait on the verdict, because to be fair, I don't know what is the I know we are not in a time difference, but I don't know how long we have to wait for that to come. So let me have a look if, to see if there's like if there's a verdict, like if we're waiting half an hour, 30 minutes. Does anyone knows that has been following this trial, like how long is the time that we're gonna have to wait? So yes, indeed, justice for Fabio is the victim. That I know. See, I do know some things about this case. And I know her co-defendant um was on a stand. I know that. I know bits and pieces of this case. I'm not fully educated on it. I know about all the spiciness because I live on Twitter or X or whatever you want to call it. And yeah, sometimes I have free time. So yeah, that's Fabio Sementelli. The Is this Sementelli, William? His name, I think it's Cementelli, his name. So that, yeah, I think it should be about half an hour. I don't know. Um, England. What I can do is, where is? I need a third phone. I need a phone. I have so many devices near me. It is incredible, and how this is. So what I'm gonna do is on the business phone of GardenBot, I'm gonna put um yeah. So okay, I have. Oh, oof, that sounds harsh. Sorry, I'm just saying that there's a sentencing on the same feed we were watching the James crumbling. There is also uh a sentencing afterwards on that. So that is crazy. Sorry, this is what I say. I need more devices so I definitely can be able to do everything. But it's just hilarious. It's not having too much time. I just have too many devices available. My Okay, as like I don't know if someone can just check it out. How long would it be of the difference or anything? Because otherwise, I was just gonna say we would carry on watching Kathy until the verdict would actually start. Because I don't know how long it's gonna take until actually comes along. Um, and Yes, Cemetery's neck inline crime chat is going crazy. I can imagine. I can imagine that the chat is going crazy. I mean, after what, 4,500,000 days, they're finally finishing the case. Actually, we can kind of take a peek, can't we? Um, Yeah, there's the there. It's my days. It's crazy. What do you think, William? Um, ugh, why is not going up? Hello, computer. Good morning. It's time to wake up. There we go. Um, so, actually, William, you probably like. What do you think? Is she guilty? Not guilty? What do you think, friend? Oh, they've gone live. All right. Um, I didn't follow so many guys. Oh yeah, I don't know either as well. In you know, I just know that it's a very popular case and it's a verdict and we can watch. So I just thought we'd jump on because we are gonna after this we're gonna jump back to Detroit, to Michigan, and then to watch the rest of the James Cromley hearing, and then back to Kathy. So of Linda Stermer. I can try to see if I can find it, but yeah, I can try to find it. Oh, just got the second person in the area. Oh no, definitely will keep them in your thoughts. Yes, if there. Iowa is a verdict for Monica Sementelli, not for Linda. Sorry. Um, this is for Sementelli. Sorry, I need to put that this is the verdict for Sementelli, not our case. I don't want to confuse people. Guilty's okay. All right. I don't know. I did not hear enough of this case to like form an opinion or anything. So absolutely don't know. But yeah. Interesting. Definitely need more information in this case before. But anyway, we'll just see. Because I think she's still in custody, isn't it, William? Or she's out on bond. Do you know, friend? Probably I should I could have just bring a case a brief from somewhere and we could read Cementilli. There you go. Let's so let's have a look if we can find a brief information on this case. All right. So from Court TV, let's read that. I don't know either. Oh, she's in jail. Thank you very much, case one. Appreciate it. So Monica Cementilli, 52, is charged with unaliving and conspiracy. Oh, hang on. I think she's coming. But very quickly. Yeah, no, that's what I'm trying to do. So, with an aliving and conspiracy in the death of 49-year-old Fabio Cementelli, prosecutors say that Monica and her lover, 60-year-old Robert Baker, which testified, unalived Fabio to continue their affair and cash in a life insurance policy worth $1.6 million. Fabio was found pocked stabbed to unaliving at their Woodland Hills home on January 23rd, 2017. It was initially believed to be a home invasion robbery gone wrong, reported the LA Angels Times. Monica and Baker were arrested 6 months later after investigators uncovered their affair. DNA evidence at the crime scene also connected Baker to the unaliving. Baker pleaded no contest to the charges against him. He accepted a sentence of life in prison without possibility of parole. In October, a third person was arrested in the unaliving plot. Christopher Austin was extradited from Washington state on charges of murder and conspiracy to commit unaliving. Ahead of jury selections in Monica's trials, prosecutor announced that Austin pled guilty to second-degree unaliving and the personal use of a pokey device in exchange for his truthful testimony against Monica. Austin faces 16 years to life in prison and his sentence is scheduled for May. Um, so Monica, through her attorneys, maintains a claim that she had no part in Fabio's unaliving. So that's basically the rundown of the Monica Cementelli case. Wow, she's in custody for like 8 years. Whoa, guilty on the well, yeah, Paula, that is the two options or hung. I mean, there's still that option of hung jury, but yeah. Um, yeah, so that is the case like overview of this case. Sounds like a good novel of opera. Yes, it does, doesn't it? um Yeah, I seeking justice. No doubt she is guilty. To be fair, she does sound guilty because I mean she kind of sounds a little bit like our friend Laurie in the Cuckoo Land. So, oh, I've seen her facial expressions. So GSD dog, definitely. The when in doubt, guilty. Because yes, when in doubt, definitely pick guilty. Absolutely, agree. I mean, it's like a whole like, oof. Yeah, exactly. I mean, who would not want 1.6 million? I would want, but I don't think I would. Pocketbook device garden, but for it. So, yeah. Oh, change it again. Well, kind of keeps us in our toes, definitely. So that is the overview on the case of Monica Sementelli. Is this Sementelli that am I saying correctly? Oh well, I think I am. Obviously this is not going to count for our tracking, absolutely. um yeah, exactly. Didn't the Robert Parker testify in favor of her, William? I think it was, wasn't it? Sorry, I'm putting you on spot. But yeah, I'm just wondering that. I think I saw that. I'm not 100% sure. I think I saw that. Or oh, Iowa. Well, sorry. Is that I had the same. So I don't know, but I'm glad that you are on your way home. Though it's very 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 good news, but hopefully all of it can be fixed together, fixed soon. Sorry. And oh, very happy that you guys are going home. Definitely need some rest and some treats for sure. um and oh my days, Iowa, I am so pleased that it's all great news. Definitely we needed that. Definitely we definitely needed that, and now we just need a guilty verdict on Monica and a guilty verdict on Linda. I forgot her name. I forgot Monica's charges was unaliving and conspiracy of unaliving, I think. Hang on, let me double check. 1 second. One second, guys. Sorry about that. So I think the let me check. She is charged with unaliving and conspiracy of unaliving. Yeah, thank you. Monica Sementelli. She is a case that's been going on for the last 500 million days. No, for the last 41 days, and out of California. And there is some spice. There's a lot of spiciness in this trial, going from faces from the defendant throughout the trial, from to stop at the openings of the prosecution that lasted 4 hours, and the closings of the prosecution lasted about 4 days, plus the defense, I think, was just a day or 2 days or something like that. The case was extremely long, and 41 days in total. Lots of craziness. And they just reached a verdict, and I thought we could jump on the bandwagon of, yeah, of watch it. So oh yeah, no, that's fine. That is absolutely fine. We are here to help you out and help everybody out and to explain exactly what we're doing, because you guys know that on a verdict watch, I like to jump around between hearings, parole hearings, and well, now apparently verdicts and Kathy's videos. So which is amazing. So yeah, I don't know how long it's gonna be, but they're gonna come back, because can you guys imagine, like, we are in the middle of the verdict, right? And they say, like, we the jury find the defendant, and then our trial comes with the verdict. That would be mean. or if they come with a verdict now, we would have to swap 2 hours now, and I've already pumped that so much, Monica, that I don't know what we do. That would be crazy. My days. But I think hours would still take some time to gather everyone in a courthouse. I was wondered, if a defendant is on verdict watch, what do you do? How do you prepare yourself for that? It must be a lot to just, it's literally deciding the rest of your life. It's a life decision, like you cannot run away, and it's not even made by you. So is just like, how can you prepare yourself to hear the news that literally is gonna shape the rest of your life? So I just wonder, what do they think during jury deliberations? Not that I'm gonna commit a crime and to know what they think, but it's just, I just wonder. And I, like, if I would interview a defendant, right, I think that would be one of the questions I would ask. What would you do or what do you do, or what you did to prepare yourself for the verdict? Because that can take a toll a lot. Sorry, I'm just like going very deep right now. What would you guys ask, for example, a defendant, if you could ask? Let's think. um so we know what no, I am not going to commit crime, so what a criminal thinks. Yeah, no, I'm not going to commit crimes, just so we know that. Can you imagine that? That would be hilarious. But I mean, who would you, if you had an opportunity, right, either guilty or not guilty, if you had an opportunity to interview a defendant, who would you do it? So, oh wow, today would have been her trial day 44. That's a that's a long trial. Ouch. My days. Thank you, Willa, for that information. I don't know who I would. I think my answer to that question would change from case to case. But definitely Laurie probably would be on my high list. I would love to interview Laurie, but probably she would brainwash me or something. Probably not her. But there's like, I think I would, in terms of guiltiness, not guilty. Definitely, I would interview either Colin Griffith or Nicole Rice, because we've had not guilties. We had Jason Levesque, but I don't want to interview that one. It's not very interesting. No, I don't want it. But I think I would definitely either Nicole Rice or Colin Griffith. Colin Griffith would be, if I could, move past the fact that he got not guilty. Nicole Rice, I'm just okay. So it's sad. I'm still very sad and upset about that one, but Colin, I'm still very hurt. If Alex, from the Lori Vallow, if he was, that is a good one. That is a really good one, Emily. Oh, here it comes, Monica. Here we come. That's Monica, guys. Everybody, that's Monica Samantelli, our defendant in the case. But that's a really good choice, Emily. I like that. Alex, yeah, that would be. That's a great choice. Oh, hang on. Is there audio? I don't think there's audio. No, there's no audio. Um, uh, guilty. Oh, we'll see. Hopefully, I mean, I'm nervous, and we didn't even spend 44 days covering her trial, or 43 days. So, of course, she looked. Well, if she didn't look concerned, that something would be wrong. For sure, I think case one would. I think something would be wrong if she did not look concerned. Unless you are Lori Vallow and you already know your fate anyway, that you're going to spend the rest of your life behind bars, no matter what. This girl at least only has this going on. She doesn't has. Oh, yeah, that's the thing. Oh yeah, I that is very good, actually, Emily. I also interview a bunch of school pupils. If I was assured they would tell the truth, just to get into their reason would fascinate me. Oh, and indeed, oh, Emily, talking about that, there is no. Have you seen I can't say the name. Oh, I can't say. Someone please help me. You know that Netflix show, the UK Netflix show that has been. She does look concerned. That Netflix show that everyone has been raving about. I know how to spell it. I'm gonna spell it. I think that's how you spell it. The Netflix show. That it's a UK Netflix show. It's very good. Apparently, it's short as
We are on the record here as a cemetery. The defendant is present, all counsel present, jury, and all are present. Good morning. Juror number 10, I understand the jury has reached verdicts. Is that correct?
That's correct.
Are the verdicts dated and signed?
Yes, sir.
Please hand all verdict forms to the judge. Thank you. This time, the clerk, please read the verdicts.
In the Superior Court of the State of California, County of Los Angeles, in Department 101, the people of the State of California versus Monica Cementelli, in case number BA 452-97502. We, the jury, in the above entitled action, find the defendant, Monica Cementelli, guilty of the crime of murder in violation of Penal Code Section 187A, a felony as charged in count 1 of the indictment. We further find the murder to be of the first degree. We further find the allegation that the murder of Fabio Cementelli was intentional and carried out by the defendant, Monica Cementelli, for financial gain within the meaning of Penal Code Section 190.2A1 to be true. We further find the allegation that the defendant, Monica Cementelli, intentionally killed the victim by means of lying in wait within the meaning of Penal Code Section 190.2A15 to be true. Dated April 11th, 2025, juror seat number 10, four-person. In the same case, title, and cause, we, the jury, in the above entitled action, find the defendant, Monica Cementelli, guilty of the crime of conspiracy to commit murder in violation of Penal Code Section 182A1, a felony as charged in count 2 of the indictment. Dated April 11th, 2025, juror number 10, four-person. Ladies and gentlemen of the jury, are these your verdicts? So say you one, so say you all.
Yes. Does the defense of the jury poll?
Yes, please, Your Honor.
Please poll the jury.
Ladies and gentlemen of the jury, as I call your seat number, please answer yes or no to the question. Juror in seat number 1, are these your verdicts?
Yes.
Juror in seat number 2?
Yes.
Juror in seat number 3?
Yes.
Juror in seat number 4?
Yes.
Juror in seat number 5?
Yes.
Juror in seat number 6?
Yes.
Juror in seat number 7?
Yes.
Juror in seat number 8?
Yes.
Juror in seat number 9?
Yes.
Juror in seat number 10?
Yes.
Juror in seat number 11?
Yes.
And juror in seat number 12.
Yes.
The jury has been polled. The verdicts are ordered recorded. Both sides waive reading of the verdicts as recorded by the people
Yes.
and the defense.
Yes.
Your service now comes to an end. A couple things I need to tell you. First is my thanks. You made a tremendous sacrifice. We've been together for a long time. You are the backbone of this democracy.
All right, so we don't really need to watch that part. We have not been following this, guys. Oh, is this the? Hang on, wait, sorry. Let's retract. Is the sentencing gonna happen now? Hang on, let's see.
And for that, you have my endearing thanks.
We'll see if the
Sealed.
sentencing. we'll see if the sentencing is happening now, because might as well stay here if it is.
It cannot be unsealed without an order by me, which I cannot do without notice to you. I hope your service before me wasn't too unpleasant, because I'm going to see you again soon. You're now discharged. The jury assembly to sign out. Thank you so much. Make room for the jury. The jury also now at the courtroom. Mr. Levine, when do you wish to have sentencing?
Could we request a date from the end of June?
Yes. What's a good date? Anything in June. I'm waiting for a good date.
Sorry. June 26th, Your Honor?
How's that with the people?
May I have a moment?
Sure.
Did you say the 26th, counsel?
Yes.
All right, so they're just talking now about the sentencing, which is not gonna happen today. So, yeah. Sorry, I keep looking on my phone because I can see heads on Linda's stream. Sorry about that. I keep looking that way. But yeah, that is actually quite awesome. We have a thing we like look at the seals and see what they say, and if it is in Latin, we kind of translate them. Oh yeah, I think she thought she was gonna go to Vegas and spend the 1.6 million. Hey, girl, you're going to prison for the rest of your life. Right. Okay. Now, so there's still nothing happening in Linda. Linda's still not happening. So let's go back to James Crumley, because they've been on. Oh, hang on. Let me just 1 second. One second. They haven't actually started on James Cromley. All right, okay. So let's finish Kathy then. Where's Kathy gone? We'll finish Kathy and then come back to James, because they are still not done. So let's laugh a little bit more now that we've watched that verdict, and see the rest of the video of Kathy. There she is.
Tells us about the casting out of the evil. Girl, you didn't run like your ass was on fire. I would have left so fast. This is why I'm not a group person, as you may have summarized by now. Anyway, so Lori gets up for the cross-examination, right? And she was just like, hello, Serena. I was like, this about to be fire. This gonna be so good. I didn't even know what she was gonna say, but I was like, this is gonna be good. Because she knows that she has a weak-minded weirdo up here. I mean, Serena, girl, you're real cute, but you gotta acknowledge you a little bit weird. Anyway, so she was just like, hello, Serena. When you came in here today, did you take an oath? Serena was obviously a little bit scared. And she was just like, yes, I took an oath. And Lori was like, did you promise to tell the truth? The whole truth? Oh, excuse me. And nothing but the truth? So help you who? And I was like, is she intimidated? And Serena was like, God. I was like, oh, here we go. Lori found somebody she could dominate. This is her favorite person. And I was just like, Okay, so she's like, so you understand that you're accountable to God. And Serena was like, yes. The state was like, objection, weirdness. And I was like, The judge was like, sustained. Okay, have to get to the point. Again, I'm summarizing. So she was just like, how many one-on-one conversations have you and I had? Serena cowering more on the witness stand. She's like, I don't know. So Lori's like, did I say zombies? And she was just like, yes. So Lori's like, you heard me say zombies? Now listen, this is why this question is important. In my opinion, I believe that Lori reserved the word zombies or Z's or however she referred to them for a very small select group of people and not the weak-minded idiots that was on the fringe of this group. No offense, Serena girl. We talking about you. This is not for you. I'm just, explaining to the people. Anyway, so I believe personally that Lori didn't say zombies a lot. She talked about zombies with her deep, deep inner circle. Since then, everybody knows about the zombies. So folks who were there, in my opinion, are like, I feel like I remember her saying something about it. Now, did Lori specifically say the word zombies? I'm willing to bet no, because she's crazy, but she's also very careful. So Lori was like, you heard me say zombies. And Lori was like, I don't, maybe. Lori's like, maybe you heard other people talking about zombies and you decided that I said it. And Serena was like, no, I feel like I heard you say it. You can see poor Miss Serena just kind of melting in the chair. And Lori went full devil and was just like, tell me the exact words I said. And I was like, oh, this is what I'm here for. The state was like, objection, wigging out. And the judge was like, sustained, maybe rephrase. I was like, Your Honor, can we just run that back? Never mind. I'm watching it on live stream. I could just run it back again and again and again, where Lori really, really freaks out. Those are my favorite parts of this trial. And she was just like, what exactly did I say? What sentence did I say? And the judge was like, Heifer asked and answered. You done asked this heifer this same question a million times. You see her over there. She has piddled in her pants already. Can we just back up? And I was just like, no, more please, more. And so Lori then goes, okay, I'll move along. Now it's time for the Bible quiz section. And I was like, ooh, a Bible quiz. I went to Sunday school and stuff. I know Bible things. I mean, I did skip out on vacation Bible school and went roller skating at United Skates of America. But that's another story for another day. So she was just like, who are the Nephites? And Serena was like, I don't know. I was like, oh, girl, no points for you. And then Lori was like, who was John the Revelator? Serena was like, he was a Bible dude. Again, not a quote. And Lori was just like, was he translated? I'm not. Okay. You may have guessed I'm not LDS. I don't know what that means. I'm like, did he speak in tongues? Did he know several languages? Was he a polyglot? What does that mean? Was he translated? I grew up in the church. Child, I never heard of nobody being translated. But I was like, okay. Serena was like, I mean, I don't know. And Lori was like, this is LDS doctrine. This is Christian doctrine. Aren't you a Christian? This state is like, objection, Bible quiz. And the judge is like, sustained. And then Lori was just like, okay, I'm going to let this sinner go. I mean, that's not exactly what she said. That's the spirit of what she said. And so then Serena wept softly and tried to cover the wet spot on her pants. And then she left the stand, right? And I was like, this trial is fire. Much like the way Lori Vallow Daybell gonna burn in hell for her evil actions. Anyway, so then the state called some phone dude, and the phone dude got up and it's like, we take phones, we download phones, we do stuff with phones, and then we can recover lost data from the phones. And I was like, okay, that's interesting. And then the jury had a question. Now listen, through Adam Cox, I don't recall there being any questions. Through Serena, I don't recall there being any questions. Now the boring phone dude gets up and somebody from the jury got questions. Okay, jury, what are y'all doing over there? But keep in mind, Lori Vallow Daybell was very intentional when she chose her jury. She chose mostly men and just a couple of women because she feels like she can charm the men. That's the gospel according to Kathy, honey. Anyway, So one of the jurors had a question, and he was like, hey, I have a question. So if you delete your browser history and it's all gone and you think nobody can see it ever and ever and ever, and it's been like 6 months, can it still be seen? And I was like, sir, that was oddly specific, and I'm really scared to know what's in your browser history. Okay, was you over there just like Googling big brown titties and your wife don't know about it? Excuse me, maybe I might have to like bleep that part out, but I'm asking for myself, sir, what is in your browser history? And the little professor, he was like, look, this is my chance. I can ask anonymously. Nobody gonna know. I just need to find out, do I need to just like get a new phone to throw my phone in the river, accidentally drop it in the toilet, something like that? Because you know what's not gonna happen. My wife not gonna divorce me over my browser history. And so the professional phone guy was like, we can still pull it up, you know, under most circumstances. 100% chance all them men went home and accidentally dropped their phones in the toilet last night. I'm telling you right now, court is out today. That's plenty of time for everybody on that jury to go and get new phones, mostly the men. Anyway, so then the fingerprint lady got up there and she was like, I couldn't find no good fingerprints. Okay, ma'am, thanks for coming. Bye-bye. I mean, it took her like a whole hour or whatever to say that. And I was like, okay, this trial, I'm now bored. I don't know what I'm going to do with the rest of my day. Should I start planning dinner? And I looked away and I looked back. And what did I see on the stand? None other than the gorgeous and amazing Kay Woodcock. Oh, I was like, oh, Kay girl, you are slaying today. You look amazing. The little gray streak in her hair. Now listen. These other heifers that got up on the stand was a little bit scared of Lori Vallow, especially that Serena. She was just like, oh, please don't hurt me. Kay Woodcock has no time for Lori Vallow's mess. If you don't know, Kay Woodcock is the reason that Lori Vallow is on death row, because it is Miss Kay Woodcock. When she could not find her son JJ, she was like, boop, 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 boop. Hello FBI, y'all gonna help me, and I'm not gonna get off the phone till you do. And so the FBI was like, oh, Kay Woodcock is on the phone, and they commenced to getting their behinds together and investigating all kinds of things, and uncovered an entire cartel of crime that was taking place at the hands of this crazy lady and her boyfriend that looked like a thumb, who was living up in northern Idaho. Wow. Let me tell you something right now. Miss Kay Woodcock is not to be messed with at all. She is a goddess. If you want to give your children a strong, powerful name, I'm telling you right now, you name them Kay. Okay, so now you know how I feel about Miss Kay Woodcock. And Miss Kay, I'm sending you a jar of cares, because you out. You don't have none. You ain't just lose them. She not fresh out. She been out. I got extra jars. So I'm going to send Miss Kay a jar of cares. Or maybe she don't need them, because Miss Kay Woodcock, in my opinion, is divine. Anyway. So Kay Woodcock takes the stand and she explains that she is Charles Vallow's sister. And she was close to Charles and they grew up together, and there's a bunch of kids in the family. Everything is wonderful. She from Lake Charles, Louisiana, and she has an adorable Louisiana accent. Please hold. You know I done talk my throat dry. Hang on. So she was just like, I'm over there down in Lake Charles getting my nails done to the nail salon. And then I get a call from one of my grandsons saying, wait, somebody told me daddy is dead. And so she's like, well, that cannot be right. Let me let my Google fingers do the walk. And then she Googles her brother's name. And she was just like, oh my God. And she was devastated, and she's crying on the stand. Well, if Miss Kay is crying, we all crying. The nation wept. I'm telling you right now, the nation weeps with Miss Kay. Right. And so she was just like, and Lori, that trollop over there, not a quote, but the spirit of what she said, she was like, that trollop over there didn't even tell us about the death. Ultimately, she contacted me when she found out that Charles had taken her name off as the beneficiary and just texted me a copy of the beneficiary change form that said 5 kids and no money. And Miss Kay let us know, heifer, you ain't even have 5 kids. Together, y'all have 5 kids. 3 of them were grown and 1 was almost grown. So what are you talking about? Miss Kay had no time for the BS. And so Lori Vallow gets up there to cross-examine her. I was like, I don't know how this gonna go. It's clear that Lori Vallow is not afraid of Jesus. She's not afraid of God. She's not afraid of the legal system. You know who she's afraid of? Kay Woodcock. And she should be. So when Lori stood up to go face to face with Kay Woodcock, the American Gladiator theme played in my head. And I would play it right here, but you know I'm not trying to get a copyright strike. Anyway, so she was just like, Miss Woodcock, were you there on the day of the incident? Wait, when Lori stood up, Kay was like, oh boy. You know, she was just like, if only I had my finger on that shock belt. She would have Lori flopping like a fish on the floor and the world would cheer. Anyway, so she was just like, Miss Woodcock, were you there on the day of the event? And Kay was like, no. She talked to this woman like the garbage that she is. And then she's like, did you know about the difficulties between Tylee and Charles? And Kay was like, she was a teenager. I knew there was trouble. I didn't want to get into it. And she was like, did you know what happened to Charles? Were you there on that day? And Kay was like, no, because you didn't tell me. You just sent me a raggedy ass text like weeks later or whatever. I was like, come through, Miss K. Come all the way through. And so then Lori was like, did you see me conspire? And I was like, oh, Lori not gonna ask a whole lot of questions because this is always Lori Vallow's last question. We see you, girl. And so I was like, Nikkei is a very smart lady and she knows she's been watching this testimony. She has to know that this is going to be the last question that Lori is going to ask her. And this is her chance to say what she wants to say. Kay Woodcock come through. I knew she would. So when Lori was like, did you see me conspire? Kay was like, no, but there was a mountain of evidence to prove that you did. Mic drop. Lori set her behind down. I was like, yes, Miss Kay, yes. And then when Kay got off the stand, I saw her hugging Colby and I wanted to hug her too. And I was like, will you be my grandma? Will you be my big sis? We too close in age for her to be my grandma, but I really, really, really want her to be my grandma. And then, the court, that was all they had for the day. And I was like, but wait. That's all? Can we have some more? Can Kay come back? Kay, we need you, Kay. Anyway, the way I wish Kay Woodcock was prosecuting this case. But anyway, this is what you need to know about Lori, though. She is really, really screwed herself in this because a real lawyer, Kay's extra statements and her extra information that she throws in, a real lawyer would have said objection. All that last part of the answer about there being a ton of evidence would have been stricken. But Lori's not smart enough to know to do that. And I was like, and I'm glad. Now look, last but certainly not least, y'all have been in my comments and y'all have had thoughts and feelings and you have shared them with me. First of all, this Saturday morning on whatever tomorrow is, the 12th, I'm doing a live stream that will also be an AMA. Ask me anything. Show up on my live stream. Ask me whatever you want to ask. I'll answer what I feel like answering because you know I'm not big on the rule following. Secondly, one crafty little Mormon got in my comments to let me know that I have missed a level of Mormonism. And I was like, let me stand corrected. To review. According to me, there are 3 levels of Mormons. That's the funeral potato Mormons. You know, the nice people, they're your friends and neighbors. They make the funeral potatoes. They go to temple. They have regular lives, just like me and you. Then there's the better than you Mormons. They looking down on you. Lori and all of her ilk, those are the better than you Mormons. They more Mormon-y than you. They know all the stuff. Okay, fine. Then there's the zombie level of Mormons that feel like they can unfortunately unalive people because Jesus told them it was okay. They're delusional and crazy, and hopefully most of them end up in jail, but okay, whatever, ain't none of my business. This crafty little Mormon got into my comments and she was like, you've left out a level. There's a level below funeral potato Mormons. She's like, we like lightly Mormon. She referred to them as Diet Coke Mormons. And I was like, oh, they drink Diet Coke. Listen, in my mind, they have like bikini cut sacred garments and they out at the club. They like Jesus and stuff, but they not obsessive about it. They may or may not go to church. They never go to temple. They trying to get a temple recommend, but they still believe all the stuff. You know, like if you a Christian and you only go on Christmas and Easter, you a diet Christian. So apparently there are also diet Mormons. Okay, diet Mormons, I see y'all and I'm going to add y'all to the chart. So the diet Mormons, the funeral potato, the better than you Mormons, everybody, we gonna gather here the next time the court is open, and I will see you soon. Bye.
That's, oh my days, that was hilarious. Hang on. There is why is there movements on a case while I'm trying to post a TikTok? Why? So yeah, so levels of Mormon according to Lois and according to Kathy. So is the drink Coke, funeral potato, and better than you and zombies. She is great. She is absolutely hilarious. I am gonna try definitely for sure be on the live tomorrow. It's at 1 p.m. for me, so I should be fine in terms of going. But I am keeping an eye on our trial, on our verdict. There's still no words. I might have to take a bit of a break. Oh no. Oh, case file, dude. Please don't miss verdict. I'm so sorry about that, my friend. Oh, that's hang on, I'm gonna grab her channel. Come on, I wanna. There we go. I'm gonna post Kathy's channel, and I'll post the link in the description. Go follow Kathy. Absolutely 100%, 1000% recommend her. She's amazing. She's absolutely amazing. Deserves a follow for sure. So yeah. Um Talking about James Crumbly. James Crumbly, they have not come back. I don't know. Uh they're talking a lot about other stuff that not really interesting me. But yeah, so we'll keep an eye on James Cromwell. If they come back, they come back. If they don't come back, they don't come back. So I hope you can get back, yeah, because for the verdict, but I will try to post it on the Discord channel thing that we have just for the chat and everything for the channel. So yeah, we will post that, and we'll try to post on Facebook as well, just to let people know that there's a verdict with the link for the stream. And yeah, so that was fun verdict. That was funny videos from Kathy. Absolutely. I'm just looking to see if there's anything on that we should be covering. The only thing in our trial, I'll show you what's happening right now for our trial. This is just the seal. Still nothing much going on. I don't know if there's a verdict. I don't know. If anyone knows if there's a verdict, let me know. That's the only thing that is happening right now is the seal. Nothing else is happening. So yeah, that's it. What we're gonna do is I need to figure out when is dinner gonna come, because when dinner comes, I think I'm gonna take a small little break. Stream's gonna carry on. We're still doing good time. But yeah, we are gonna. Ooh, sorry, I just saw something very. Oh, hang on, is that Menendez thing today? Huh? Lottery ticket to access. Is there a hearing for the Menendez today? Does anybody knows about that? I did not know. Because, that is crazy. Um, I don't know what Garden Bot is ordering. He's in charge of ordering food, so I don't know. Um, I cannot see. I can see you are on the app, but is it? Ooh, it's KFC. Ah! It's KFC. Sorry. Like KFC myself, like some chicken. Oh, I hope you can too. Otherwise I'm gonna try to record a short of the verdict and I post there, so you don't have to scroll through the whole feed again to find the thing. I love the gravy. I hope Garden Bot is hearing me right now and orders me some gravy because I like the gravy. I really like some KFC myself. I think I'm getting a little bit sicky of thingy of McDonald's at the moment, so definitely probably gonna have a bit of a break there. So I was trying to see if there was anything going on more interesting, but there isn't. So I'm gonna find the Nikita Casp hearing, and I will put that on. Kasap, sorry. I keep saying the name wrong, guys. I need to learn. So there's a hearing for this case that is happening out of Waukesha, Wisconsin, of Nikita Kasap, a 17-year-old that unalived both of his parents, his stepdad and his mom, in their home in their home in February of this year, and then he lived in the house for 2 weeks with the bodies, and then decided to pick up his things and leave to Wyoming. Drove. He took his stepdad's car to Wyoming. He did not have a driving license or a permit or anything, so he just decided to go. And then school gets involved because they haven't heard from him in 2 weeks, and he had a perfect attendance, so they thought it was very, very weird. So they decided to investigate into a welfare check on the residence, and when the police showed up, they discovered the bodies of the stepmom and stepdad and the mom. And then he got arrested in Kansas, I believe, and he got arrested on the charges of the car and of having a pew pew on him that he shouldn't have. uh, but then he got his charges upgraded for the unalivings of his parents. So there was a probable cause hearing a couple days ago, I think, to see if there was enough evidence, if it was enough things to go to trial, and that is what we're gonna watch and hear. All right, see you very soon, Paul. I still need to get that done. You keep reminding me of that every day. So I'm gonna play that, but I just wanted to make you guys aware of something. This feed that I have, there is available for this. It is not the greatest. Okay, you're gonna probably, if you are literally looking at the screen, you're gonna see that what they are saying doesn't match to the audio, which I know it sucks, but is the only thing that there is on it. So, but and it is long enough to give us a bit of time for, so I can have a bit of food. Well, the food is not here yet anyway, but I need to get some stuff done in the background, and yeah. So I think my day's trying to get that clock in the correct position is getting to me. And there we go. I think that's better. Right, let's get started on Nikita Kasap.
All right, court will call State of Wisconsin versus Nikita Kasap. This is 25 CF 598. The matter is tabbed to the Honorable Ralph Ramirez. May I have the appearances, please?
State by Leslie Basie and Brooke Schultz.
Nikita Kasap appears in person and in custody with attorneys Maura McMahon and Nicole Ostrowski. Good morning.
Good morning. The matter is scheduled here today for a preliminary hearing. State, are you ready to proceed?
We are.
And who is your first witness?
Stetzer Seitz.
All right. If you could please come up, remain standing, raise your right hand. My clerk will swear you in.
Do you swear that the testimony you're about to give in this matter before the court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do. Thank you, and put down your right hand, grab a seat. Please state your name for the record, spelling your last name, and letting us know how you're employed.
Ross Seitz, S-E-I-T-Z. I'm a detective with the Waukesha County Sheriff's Office.
All right, state your witness.
Sir, how long have you been in law enforcement?
About 14 years.
And how long have you been a detective?
About 9 years.
Direct your attention to February 28th, 2025, where you assigned a homicide investigation regarding suspect Nikita Kasap.
Yes,
Do you see Nikita Kasap in the courtroom today?
I do.
Can you point him out by where he is seated and what he is wearing?
You see at the defense table wearing a red jumpsuit.
Let the record reflect the witness has identified the defendant.
Any objection?
No subject to cross.
The record shall reflect the identification of the defendant by the witness. Go ahead, state.
Direct your attention to February 28th, 2025 at approximately 9:45 a.m., where deputies dispatched to a residence located at S38 W27056 Cider Hills Drive in the village of Waukesha, Waukesha County, Wisconsin.
Yes.
What was that with regard to?
Well-being or a welfare check at the residence.
And direct your attention to the victim identification key. Who all lived at that residence as of that time?
Victim A, Victim B, and the defendant.
And what was the defendant's relationship to Victim A and Victim B?
Victim A would have been the defendant's stepfather. Victim B would have been the defendant's biological mother.
State, can I just interrupt? And this has nothing to do with the testimony. We do have brother/sister-in-law of victim A in Zoom. I just want to make that record. And another person has joined us in the last few minutes. It just says Vic A 25 CF 598. I just want to make a record reflect that we're doing everything we can to comply with Marcy's law. And we have a couple of advocates in there. I apologize for interrupting. I just want to make that record, and that person just joined. This was set for 9:15. It's now 9:42. With that, please go right ahead.
Thank you. Do you know why the deputies were dispatched there for a well-being check? What information they received that caused that to happen?
Victim A's mother, who lives out of state, had not had contact with the family for a few weeks and requested law enforcement check on their well-being.
And did you have any information with regard to the school resource or from the school resource officer at Waukesha West High School with regarding the defendant's attendance at school?
Yes, the last date of attendance according to school was February 11th of 25.
Did deputies end up going into the residence to do that welfare check?
Yes.
Upon entering the residence, what, if anything, did they observe?
They observed the deceased body of what was later identified as victim B laying in the hallway just adjacent to the garage.
And did they exit the residence in order to obtain a search warrant?
Yes.
And was that search warrant obtained?
Yes.
Directing your attention to approximately 1:52 p.m., did the Sheriff's Department then re-enter the residence to do a search of the residence?
I believe it was closer to 5 p.m. when they got the warrant.
Sorry. So at approximately 5 p.m., did they do that?
Yes.
And what, if anything, were you there at that time?
Yes.
And when you entered the residence, what observations did you make?
The things had been emptied from drawers and closets. Things were all over the floor. Victim B body was appeared to have been deceased for some time. Was unable to definitively identify who it was. Continued walking through the residence. Again, things were strewn about everywhere, and we located a mound of blankets and pillows in the first floor office that was later found to conceal victim A.
And when deputies first made contact with victim B's body, was it concealed?
Yes, there was a blanket and towels, I believe, covering the body.
Thank you. Did you make observation of what victim B was wearing at that time?
A close to full-length maroon winter jacket, a red sweater, black pants, and I believe black socks.
And you indicated that the second body that was located was subsequently identified?
Subsequently later identified as, victim A, yes.
Thank you. Did an attempt to locate, or did you have any information at that time with regard to the defendant's whereabouts?
At that time, we had obtained emergency pings on the defendant and victim A's phones, which had showed it was possibly in Wyoming at that time.
And based upon that information, did you know if the defendant was in danger?
We did not know.
Was an attempt to locate put out for?
Yes. Yes, for the defendant and the vehicle that was missing from the residence.
So there was victim A and victim B. Did each of them have a car registered in their name?
Yes, victim A had a Volkswagen Atlas. Victim B had a black BMW sedan.
And was either one of those vehicles at the residence?
Just the BMW belonging to victim B.
So you did put an attempt to locate for the Volkswagen?
Yes.
And while you're executing the search of the house, did you receive some data with regard to the defendant's cell phone in terms of the tracking of the cell phone to the location that it was last located at?
Object to leading.
Again, I'm directing the attention. There's a ton of downloads from the cell phone.
Overruled. I'll allow you to continue.
I'm sorry, can you repeat that?
Sure. Did you receive ongoing information with regard to the emergency ping on the defendant's cell phone?
Yeah, once we received the data from the provider, Detective Schrader was analyzing it, and we obtained information showing previous locations of the phone on the 24th in Walcott, Iowa, and I believe the 25th in Nebraska.
State, and the witness, you say "we" now and again. I heard you identify another individual that helped you. Could you, when you testify, when you say "we," could you please identify if it's just you or another person helping? So with that little caveat, please go right ahead.
And Detective Schrader was the individual who was monitoring the cell phone locations?
And analyzing the data that was provided to us, yes.
And did you have a location in the city of Walcott where the defendant's phone was, and I'm not asking you for the name of the location, but were you given a specific location within the city of Walcott, W-A-L-C-O-T-T, with regard to the location of the defendant's phone on February 24th, 2025, between 2:20 p.m. and 2:50 p.m.?
Yes, it was a truck stop or a gas station.
And were you, was Detective Marshall, M-A-R-S-H-A-L-L, able to obtain video of the defendant or victim A's vehicle at that location?
Yes, he obtained both of the defendant and the vehicle, as well as the defendant there with the family's dog.
And was anyone with the defendant in that video?
No, we did not observe anyone with the defendant.
Did the defendant seem to be under duress, or did he appear to be walking freely about that area?
He did not appear to be under duress. He had taken the dog for a short walk. I did not observe anything that would lead us to believe he was under duress.
And did you subsequently, was a warrant obtained for further location data of the defendant at a subsequent date?
For the phone records?
Yes.
Yes.
Okay. Now, going back to the residence, as the residence was being searched, did you locate a receipt indicating that victim A had purchased a Smith & Wesson .357 Magnum firearm?
Yes.
And during a search of the residence, was that firearm located?
No.
Were you able, from the receipt, to obtain a serial number of that firearm?
Yes.
Did you attend the autopsy of victim A and victim B?
Yes.
And during that autopsy, did you personally observe any evidence of either one being shot with a firearm?
Yes.
Could you briefly describe, with regard to victim A, what evidence you observed of that?
Victim A had what appeared to be a gunshot wound to the back of the head, where a bullet was eventually recovered from during the internal autopsy from his head. Victim B had what appeared to be 4 separate entry and exit wounds to the body, right wrist, neck, upper chest, and abdomen. No rounds were recovered.
Based upon the nature of the bodies, did it appear that either death had been on or about February 28th, 2025?
No.
Okay. And was Dr. Bidzricki able to obtain positive identification of both victim A and victim B based upon dental records?
Yes.
And did the medical examiner's office later issue a death certification summary with regard to the cause and manner of death of both victim A and victim B?
Yes.
And with regard to victim A, what was the cause of death?
Homicide due to gunshot wound to the head.
Okay, thank you. And with regard to victim B?
Homicide due to multiple gunshot wounds.
With regard to the location of victim B's body, were any projectiles located around the area that victim B's body was located within the residence?
Yes.
And where were those located?
One was located, lodged in the wall near the access door from the garage into that hallway. Another one was located in the floor around the location of victim B's body. And then a third was later recovered on a desk located near victim B's body.
Thank you. That night, February 28th, did you receive information from another law enforcement agency that in fact the defendant had been taken into custody?
Yes, the Waukene Police Department in Kansas.
And that's Wakeeeney?
I believe so, yes.
And was anyone in the car with the defendant?
Just the family dog.
Was the defendant the driver of the vehicle?
Yes.
And was it the same victim A's Volkswagen Atlas?
It was the Volkswagen Atlas, yes.
During a search, did officers, and let me withdraw that question, did the Walkeny Police Department search the vehicle that evening?
They did begin searching the vehicle that evening, yes.
Did you subsequently have that, or did the Waukesha County Sheriff's Department arrange to have that vehicle brought back to the Waukesha County Sheriff's Department?
Yes.
And was there a search pursuant to a search warrant of that vehicle?
Yes, on March 4th, I believe.
And what, if anything, with regard to money was located within the vehicle?
There was roughly $14,000 found in the vehicle. I believe 8 was possibly found in a Bible, 6 was in a iPad case, or I might have those two mixed up, might have been the other way around.
And were those in a consistent denomination, or were they in
$100 bills, yes.
Did Walkeny Police Department turn over any firearms to you?
Yes.
And what was that?
It was a Smith & Wesson Model 686 357 mag that was same serial number as what matched the receipt found at the residence.
And do you know where that was located within the vehicle?
The floorboard of the front passenger seat.
Do you know if they located any jewelry within the vehicle?
It was approximately 70 pieces of women's jewelry found in the vehicle.
Were you able to subsequently locate some receipts for approximately 6 of those items?
Yes.
And who were those purchased by?
Victim A.
And what was the value of the 6 items you were able to find a receipt for?
I think just over $14,000.
Was there also ammunition turned over?
Yes.
By Walkeny Police
Yes.
Department? Okay, I'm sorry. And can you describe that?
They recovered a box of 50 count of 357 Anguilla rounds. I believe 36 were ultimately turned over to us of that box, along with some 38 special ammunition as well.
And are the 357 Magnum ammunition, would that be consistent with the bullets located around victim B's body and located within victim A's skull?
I'm sorry. And I think I misspoke. I said 36. It was 46 rounds of 357 Anguilla. And I'm sorry, I didn't catch the last question.
Let me just strike that last question. So 46 cartridges, therefore there was 4 missing if it was a box of 50, I assume?
And 4 empty shell casings, yes, of the same kind.
Okay, so
which accounted for the 50, yes.
So 4 empty shell casings were found along with 46
357 Anguilla cartridges, yes.
And those are Aguila?
Yes.
It's a brand name, I take it?
Yeah. I don't know that I'm pronouncing it correctly.
And the 4 missing bullets that would go to the cartridges that were turned over to you, would those be consistent with the rounds that were located within victim A's skull and around victim B's body? I'm not saying that they're the
It's consistent with, we have 4 rounds recovered, 1 from the head of victim A, 3 around the body of victim B. At this point, those have been submitted for testing. I can't tell you that those are certainly the Anguilla 357 mag rounds.
Are they consistent?
I would say they're consistent, sure.
Thank you. Also, when the defendant was taken into custody on February 28, 2025, was he in possession of a wallet containing banking and financial cards associated with victim A and victim B?
No object to speculation.
Hearsay is allowable.
But
He didn't take him into custody, and the question was phrased as when he was taken into custody.
wish to rephrase, counsel?
Sure, that's fine. So when the defendant was taken into custody, he was taken into custody by the Walkeny Police Department?
Yes.
Did the Walkeny Police Department prepare reports indicating that they searched the defendant?
Yes.
Did they prepare reports indicating that they had searched the vehicle the defendant was driving?
Yes.
And based upon those reports, when the defendant was taken into custody, did he have possession of a wallet containing banking and financial cards associated with victim A and victim B?
Yes.
And specifically, was there a debit card from BMO Bank?
Yes.
And do you know what the last 4 numbers of that card were?
5341 possibly. Or 4231. There's 2 that are very similar.
Okay. So if the complaint Did the BMO bank have the last four numbers of 2431 and belonged to victim A? Would that be correct?
Yeah, yes.
And was there also a Citibank credit card with the last four numbers of 5341 that also was associated with victim A's account?
Yes.
And in your investigation, were you able to determine if those cards were used by the defendant?
Yes.
And can you describe for the court how you determined that?
The BMO bank records were used primarily, the BMO bank card was used primarily between February 24th and 28th at various gas stations from and for the Citibank card. That one was used primarily between the 12th and I think 28th. And again, consistent with the defendant using it. There was one specific transaction on the 24th where he used it at the Quick Trip just prior to leaving the state.
Okay. And first of all, when you said the 12th to the 28th, would that be February 12th, 2025 to February 28th, 2025?
Yes.
And Quick Trip, that video was you obtained video showing the defendant using that specific Citibank credit card that was from a Quick Trip in the village of Big Bend?
Yes.
And that's in Waukesha County, Wisconsin?
Yes.
Now, with regard to the document received from the medical examiner's office, the death certification summary, did Dr. Biedricki have an estimated date of death?
Yes, February 11th, 2025.
And that was for both victim A and victim B?
Yes.
Did you go back with regard to the whereabouts or the locations of victim A and victim B going back from February 28th when their bodies were located?
Yes.
And when were you able to talk to, or was someone able to talk to victim A's manager at his place of employment?
Yes.
And was he, or is it a he?
Yes, he is.
Was he able to determine when the last time he actually knew he was talking with victim A, either through verbal communication where he heard him talking or he physically saw him?
He believed the last time he was confident he talked to victim A was February 11th.
Were you able to locate definitive proof that either victim A or victim B was alive after February 11th, 2025?
I have not been able to find any evidence of that.
And did you locate, when's the last known observation that anyone had of victim A?
The last observation of victim A would have been roughly 5:30 p.m. on February 11th, 2025 after leaving Woodman's in the city of Waukesha.
And how about with regard to victim B?
Victim B would have been the same date, February 11th, 2025 at roughly 8:30 p.m. leaving the Pick and Save on Sunset Drive in the city of Waukesha.
And did you observe that video from the Pick and Save on Sunset Drive?
I did.
And the clothing that victim B was wearing in that video, did it match the clothing that victim B was wearing when she was found deceased?
Yes.
Which Pick and Save? There's two on
It's on Sunset Drive, the one nearest, like the Target, Fox, right off of Oakdale.
Okay, thank you. There's two
The
on
Metro
Sunset.
Markets?
There's two Pick and Save.
It's a Pick and Save, but
Communication that employees, teachers, or administration had with the defendant after February 11th, 2025, when he was last seen at school?
yes.
And when was that?
I believe it was February 20th. I could be wrong. There were some emails sent from, I believe, concerned teachers trying to figure out why the defendant hadn't been in school for some time.
And did it, sorry.
I just don't recall if it was the 20th. It was sometime after the 11th, certainly, though.
And was there any information that teachers were able to provide that the defendant turned in an assignment on February 12th, 2025?
Yes, there was an assignment he submitted electronically on the 12th.
Okay. Now, on March 7, 2025, did Detective Frederick speak with an individual who was identified as Witness A?
Yes,
And what was Witness A's relationship to the defendant?
fellow student at Waukesha West.
And did Witness A have any information with regard to statements the defendant had made that were concerning to her?
Yes.
And what were those statements?
Witness A indicated that the defendant at times had talked about killing himself or harming himself, and had mentioned that first he would kill his parents by possibly shooting them because he didn't want to subject them to his own death.
Did he ever indicate to her if he was serious about doing this? Did he mention it more than once?
From what I recall, he did mention it more than once, but also would indicate that he didn't have access to claimed he didn't have access to a firearm, and that he was not being serious.
And in speaking with Witness A, did she indicate whether or not he had ever threatened her?
Witness A stated that that during some of these conversations, the defendant told her that if she ever told anyone about this, that he would. It was a vague threat of you'd regret this or something similar to that. There was nothing specific.
Did she take it as a threat?
I believe so.
And in going through the phone, did you, in going through the defendant's phone, did you locate any pictures that were relevant to this investigation with regard to a Smith & Wesson firearm or Anguilla ammunition?
Yes, on an older phone that we don't believe was actively being utilized, yes.
And what about, what information did you locate?
I think it was an iPhone XR that appeared to have been a previous phone utilized by the defendant. And when searching through the images or the cache history, there was an image with a date of January 28th that showed the defendant holding a Smith & Wesson Model 686 while standing inside of a closet. And then also an image from February 9th of two different images of one round of that Anguilla 357 meg ammunition.
And when's the last time that you can associate the Volkswagen Atlas being at the residence on Cider Hills Drive?
Definitively would probably be February 23rd in the afternoon.
And how were you able to determine that?
But the neighbor, their next door neighbor had a Ring doorbell camera that captured the vehicle. Also, the next door neighbor specifically recalled seeing that VW Atlas driven by the defendant on the 23rd. I believe that was roughly around noon.
Did the defendant have a valid driver's license at any time?
No.
Based upon the information provided by Dr. Bidzricki that the date of death was estimated to be February 11, 2025, did the defendant have consent to use victim A's BMO bank card ending in the number 2431 between February 24th, 2025 and February 28th, 2025?
I'm going to object to speculation.
I'll overrule it. I see where the question's going. I understand it. I don't think it's speculative, so overruled. Go ahead, counsel.
I would say no.
And how about, did the defendant have consent to use the Citibank credit card that was in victim B's name but was associated with the victim A's account ending in 5341 between February 12th, 2025 and February 28th, 2025?
Again, I would say no.
Do you believe, based upon your investigation and the date of death of victim A and victim B being February 11th, 2025, the defendant had consent to operate victim A's Volkswagen Atlas?
No.
Between February 12th, 2025 and February 28th, 2025?
No.
Did the defendant have consent to possess or remove from the residence? Did the defendant have consent to remove jewelry purchased by victim A from victim A's residence on or about February 23rd, 2025?
I don't believe so, no.
And how about the $14,000 in cash?
I would say no.
And again, based upon the observations you made of both victim A and victim B's body, were there attempts taken to hide those bodies?
Yes.
And were there further attempts made, do you know if there were further attempts made by the defendant to make it appear as if at least victim A was alive after February 11th, 2025?
Yes. Sorry, yes.
Thank you. Was there any video footage obtained from the residence?
Yes.
And specifically, was there any video, a camera outside the residence above the garage?
Yes, a Simply Safe camera, yep.
And I think I asked you this before, but were either victim A or victim B observed leaving the residence anytime after February 11, 2025?
No. The last time we have ever seen victim A was leaving Woodman's at 5:30 on the 11th of February 11th, 25, and the victim B was leaving Pick and Save on February 11th, 2025 at 8:30 p.m.
Was there anyone else other than the defendant that was observed going to that residence between even February 10th, 2025 and February 28th, 2025?
What was the second date? You said February 10th and when?
February 28th, 2025.
There
Other
was
than law enforcement.
There was a guy from Bryce's Lawn Care that came to the residence and met with, we believe to be victim A. There might have been a mail delivery here or there, but no, I didn't recognize or identify anyone else that came to the residence.
Nothing further.
Cross.
The Simply Safe camera that was above the garage, you indicated that was running and functional, correct?
To the best of my knowledge, yes.
And you stated here today that the last time victim A was seen was leaving Woodman's on February 11th?
You said victim A, February 11th at 5:30 p.m., yes.
Okay. And victim E, the last time that individual was seen was leaving that Pick and Save at 8:30 that night?
Yes, ma'am.
There was no video footage of them returning home?
On the Simply Safe camera?
Correct.
No, there's no footage of it.
Is the Simply Safe camera something that runs continuously or is it motion
I
activated?
think it's motion detected.
And it's above the garage?
There was one above the garage, one at the front door, one at the side yard, and one at the backyard.
Okay, and you indicated that when you, or law enforcement reviewed that footage, you were able to see a vehicle leave the residence at some point?
When?
Between February 11th and February 28th.
I'm sorry, can you be more specific? On which camera?
You had testified
Yes.
that in looking at the Simply Safe camera footage, that you had seen the defendant leave the residence.
Yes, during that time, during the 11th through the 23rd.
Okay, so the camera footage picked up who you believe the defendant to be leaving the residence, but it didn't pick up victim A or victim B returning to the residence?
I'm sorry, what specific time are you talking? Like, so on February 11th through the 23rd, I regularly see the defendant out in the yard, moving the garbage can, shoveling snow. On February 11th, are you asking me?
You testified that the last time victim A and victim B were seen was leaving different grocery stores on February 11th. I'm
Yes.
trying to determine if the cameras on the home picked up their return to the home on February 11th.
No, it didn't.
Okay, thank you.
Sorry.
That's fine. There were a number of questions about consent with respect to bank cards, vehicles, firearms, jewelry, cash. Do you remember that line of questioning?
Yes.
Okay. And is it fair to say that you yourself and your fellow law enforcement officers have not been involved with this family prior to this investigation?
That's correct.
Okay. You don't know the family's arrangement in terms of utilizing funds?
I have no idea.
Okay. You don't know if they had an arrangement about utilizing the vehicle?
There is some information that we know that Nikita did not have a driver's license, and there had been conversations in the past about him potentially earning the right to obtain his driver's license. But I don't know. That was, I believe, a little bit beforehand, sometime before this incident.
Okay, you said there was conversations about him earning the right to obtain his driver's license?
There was, I believe, from talking to family, they had mentioned that they did not believe he yet had a driver's license, although he was 17, and thought that was a point of contention possibly at the family, and that he wanted to drive, but the family was not yet willing to allow him to get his license.
And this information that you're referring to is coming from victim A's family?
Yes.
Okay. Do you know how involved victim A's family was with the defendant?
Objection as to relevance for this hearing.
What is relevant?
He's just testified that he's obtaining information from these individuals about the relationship, potentially consent and things like that. They talked about consent and whether it was there.
I'll overrule the objection, but it'll only go so far, counsel. This is a preliminary hearing. This isn't a trial, so go ahead.
Understood.
I know that victim A's family primarily spoke with victim A and received information on family dynamics, typically from victim A. Not so much that I don't know that they were communicating regularly with victim B.
The only other question I'll ask about it is it correct that victim A's family does not reside in the state of Wisconsin?
They do not.
Okay, thank you. In terms of the statements that were made by witness A, those were made when law enforcement was speaking to individuals from Waukesha West, is that correct?
I don't understand your question. When they were speaking to individuals from Waukesha West?
Correct. You testified that during the investigation, Detective Moonen spoke to individuals that were at Waukesha
Detective
West.
Fredericks, I believe, interviewed victim A, or witness A, I'm sorry.
Okay, so Detective Moonen spoke with employees at Waukesha West.
Primarily like the school resource officer and staff.
And Detective Frederick spoke to witness A.
Interviewed witness A, yes.
Okay, and those happened on different dates?
I believe so.
Do you know if witness A came to Detective Fredericks or if Detective Fredericks went to witness A?
Objection as to relevance for this hearing. Again, this isn't a discovery proceeding.
Sustained.
The statements that were made that were concerning to witness A involved self-harm and potentially killing himself, is that right?
There were statements to that effect, yes.
And those were generally followed up with, I don't have access to a gun, I'm not serious about this, it's a joke?
Yes.
Okay. And the phone that you found, that you referred to as an iPhone XR, you said you believe that it was used by the defendant?
I believe it was his primary phone from roughly 2019 to maybe January of 25, yes.
And you said on that there were two images that drew your attention?
Yes.
One was from January 28th of 25?
I can't tell you exactly when the image was taken. I just recall that I noted that the date associated with that image in that phone download showed January 28th. I don't know if that means that device actually took that picture or if that image was transferred from another device to that phone on that date. Okay. I can't tell you that.
And the other one was somehow associated with February 9th, and that was with one round of ammunition?
There's two images of both depicting that one round, yes.
Okay. The iPhone XR is not the phone that you were tracing to try and locate?
No.
Mr. Kassab, okay. What phone was that?
Objection as to relevance for this hearing.
Well, I'll overrule it. I mean, I think the question is whether the phone recovered.
The phone you're referring to?
So you testified that the iPhone XR you believe to be Nikita's primary phone from 2019 to January 25, correct?
I believe so, yes.
That's not the phone that law enforcement was tracing to try and locate him on February 28th?
That was not the one that was currently assigned his phone number that he was actively using, no.
Okay, so there was a new phone that was assigned?
There's multiple phones recovered during this investigation, but the phone that you're referring to that emergency pings were submitted on was not the iPhone XR, no.
Okay. You indicated that you believe the bodies were covered to try and avoid detection, is that correct?
I believe they were covered, yes.
You testified that you believe it was to avoid detection of those bodies, right?
Potentially, yes.
Okay. Were there also candles lit in the residence near the bodies?
Only evidence of that was near victim A.
Okay. Did you observe, or did any other law enforcement officers observe any other attempts to maskless?
Not that I recall.
No cleaners that were out or chemicals or anything like that near the bodies?
Not that I recall, as I said here, no.
The state of the home, you said that it was, things were all strewn about the floor, that drawers were open and emptied, right?
Yep.
And I don't remember if you testified as to why you believe it was like that.
I did not.
Okay. Why, in the complaint, it states that law enforcement believed the home was in that state because there was a search for money. Would you agree with that statement?
I think that's certainly a possibility, yes.
And it's true that within the home, there was additional cash that was found, right?
I recall there was, I believe, 500 found at one point. I can't remember where it was. Maybe in a BMO envelope, I believe, yeah.
And that was in an iPad case in the office?
That sounds right.
Did there appear to be anything else missing from the home that was noticeable?
There was empty jewelry boxes in the basement. Again, we had the receipt for that Smith & Wesson Model 686, but we couldn't find the gun or any type of like safe that it would have held. There was empty BMO cash envelopes on the kitchen counter that were empty. We did not find cell phones that we would have associated with the two decedents. Yeah, there was a number of things that we believed were missing, yes. The vehicle.
Do you recall the date of the receipt for the purchase of the firearm?
I know that it was from Select Weaponry, and I believe it was 2021 or 2022, but I don't recall the exact date, no.
You stated that officers' observation of the video of Nikita at a truck stop in Iowa, he did not appear under duress, is that correct?
Yes.
And you said in part that was because he was walking the family dog?
Yes.
Did you review any of the information that was found on the cell phones that were recovered with Nikita?
I have reviewed some of the information, yes.
Do you recall messages that were being conveyed about a plot that could have influenced Nikita?
Objection as to relevance for this hearing.
I'll sustain that objection. Move on, counsel.
I might have missed this, and I apologize if I did. You stated that there were 4 shell casings that were recovered?
There were 4 shell casings recovered in the VW Atlas. That was also located with the other .357 Agia rounds.
And there were 3 bullets that were recovered in the home?
3 in the home and 1 from victim A.
Okay. How many gunshot wounds did victim B have?
Victim B had 4 entrance and exit wounds. However, during my discussions with Dr. B, she was not confident that the injury to the wrist was an independent event and could have been as a result of one of the injuries to the neck, abdomen, or upper chest. And I'm sorry, Dr. B is Dr. Bidzricki.
Thank you.
The cash that was located in the vehicle, do you recall where in the vehicle those things were located?
There was an amount of $6,000, an amount of $8,000. One was found in a Bible, and one was found, I thought, in a iPad case or laptop case or something similar to that. I'm sorry, it was a memory. It was a photo memory book was one of them, and a Bible.
Do you know where the Bible and the photo book were located within the vehicle?
I don't recall at this point.
The money that was located in the Bible and the photo album, was that located when officers in Kansas were searching the vehicle, or was that after it came back
I
to
believe that
Washington?
was March 4th when they executed the search warrant here at our Fleet Services building.
So fair to say it wasn't in plain sight when they stopped the vehicle?
I don't know. I don't believe so.
Did you review the report of the Kansas law enforcement agency?
Yes.
And you don't recall if in that report they indicated that they collected the Bible or saw cash strewn about?
I don't remember, sorry.
No further questions.
Redirect.
Briefly, you indicated that there are no cell phones associated with either victim A or victim B found in the residence. Is that correct?
I believe that iPhone XR was found at the residence. But I don't believe we ever found the phones that we would have assumed to found next to the victim A or victim B. We did not locate.
Were any phones associated with victim A or victim B located in the vehicle the defendant was driving?
Yes.
More than one?
Yes.
Thank you. And the Simply Safe camera, is that connected through Wi-Fi?
Yes.
And therefore, if someone disconnects the Wi-Fi, would it not show any video?
That's true.
Okay, nothing further.
Hey, recross based on those questions.
No.
All right, may this witness be excused.
Yes, Your Honor.
All right, thank you very much for your testimony. Any further witnesses?
No, Your Honor.
Thank you. So you rest?
Yes.
Thank you. Defense?
No witnesses.
Thank you. The court will consider evidence closed. State your motion to the court.
Your Honor, the state moves for bind over based upon the testimony of Detective Seitz. The state does believe that there is probable cause to believe that this defendant committed a felony, and specifically all 9 felonies that have been charged against him at this time.
Thank you. For the defendant?
We would object to bind over and move for dismissal.
Thank you. Well, the matter comes before the court on a preliminary hearing. Court's heard testimony. We had identification of the defendant. We have jurisdiction on this matter. There was testimony about where the police department was dispatched to, the address here in Waukesha County. Court notes that as the testimony went on, every single count was addressed. First of all, we have reports from the coroner, cause of death, gunshot wound, homicide being the cause of death for both victims. The bodies were hidden. There was a hiding a corpse allegation, counts 3 and 4. I heard a fair amount of testimony on that. Those counts are shown as well. There's a probable cause to believe that this defendant committed counts 1 and 2, committed counts 3 and 4. The other issue that was brought up during the course of testimony was the issue about lack of consent to counts 5, 6, 7, 8, 9. Now, as far as the amount of theft, $10,000 to $100,000, there is evidence in this record just by the jewelry that's $14,000. The source of the cash, that's another matter, but it's well beyond $10,000. There's a lack of consent by virtue of the fact that the owners of this property died there's a lot of testimony on, I think, February 11th from a coroner,
from reports from a neighbor, everything tells me that the people who have consented to any of these things were not with us in this world anymore. They were passed on, so no consent was given. We even had additional testimony about the fact this defendant didn't even have a driver's license, knowing the family wanted him to be driving at the time. In fact, that's more detail than I would typically get at a preliminary hearing. And yes, counts 5, 6, 7, 8, 9. There's no consent here. So as to all counts, the court will find the following. There's probable cause to believe that this defendant committed all of these counts, all these felonies. So I'll order him bound over for trial before the trial court, the Honorable Judge Ralph Ramirez. The court makes that finding on today's date based on the testimony before it. State, have you filed an information provided to the defense?
We have not, based upon the information provided here in court, and we believe the continued download of electronics, we believe, well, I know additional charges will be issued.
All right, so you're asking for an arraignment date
We are.
before the judge?
As close to 30 days as possible.
All right, that being said, defense, any comment before we obtain that date?
No.
All right, Madam Clerk, a date for arraignment within the statutory deadlines.
April 30th, 9:30, 10, 10:30, 11.
I'm in trial that entire week. Would you have anything May 5th at 1 o'clock, or this needs to be for branch 3? May 5th, I am in front of Judge Ramirez at 9:15.
I do not have May 5th, otherwise May 7th. Can do 9:30, 10, or 10:30.
I'm in other branches at those times. Is anything available on May 8th in the morning?
I do not have May 8th.
Is counsel available May 2nd? And is court available May 2nd?
That wouldn't work. Sorry. I'm booked and Ms. Ostrowski is in training in St. Paul. Is anything available on the 7th?
That was the day you could.
That was the day that I couldn't make, but you could.
Could we do 10:30 on May 7th?
State, is that available?
I know my trial is actually in Judge Ramirez's court, so possibly we could squeeze it in on April 7th. I'll be there anyhow.
Would Judge Ramirez be amenable to doing that? I mean, just pausing proceedings?
Done that before, where we've done it at 1:15 before the court starts, or 1 o'clock. I'm available. I'll be in that court all day, so.
I mean, we could also do 1 or 1:15. That would work better, I think, for us.
Oh, I'm sorry. Actually, April 7th is just the further jury status hearing, so he would have some availability on that day.
May 7th.
May 7th, no.
I just want to make sure you're looking at the right one.
Yes, thank you.
You're looking for May 7th at 1:15?
Yes.
Defense, can you do that?
Yes.
All right, so May 7th, 1:15 for arraignment before the Honorable Ralph Ramirez. And before we conclude today's proceedings, do the victims want to be heard in any way?
We will check with them, and I would just ask the victim witness specialist, Ms. Peterson, who's on Zoom, if she can verify and let the court know.
And to be fair, family of the victim, I should be more specific.
Yes.
Go ahead, anyone? Carrie Peterson, what do you want to tell us? Does anyone want to be heard today?
No, I do not believe so.
Thank you.
All right. All right, that'll conclude the hearing. I wish everyone well. Have a good day. Take care.
Thank you.
All right, so I'm just coming back to talk with you guys a little bit while I swap us to the next segment of this. So there's still no whatsoever verdict or jury questions or nothing. So it's absolutely still radio silent. It's been 5 hours of deliberation and there has not been nothing. So I guess it's time, y'all. We're gonna watch some parole hearings. So I'm gonna play a parole hearings. So I'm just trying to decide which one we're gonna watch today. Uh, some there's parole hearings, there's revocation ones. Revocations are always longer for some reason. Um, because I think that's the only thing we left to do. We've covered hearings. James Crumbly has never come back. Yeah, you will get life, absolutely. And journeys, I really hope it's just Darrow that covers this case. That would be amazing if she would. I would be there so fast. Right, okay, let's hear some revocation hearings. I think that will be good. I don't know when this from, but we'll figure it out. Man, I'm just having food. That's why I'm not on screen. I'll be back in a minute. I just need a little bit of a break and some food too. I'll see you guys in a minute. The best still be in chat too.
I'm going to be serving as chair for this panel. To my right is Mr. Pete Freeman. Remotely, we have Michelle Renanza. We're seeing an inmate at the Baton Rouge Parish Prison. Would you introduce yourselves here at headquarters for the record?
Yes, probably.
And we have some people there at the facility. Would you please introduce yourselves?
You're on mute. Lieutenant Murphy.
Okay, Lieutenant Murphy, I'll be asking you a question here shortly, okay?
Okay.
Sir, would you state your name and your DOC number for the record, first of all?
Michael Medell Stewart, 119852.
Okay, Mr. Stewart, do you have in front of you a parole revocation questionnaire?
Yes, ma'am.
And you recognize your signature on that?
Yes, ma'am.
Okay, so today you have appointed counsel Scott Collian, and he is here at headquarters and will be assisting you in this hearing. I'd like, first of all, to also introduce your sister, Ternice Stewart, is here, and she would like to speak, and we will give her an opportunity to do that. But before that, Mr. Leonard, I'd like to ask you, Sergeant, what has his conduct been while he's been there incarcerated?
Oh, you're asking me?
Yes, sir.
Ma'am, I can't honestly answer that because this is the first time I've ever had any, interaction with him.
Okay.
Okay.
Thank you.
You're welcome.
We're going to go ahead then and allow your sister at this time to make a statement on your behalf. Ma'am, if you'll just go to the podium, address your comments to the panel.
To the panel?
To us.
I've never did this before.
That's okay. You'll be fine. Just tell us why you think that he should be released at this time.
Michael Stewart is my brother, and he's not a bad person. He lost a lot of people in his family by being incarcerated. Michael come home and did 38 years in prison. And he come home and I was all he had. And I tried my best to help him. And he had a job, I gave him jobs, and he was seeing psychiatry, and he was doing a whole lot of stuff. He was doing really, really good, and I was very proud of him. He worked for the city of Baton Rouge, he worked for Tony's, he was going to all his doctor's appointments, and I helped him get his own place. And I thought that he was fine with the girlfriend that he had, but I didn't see no signs, so I didn't know what was going on with that. But I believe he learned his lesson because he was in a ministry in church. My husband is an active pastor. And we tried to work with him, and we will continue to work with him. And I will mind and keep a close eye on my brother. And I just feel like he did his time, and he give him another chance for him to come home so that I can better keep an eye on him and put him back in mental health or whatever he may need to better himself or whatever. And I'm just here for him. I'm just here for him, and I'm just hoping that he come home. And this time he looks like he's full of medicine or whatever. But this time I'll keep him close. Thank y'all for having me here. And thank y'all for your talk. I love you. I hope
Okay.
hear me.
Mr. Stewart, I'm going to handle your case with your violations now that we've had someone speak on your support. Mr. Stewart, you are accused of violating the conditions of your parole and that you were involved in criminal activity, and it was evident by your arrest at Baton Rouge Police Department on 6/22 of 2024. You were arrested and booked to the Baton Rouge Parish Prison with the charges of domestic abuse battery with strangulation, 11/17/2024, and you pled guilty to the amended charges of domestic abuse battery. How do you plead in this case? Guilty, not guilty, or guilty with a statement?
I pleaded not guilty to my lawyer, to my attorney, but my parole attorney. I pleaded not guilty to my parole attorney, but
Okay, so Mr. Collier is going to help you with this. Mr.
Sir,
Collier.
Again, just for the record, my name is Scott Collier, appointed Taylor Juar, which is probation parole officer. I met Mr. Stewart. We talked about facts in the case. It was acknowledged that there was an incident with a girlfriend putting hands on her, and I think that Mr. Stewart would acknowledge that he hated me. And so I think that's the statement he wants to make. Mr. Stewart, correct me if I'm wrong. Is that a good way to sum up what happened?
Yeah, sum up what happened that I had did my time for what I pleaded guilty to, and I would like to be home with my family, to go home to my family.
And talked about what happened with your girlfriend, acknowledged that you put your hands on her and you pled guilty to that. And I believe that Meyer, correct?
Talk now?
Yeah.
Like I said, I would like to go home and be with my family. And I served the time for what I'm in here for.
I don't know if that's, yeah, just want to let you know my appreciation, Mr. Stewart, and I's conversation about this. Want to move forward on something else.
So,
I think that acknowledgement is what Mr. Stewart.
Mr. Stewart, it also alleged that violation number 10, in that you have not paid your fees and you are in arrears $1,008. How do you plead on that?
I don't know nothing about. I paid the last time I went. I paid my fees. Last time I went to my parole officer, I paid my fees.
You owe $1,008. You want to plead not guilty or guilty?
Yeah, I'm gonna plead not guilty because the last time I went, I paid my fees then.
Okay. All right. Mr. Stewart, since you have been in this time, have you had any problems in the facility? Have you had any write-ups or any disciplinary problems?
No, I had a minor infraction. Then I had a severe incident where I was crowded by 4 individuals, and they gave me stitches in my mouth. And my nose bleed real bad, and I had to get for my brain head. I had head tumors and all that there. But 4 individuals, they crowded me.
Okay. So tell, what kind of medication are you currently receiving for your mental health condition?
Oh, I'm not right now. I'm not on no kind of medication. They had stopped.
So you're not on any kind of mental health evaluation. You've been evaluated, but you're not on medication right now.
No, I'm not.
Okay. So do you understand that that your violation of your conditions of parole would mean that you are returned to custody, and you understand how long you're going back? You understand what's going on today?
Yeah, I understand that. I'm here for my plea agreement, and before the board, that the board was sending me back. That's what I was saying, that I don't deserve to be back in jail because I served my time. And I believe they calculated my time wrong. The length of time that I was in, they calculated it wrong. I had arguments due to that. We go before a judge. I never been back to court on all my legal work and everything. They took the legal work and all that.
So you pled guilty. You pled guilty to domestic abuse battery.
Yeah, and I done served my time for it. That's what I was saying. The only thing I would like to be home with my family.
So that's a violation of your condition of parole. I'm going to ask if my colleagues have questions.
No, sorry, I haven't.
Yeah, I do. Mr. Stewart, whenever this incident happened with your girlfriend, well, let me rephrase that. Before you came back to jail there, where you're at now, when you were out on the street, were you taking any medication?
Yes, I was.
And so since you've been in jail, you haven't had that medication?
No, I haven't.
And so do you remember what happened with your girlfriend?
Yeah, I have a memory, but then I clearly remember. I have a memory of me telling her not to be disrespectful and not be rude in my apartment, screaming and yelling.
Right. Have you had any contact with her since then?
No, I haven't.
So she's no longer your girlfriend?
No, she's not.
Okay. All right. Thank you, Ms. Ledoux. I have no other questions.
Mr. Stewart, based on your guilty plea of domestic abuse battery, my vote today is going to be to revoke your parole. Mr. Freeman?
I concur.
Ms. Renatza?
I concur.
Sure, Stuart, I'm going to make note of my record that you need to, I know you've had 2 evaluations for mental health, and in one of them it says that you were prescribed Seroquel for that, but I'm going to go ahead and request that you be sent to mental health evaluation at Hunt so you can have better medication. Okay.
Well, how much time do I have to back up? I already did my time.
Don't do time, sir. Thank you very much. Good morning. The panel is at headquarters in Baton Rouge. And on the panel today, Mr. Freeman's to my right, Ms. Renatza is remote. My name is Ms. LeJew. Sir, would you state your name and your DOC number? You're muted, sir. We'll need someone to unmute you.
All right, go again, Richard. My name is Richard Nixon, 1038.
Richard Nixon.
I think we're supposed to have Willie Carr next. Do you have him available?
Okay, yeah. Yeah.
Okay, we'd like to switch out.
He's it's in that. Is his paper, huh? You can leave it there. You can leave it there. They won't see Willie right now, Richard. I'm already but they won't see you. Oh, don't really work. Yeah.
Hey, Mr. Carr, is that you
Yes,
before?
ma'am.
Okay, I'll reintroduce us. To my right is Mr. Freeman, remotely is Ms. Renatza, Ms. LeJew. We're your panel today. Do you have, go ahead and introduce yourself with your name and your DOC number.
Okay, my name is Willie Carr. My DOC number is 509486.
Okay, Mr. Carr, do you have before you paperwork that you completed called a parole revocation questionnaire?
Yeah, that paper right there that's in front of you. This one right here? No, this one right here. Yes, ma'am. Yes,
And
ma'am.
you utilize your signature.
Yes, ma'am.
Okay. Did you decide you wanted to hire an attorney today? You're not eligible for appointed counsel. Did you hire an attorney?
No, ma'am.
Okay. So we'll go ahead and continue. I'm going to ask Ms. Renatza to read the allegations against you, and she's conduct an interview with you. Okay.
Yes, ma'am.
Good morning, Mr. Carr.
How you doing today?
I'm doing well, thanks for asking.
Yes,
So
ma'am.
we're here for a revocation. You're accused of violating the conditions of your parole. So I'm going to read the allegations and you need to make a plea of guilty or not guilty, okay? And then we'll talk about it.
Okay.
So you're accused of violating condition number 4, and it says you were granted parole or released on good time May 13th, 2020. It's 24. Was it 23 or 24?
It was April the 23rd, 2023.
That's what I got. So that's a typo. You were released on good time April 13th, 2023.
Yes,
on
ma'am.
June 19th, I'm on the wrong one. I'm sorry. That's why I had the wrong dates.
Yes, ma'am.
Mr. Carr, hang on, let me get to your file. Here it is. So, it is alleged that you engaged in criminal activity when you were arrested August 10th, 2023.
Yes, ma'am.
And charged with the following offenses: battery of a dating partner with child endangerment, aggravated assault with a firearm, home invasion, and simple criminal damage to property.
Yes,
In
ma'am.
January 13th of this year, 2025, the charges of domestic abuse, aggravated assault, home invasion, battery of a dating partner with a child endangerment, and possession of a illegal firearm by a convicted felon were dismissed without prejudice. So
Yes,
how do
ma'am.
you plead to violating condition number 4?
Not guilty.
So tell us what happened August 10th.
Okay, August 10th, they came pick me up from my girlfriend's house. Me and her was staying together, the same address where they say I had a home invasion for, which I can't see how because this is my parole address. This is the same address that I paroled out to. And me and my girlfriend, we really just had an argument. It wasn't no type of argument to where no leaks was passed or nothing like that. And I guess she kind of felt kind of bad because I was trying to leave. She didn't want me to leave at the time because her 12-year-old niece had just got killed in Central. And I guess she wanted me to be there, and I really didn't want to be there, and I was just trying to leave. And when I left, she just called the police and told them all kind of lies against me.
So we're talking about Ashley Green.
Yes, ma'am.
Okay. Well, the police report, and there were witnesses, according to the police report, witnesses, and the witnesses were her sisters, Chantel and Lisa, that they were there.
Yes, ma'am.
And that you entered the house without permission during one of the kids' birthday parties.
I stayed there. I have a key to get in the house. I mean, this is my parole address.
Did you have a gun?
No, ma'am. That was my cell phone. I didn't have a gun at all. I don't even own a gun.
Why would she say that?
Man, I mean, I don't know, but she actually.
Why would her sisters say that?
I don't know. She actually wrote an affidavit stating that she.
I saw that, but that's not uncommon for us to see.
Yes, ma'am.
A victim of this type who recants their statements. It's not uncommon, even when it really did happen. So, I put a lot of credence in that.
I didn't have a gun though. That's my word. I really didn't have a gun. I don't even own a gun. That's my place of address where I was staying.
Right. She claims that you and she had broken up. It was the other way around. You're saying she didn't want you to leave, but she said in the file that y'all had broken up and you had a problem with that.
No, she lied about that part because actually when the police got me, they got me out of the house where we were staying in together. We had moved in the house together. From when I came home from there, that's the same place that I paroled out to. Actually, was my parole address. And
how long have you known her?
We've been with each other for like 10 plus years.
Do y'all have a child together?
Yes, ma'am.
When's the last time you had contact with her?
I could probably say like after my charges got dismissed.
Which was in January?
Yes, ma'am.
Well, I know that you've been in jail a long time over this.
Yes, ma'am.
Since 23?
Yes, ma'am. And
over a year and a half.
And I actually have like 5 certificates what I've been completing. I completed.
What are those? Tell me what they are.
Right here. This is a second chance. This is for like path of employment, and it's a certification of path of employment in an opportunity program. And I also have this one. This is seeking safety, and I also have a new one that's came out. Is the MOVE program, motivating offenders through vision and excellence, where we just started. This is a new program that just came out. I actually finished phase 1 and phase 2. I'm just waiting on my certificate for phase 2. I know things kind of seem kind of crazy with me right now, but I really have been trying to do what I need to do to get back to society, to my family. And I also have a social worker who I've been working with. She works with the Capital Area Human Resource that's right there by the probation and parole office. She helped me get through a lot of classes too, and I had signed up for outpatient for when I get out, I could go do like a 28-day rehab with them, and after you finish, they help you out with, Goodwill, with clothes. They help you out with.
So yeah, you're trying to get out. You were only out. How much time did you do before you got released on good time?
6.5 years.
And so you were only out less than almost 4 months
4
when
months,
this
yes,
happened.
ma'am.
Well,
Yeah.
actually, I think this event may have happened in July, so you were
Yes,
out 3
ma'am.
months.
Yes, ma'am, but I really take accountability for everything, but I really like a lot of the stuff that they said I did, I really didn't do. I didn't have a gang. The house that they accused I home invaded, I stayed there. That's the same house that I got arrested from. When the police arrested me, they even told me like, how could they even have me on some of these charges when I didn't get caught with a gun? I never had a gun. They don't have me on camera entering a house with a gun. Like I've
Is
been
there
doing this.
camera? Does she
Yes,
have
ma'am.
cameras? Whose
Yes,
house
ma'am.
is it?
Yes, ma'am. It's our
Whose
house.
house is it?
It's our house. We had ring door cameras. They had cameras around the apartment. It's an apartment complex, and they never seen me entering the apartments with a gun. I never had a gun.
You know,
And I'm doing
what your
everything.
original charge is possession of a firearm,
Yes, ma'am.
illegal carrying, rather,
Yes,
of a
ma'am.
weapon when you were with controlled dangerous substances.
Yes, ma'am.
And so it's easy for me to believe that you had a firearm this day
Yes, ma'am. But I didn't.
because of your original charge,
Right.
I'm
Yes,
just saying.
ma'am. I
So
can
let me
promise
ask you
I didn't.
this. All right, we're going to move on.
Yes,
And then
ma'am.
I'm going to defer to my colleagues. I do have some concerns about you. I'm really glad that you're taking advantage of programs while you're there. You have been in jail over a year and a half.
Yes, ma'am.
What would be your plans if you were not revoked today?
If I'm not revoked, I've been going over a lot of stuff with my parents. My mom, she's sick right now, so she really needs me to be out there to help take care of her. But my uncle, he has his own truck business, and I be washing 18-wheelers and stuff with him. His name is AJ McManus. I can have a for sure job as soon as I get out. I have a place to stay, and I really don't.
Where would that be?
That would be with my mom. She was supposed to be on here today, but I think she had to work. She was supposed to, I think she had to work for like 6 this morning to 6 this evening. She was supposed to be on here today, but I don't know what happened. I don't think she was able to make it, but I have a for sure place to stay with my mom. I don't need to contact Ashley anymore. She's living her life. I can live mine,
What about the kid?
I just really want to check on my child, it's not like we have problems with each other. Like I don't want to do it, nothing or anything. I really just really want to take care of my child.
All right. I will defer to my colleagues.
Yes,
Thank you,
ma'am.
Mr. Carr.
You're welcome.
Mr. Freeman?
Scar, during the incident, was there any damage done in the house? I mean, did you damage a television?
Yes, sir. I was trying to take the TV down because the TV is actually mine. I had a receipt for it. That's why they dismissed it because I had a receipt for the TV where I had paid for it,
And so
I was trying to take it off the wall and accidentally broke it, so I just left it there because I was really trying to get all my stuff to where I could leave and go back to where I was gonna be staying there with my uncle, but I never got a chance to go back.
I have no further questions.
Mr. Carr, are you a first or third class offender? How many convictions have you had?
I have all my convictions are non-violent. I don't have any violent convictions under my record. I have all non-violent convictions. I'm not a violent offender.
When you were in previously, did you have any kind of anger management class?
Yes, ma'am. The certificate that I have right here, seeking safety, and the one for the MOVE program, both of them take up domestic violence and anger management. And I also have the one with second opportunity too.
Did they find a weapon in that home? Because I don't see.
Sir. No weapons was found at all. I didn't have a weapon. No weapon was found at all, sir.
Okay. No further questions.
Mr. Knotts, are you prepared to vote?
Yes. I don't know what to do with you, Mr. Carr.
I promise you, if y'all was to let me go home today, I'll never be in this position again. I promise you. I'm gonna do everything I can to stay away from jail. I promise you that. I just want to get home to my family.
Well, I know, you weren't out for a long time. You are a first offender. They didn't find a weapon. The court dismissed the charges. we do have what we have in the record from Ashley. You know, I believe something happened that day. I mean, if you were going to be taking down the TV off the wall, something was going on.
Yeah, because I was trying to get my stuff and
Well,
leave. I was a little angry.
Well, there's a right way to do things, and that wasn't the right way. But you know, you have been in jail a year and a half for this. I'm gonna do not revoke, return to supervision, add special condition. You have no contact at all with Ashley Green. If y'all have to, you know, exchange the visits with the child, you family members can facilitate that. You and she do not have to have any contact with one another, and that you do enroll in an anger management class. I'm just one vote, but that's how I feel. Good luck.
Freeman.
Okay. I'm looking at how much time you've been in jail too, and there was no gun found. Or no mention of any, you know, bruising or bleeding and stuff of that nature. So I'm going to give you a chance also, like Ms. Renata, but I do want you to stay away from her. And to make sure you stay away from her, I want to add a condition that you be on electronic monitoring for 6 months at the cost of the department, not at your cost. You go around her, we're going to revoke. Back on solid.
Mr. Carr, my experience is that when someone comes back for revocation, most of the time it's because of women and cell phones. I think you need to learn a lesson, and my vote is also going to be concur with my colleagues. That's the best advice I can give you. Okay. So you have not been revoked. In lieu of revocation, you will be returned to supervision with some special conditions. Thank you. Okay, Mr. Nixon. You're before the Louisiana Committee on Parole. Today on the panel is Mr. Freeman to my right, Ms. Renatza remotely, and I'm Jerry Ledoux.
How y'all doing this morning?
We're doing okay. You want to state your name and your DOC number for us?
Yes, ma'am. My name is Richard Nixon, 10-11-38.
Okay. So I just have to ask a question. Let's see, you're 70-something years old. Did your mama name you that before or after the president was the president?
Yes, ma'am.
Okay. You're here before this panel for a revocation hearing. I want to make sure that you have a revocation questionnaire in front of you, that you recognize your signature.
Man, I can't see. I'm blind.
Okay. So you would not have signed that.
I have the questionnaire in front of him.
Okay.
It looks like somebody read the questions to him and he responded, and I even went over it with him before y'all came back on. And he did. It looks like they may have somebody may have put a pen in his hand, and he wrote his name on the line.
Okay, so
he does have the questionnaire, and he did sign it. And the question of can you read and write, it has about his eyesight.
Okay, but he does not qualify for appointed counsel. Okay, so Mr. Nixon, we're going to go ahead and proceed. Today, your case has been assigned to Mr. Freeman, and he's going to read out the allegations against you of your parole violation, and then you're going to answer his questions, okay?
Yes, ma'am.
Okay. It is alleged that you violated condition number 4. You violated this condition as evident by your arrest on 9/9/24 or violation of protective order. This matter has also been through the 19th Judicial District Court, and on 1/14/25, you pled guilty to violating a protective order. How do you plead to that charge?
I plead guilty with a statement. See, when I got out of DCI,
All right, so
ain't
plead guilty.
nobody told me that I had a screening order. You know, I don't even remember signing a text order.
Okay, so you didn't remember there was a restraining order? I thought you said you
No,
knew
sir.
that.
No, sir, I don't even remember that. Cause I wouldn't never went there because I ain't thought I had one on me.
Okay, well, where will you go if you don't go there?
I got the address right here. I can't see. Can I give it to him to tell you?
Yes, sir.
It's 2075 McHugh Road in Baker.
Okay, who is that with?
That's my sister. Her name's Sandy Nixon.
Okay, and she's agreed to let you go live there?
Yes, sir. Y'all need a phone number?
No, sir. Do you realize now that you got a protective order and you have to stay?
Yes, sir. Yes, sir. And I got the copy. They gave me a copy of it in court.
Okay. Okay. I have no further questions.
Ms. Renatza?
So, Mr. Nixon, this is Marvia. The restraining order is so that you have no contact with Miss Marvia.
Yes, ma'am.
And when you were released, well, you went to the residence that she had. Why is that?
No, I went to my son's house, but she came around there, and then she walked me to her house.
So she lives nearby where your son lives?
Yes, ma'am.
Within walking distance?
Yes, ma'am.
What is your relationship with her? Is she your fiance?
Yes, ma'am. She got 7 kids for me.
So you say you don't remember this restraining order, and it was done in March of 2018, and it says it never ever expires.
Right. When I went to court and Mel Bella court, then I ain't signed no paper or nothing. I don't even remember that screening order.
Well, it says, I'm looking at it, I see where Judge Marabella signed it, but I also see your printed name on the form. Now, if you can't see, somebody may have helped you do that.
Oh.
But it's there.
Yeah.
And you were there, obviously.
Yeah, I remember.
So how is that going to work? You can't see her. You can't be around her.
But I'm about to. I'm moving with my sister, man. Y'all give me another chance.
Oh, with the sister. That's right. You did say with the sister. Okay. I'm sorry. Yeah. Okay. Thank you. I have no other questions.
How can you assure me you're not going to get back around this lady? I mean.
Yeah. Sir, I swear to you, I ain't coming back. You ain't gonna have no problem with me no more.
You think I would have problems out of you this time? Okay. I have no questions. Do you have any questions?
Since you've been there, have you taken any kind of classes or anything, Mr. Nixon?
No, ma'am. I've been going to church. I graduated from church here.
Well, the Bible says don't lie. We're going to have to stay away from your fiance. You can't be your fiance. You don't have contact.
How long did you stay with her? How long did you actually live there before you got arrested?
About 15 years.
No, I'm talking about this time. When you got out, she walked you over there. How long did you stay there for a few days?
No, sir. I was at my son's house, and I went to the parole office Monday morning, and then that's when they locked me up in the parole office. Me and my daughter went.
All right.
Hey, Mr. Freeman, are you prepared to vote?
Yes, I'm ready. Okay, Mr. Nixon, I was assigned your case. I'm gonna vote first. This restraining order cannot be violated.
Yes, sir.
That is, obviously, they had some bad things go on in the past for you to have a 99-year restraining order.
Yes, sir.
So I'm gonna do this. I'm gonna let them check out your sister's residence.
Yes, sir.
Go live with your sister. I'm gonna put you on electronic monitoring. I do not want you anywhere around that house. If your son wants to see you, he comes see you at your daughter's house.
My sister's house.
Sister's house. You do not go to your son's house.
Yes, sir.
Understand?
Yes, sir.
Okay, so I'm gonna give you a break because you've been in there 6 months and obviously there was a little confusion about the restraining order, but there is none anymore.
Yes,
so you'll be placed, I'll add the condition of electronic monitoring. My vote today is to do not revoke.
Yes, sir.
Mr. Knudsen?
I agree with Mr. Freeman. My vote is also do not revoke with the same conditions.
I'm going to vote to not revoke, but Mr. Nixon,
Yes, ma'am.
that's it. You're a sixth offender. No more. No more.
Yes, ma'am.
You'll be on electronic monitoring until, did you specify a time?
No, I want to go electronic monitoring.
Okay, you'll be on electronic
Until
monitoring.
the agent feels it.
And the agent will make a decision about when you can come off of that. So you've been returned to supervision. Good luck.
Yes, ma'am.
All right, Richard. Hold up. All right.
It's 10:03, and we are at East Baton Rouge Parish Prison. Sitting on the panel today, to my right is Mr. Freeman, remote is Ms. Renatza, and my name is Ms. Ledoux. Sir, would you state your name and your DOC number for the record? You're muted.
Yes, good morning. My name is Leonard Hendricks, DOC number 730500.
Yes. Okay, Mr. Hendricks, you're before this panel as a first-class offender. You're currently serving a 10-year sentence for home invasion. You have a parole eligibility date 2/6/2025, a good time date of 1/7/26, and a full term date of 8/6/2027. Does that sound correct according to your understanding?
Yes, ma'am.
Okay. Sir, I would like to ask before we get started for you to explain to this panel why you're currently incarcerated and why do you think that we should provide you consideration for early release?
I'm incarcerated for committing the crime of home invasion in 2017. The reason why I considered being eligible for parole or being granted for parole is because like during my incarceration, I completed multiple educational and vocational programs, from the Steve Hall program to living in balance, anger management, a welding program, which I got a certificate of completion for welding. I also, during that process, I did I was an instructor, which was teaching other welders how to weld and complete their trade. I have a full support system. I'm currently at East Baton Rouge work release. I'm employed at a company called Command Services where I sandblast and paint. I feel like I'm fit for society. I know my rights and my wrongs. I know what I did was pretty wrong and a bad decision. I'm also like sincerely sorry for the victim family, and the community, and the impact that I had on those. That was, and also my family. So I just want to take like a consideration of getting the good chance to be back in society.
So I think that you have done some good programming, but I'd like to also address the fact that although you have gained 360 days of good time, you lost 375 days of good time.
Yes,
based
ma'am.
on non-compliance with institutional rules and regulations. And several of those were rules number one, contraband.
Yes, ma'am.
You had a cell phone write-up as late as 2022.
Yes, ma'am.
Why?
During the beginning of my incarceration, it was like a bumpy road of trying to like understand the process of being incarcerated. This is my first time being incarcerated. So I was following, I want to say, like bad examples of people that I idolized. And it was a learning process. And the more I looked into it, I started to like see that the ones I was idolizing was like illiterate. And I've never been that type of person. So it was like a big learning process that the more I keep going on the same path of like doing the bad things or violating, and I started to see that like I wasn't gonna go home as soon as I thought I was. I kept on getting set back. So it just came to like a realization and like a reality check.
Okay. Did you ever take the program Thinking for a Change?
Yes, ma'am, I believe so.
Must have taken it after 2022 because this conduct is unacceptable. Mr. Freeman or Ms. Renatza, do you have any questions?
I do. Were all of your write-ups for cell phones? Was the contraband something else too?
Something else too.
What was the something else?
Self-mutilation.
I saw that. Okay. What did you do? What was the self-mutilation?
Getting a tattoo. Yeah.
Oh, okay. Okay. And all of your contraband write-ups, so were they all cell phones or was there some Mojo in there? Anything else?
Yeah, Mojo as well. Drug related. I
When
would
was-
think. Green leafy substance.
Yeah, I know, but when did you do the Mojo? When did you have it?
That was probably 2019.
And when did you finish Ship Shop? When did you finish your drug rehab?
I finished that in the beginning of my sentence. Probably 2018.
Okay, so you used drugs after you had been through the program.
Yes, sir.
I haven't.
Ms. Renatza, do you have any questions?
Yeah, I do. So the last write-up was in 2022?
Yes, ma'am.
And I see where you did have 45 of those days restored.
Yes,
That
ma'am.
lost good time. Have you applied for any of the rest of it?
I've been currently like submitting restoration of good time, and they only give me like increments,
right?
Like during each form. So I'm in the process of like I continue to do that.
Okay. So have you just started that process?
No, I've been doing that process for about 7-8 months.
While you've been at East Baton Rouge?
Yeah.
Okay.
I've been at East Baton Rouge for about 4 years now.
Okay. All right. And you were it looks like you were moved out of the work release program. So let's see, you were initially signed there in October of 23, and for a little period of time this month, it looks like you were transferred out of work release, and now you're back just for a few days. What was that about?
I was transferred from Southwest Transitional Work Program to East
Yes,
Baton Rouge here for a job in my trade, which was welding, but I wasn't eligible. I wasn't work eligible at the time. So they just had me here as a Class A trustee.
I see. Okay. All right. All right. I don't have any other questions. Thank you.
Mr. Hendricks, I feel like your ability to follow the rules while you're incarcerated is very indicative of your ability to follow the rules on probation. It looks like you have a good time date of January of next year. My vote is going to be to deny based on your lack of institutional progress in terms of your behavior. Mr. Freeman?
I concur. You had the ship shop program. You used drugs afterwards. Every bit of good time you get back is going to move your date up. So you don't have much longer. So my vote today is to deny.
Mr. Hendricks, I'm really pleased to see that you figured it out. Obviously you have, because it's been the 3 years since the write-up. And that's why I asked you if you started looking at, getting your good time restored, because as Mr. Freeman said, that's going to help you move that January date forward. But today I'm going to concur with my colleagues. My vote today is to deny. I do wish you well and good luck to you.
Thank you.
And now the time is 10:12 and we're closing out our hearings there at East Baton Rouge Parish Prison.
And we may take up several within a group if they're related at the same time. And so with that, let's take up defendants' motions in limine regarding inflammatory evidence, use of the term murder, and use of the term psychopath or sociopath.
Thank you, Your Honor. I'm guessing from the court's comments, the court wants me to address all three of those. I'll do that then. Your Honor, the motions are brought to the court based on Mr. Koberger's constitutional rights and the rules of evidence and relevant case law. With regard to the inflammatory evidence, that is requesting that the court issue an order preventing the state from trying its case with an emotional appeal or an excessive use of emotional phrasing or an excessive use of repetitive photographs. Certainly, we understand that there will be photographs that we may not like that come in, testimony that we may not like that will come in, but what we're talking about is an excessive use of emotional appeal. That the examples that we've seen in relevant case law come from State versus Ellington. In that case, the prosecutor repeatedly used a phrase that was inflammatory about the defendant having run over the wife of a witness who was testifying. And that was found to be inflammatory because of the excessive use of that phrase. Additionally, in that case, there was an appeal to juror emotion when the state sought testimony from a witness about why he might have left his job. Those are examples of what we're talking about. The court has to do the rules of evidence balancing test, and to do that after the state has elicited inflammatory testimony is difficult to undo and puts Mr. Koberger in a position where the jury's already been inflamed, and so we're seeking to prevent that. Your Honor, I will move then to our motion regarding the murder term. This motion is also based in Mr. Koberger's constitutional rights to due process and to a fair trial. This is not a motion to ask the state not to use the term murder. That's going to come out when the court reads to the jury the charging document. That's going to come out in jury instructions. This motion is about the state, through its witnesses, labeling Mr. Koberger. That invades the province of the jury. Mr. Koberger sits here today. He's innocent, and it's up to the state to bring evidence and a jury to decide if that's different. The state, by using that kind of term as applied to Mr. Koberger, gets in the way of what the jury needs to decide. Back when we were looking at a change of venue in this case, we worked with a social scientist named Dr. Amani El Aleli, and she talked a lot about how bias is made in people and how we think about things and how we remember things. And one of the things she talked about, and her report is in the court record, one of the things she talked about is the influence of people in a position of authority. And for the state to come in and label Mr. Koberger in their position of authority or ask a witness, especially a witness in uniform, to do so is very detrimental. It's inflammatory to Mr. Koberger. And
outside of opening statements, perhaps, where the state might say, we intend to prove the defendant murdered the victims, perhaps in reference in voir dire, that, in this case, the defendant is accused of murder. I'm having a trouble understanding how this would come up during the evidence phase of things.
Your Honor, that's why I'm asking the court to issue an order to prevent it from coming up.
Sounds like you're asking me to issue an order that says the state shall not commit prosecutorial misconduct, or the parties will follow the rules of evidence.
Your Honor, I would like an order that the parties will follow the rules of evidence.
I'm sure the state would like one too.
I'm not going to oppose that, Your Honor. We'll get to the state's motion.
I don't think I need an order because, as the name implies, they are rules, which means they will be followed.
Your Honor, in an abundance of caution, we bring these motions, and that's based on review of case law and based on years of experience when things happen in trial. I found and I believe that it's relevant to bring these kinds of motions before the court now and have all of the parties aware of.
I think there's maybe a difference between bringing them to make sure that the issues are highlighted and the parties are vigilant versus perhaps entering sort of prescriptive orders that are so broad and vague in nature that they are essentially meaningless.
Your Honor, this is my opportunity and the place that is reserved for the defense to bring these motions. I think that they're important motions, and with court's orders, it makes it more clear. Even if the court order isn't spelling out, you can't say this, you can't do that, I think there's an awareness, and I think it's relevant to have that order. I think it's important to have that order, and most of all, I think it's protective of Mr. Koberger's constitutional rights to have that order. That's our request with regard to
sociopath or psychopath.
Yes, I'd like to
address. The state was intending to go there, but you're welcome to address it.
Your Honor, if the state is stipulating not to use those terms, I don't need to make a full argument on that, but I'm prepared to do so. I'll be brief. Then with that, we brought this motion again under Mr. Koberger's constitutional rights to a fair trial and due process of law. This motion is really spelled out in Dr. John Eden's affidavit when he talks about the unreliability of tests that might label somebody in that particular way and the danger of having that label applied to somebody. If that's allowed to happen, then Mr. Koberger is colored with an opinion or a way the jury will view him that is unfair. And our request is that the court not allow the state to label him in testimony as a psychopath or a sociopath. Because any kind of testing is unreliable, that would relate to, or that would become problematic within the rules of evidence to do so, and the inflammatory nature of those kinds of labels would.
I'm not aware of any testing that has been done that has reached that conclusion. Am I missing something?
You are not missing anything. There has not been any testing. There has not been any labeling. This, again, is my opportunity to bring a preventative motion to protect Mr. Koberger's constitutional rights, and that's the purpose of that motion. Thank you.
Thompson?
Thank you, Your Honor. As the court is aware from the responses that we filed, Mr. Nye and I actually kind of divided these motions up. We didn't realize they would be heard together. But as to the inflammatory evidence, what the court has noted is exactly what our concerns are. In the defendant's filings, he doesn't specify what inflammatory evidence he's concerned about. He doesn't define the phrase exceptionally inflammatory, nor are we aware of any definition of that. The words just seem to be used loosely and freely here. And in fact, in the defendant's reply, he acknowledges at page 2 that he really doesn't even know what he's trying to object to. He's asking the court to presume that something's going to happen or anticipate something without a basis for it. We don't see any basis for the court to enter an order. We intend to conduct our trial professionally. And we anticipate that if there are questions about anything that we do, that there will be a timely objection and the court can address it in that fashion. So our prayer to the court is the court deny the request for orders that the defendant has made and simply preserve the defendant's opportunity to object if something of concern comes up in the future.
Your Honor, just briefly, the purpose of using exceptionally inflammatory is used in conjunction with our recognition that in case law, photographs that we might not like will come into evidence. Exceptionally is to define what we mean. And we mean when it's over the top, when it's unnecessary, when it's going to inflame the passions of the jury, and that tips the scale of relevance. We don't know exactly how the state's going to try its case. We do know there are over 13,000 photographs, hundreds of hours of videotape, and many, many witnesses who the state will call to testify. We believe that it is imperative that we have an order to prevent the case being tried in a way that presents inflammatory evidence and appeals to emotions for the jury.
All right, the standard for motions in limine, which I'm about to set forth, applies to most motions today that we will address today, and I don't intend to repeat this with each motion, but for the record, let me go through it once. Evidence is relevant if it has any tendency to make the existence of any fact that is of consequence to the determination of an action more probable or less probable than it would be without the evidence. All evidence, all relevant evidence is admissible except as otherwise provided by the rules of evidence or other applicable laws of the court or of the state. Although relevant evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, misleading of the jury, or by considerations of undue delay, waste of time, or needless presentation of cumulative evidence. The question of whether evidence is relevant is a question of law to be reviewed de novo, while the decision to admit relevant evidence is reviewed for an abuse of discretion. On discretionary matters, the trial court must correctly perceive the issue as one of discretion, act within the outer boundaries of its discretion, act consistently with the legal standards applicable to the specific choices available to it, and reach its decision by the exercise of reason. So my concern with the motions is not the substance of them in the sense that I think it's appropriate to highlight those issues that everybody should be cognizant of. It's in fashioning an order that has any real meaning. Because of the breadth and lack of specificity of the motions. With respect to the use of terms psychopath or sociopath, I do understand that there is no evidence that the defendant specifically has been tested and found to be with that diagnosis or personality disorder, if you will. And I understand the state is not intending to, at this point, seek to attach that label. Absent evidence, competent forensic evidence, if you will, qualified expert evidence, and I haven't worked all the way through penalty phase, and I suppose that could come up in penalty phase of things, but for now, certainly for the guilt phase, innocence phase of the trial, I am ordering that the state and its witnesses not use those two terms where they're equivalents. If something happens where you believe a door has been opened before launching into that in front of the jury, you're also required to bring that to my attention outside the presence of the jury. With respect to the term murder, well, let me start with the term murder. So I don't, obviously the jury is going to be charged with what the charge is or our charges are in this case, which include first-degree murder. I don't think there's any problem in using the term murder as it describes the charges and the allegations. Testimony or statements by counsel or by others that the defendant is a murderer or committed murder, I think would be essentially argumentative in nature at this point. I will tell you that the one thing that will get my dander up quickly is either counsel attempting to argue outside the one opportunity they have to argue in a case like this, which is closing. And I will shut you down faster than you can imagine if I see that. And if I see it again, I will admonish you in front of the jury about it, because I'm serious about not arguing in your questioning or statements or comments between questions and nature of that. And so that would also go with the term murder, I think, to the extent that it reaches a conclusion that the defendant committed murder prior to the closing. Now, certainly the allegation that the defendant committed murder is going to be relevant and probably appropriate in opening statements, perhaps even in voir dire. But apart from that, if you're intending to go there, you need to bring that to my attention outside the presence of the jury. And that's obviously important. Both of those are important to make sure your witnesses understand as well. With respect to inflammatory evidence, I don't know what that is until I see it. And certainly there are rules regarding prosecutorial misconduct. I think counsel is likely well-versed in what those rules are. I'm not one that says I'm going to order that you follow the rules. You are counsel licensed professionally by the bar, admitted to this court. Your obligation is to follow the rules. And that is what I expect of counsel. And so any attempts to skirt the rules without a good faith basis to do so will be problematic. In terms of, and I think really where there's some potential gristle, meat on the bone here, I should say, relates to, I suppose, the photographs or videos of the decedents and the state of the crime scene. This, I would imagine, from what I've seen, some of those photographs are particularly graphic, but make no mistake, these murders, whoever committed them, were brutal and were horrific. And so I suspect that the evidence will reflect that. Now, if it comes to cumulative evidence, or perhaps some that are unnecessarily graphic, we can address that on a case-by-case basis. And so I think the idea is before you show the evidence to the jury of that nature, that counsel be given a copy of that. Obviously, if you're going to be seeking to introduce those, they will be given a copy, and we can have a discussion outside the presence of the jury about how many, which, et cetera, will be presented. But I don't feel it's really does anything it doesn't advance the ball for me to abstractly say don't use inflammatory evidence. So I'm not going to do that. I will rely upon the obligations of counsel as professionals to understand their responsibilities. And when it comes to the specific actual evidence, then we can review that before it's presented to the jury. All right. Next is unnoticed 404B evidence and evidence regarding the 404B evidence that was noticed in this case, which is the traffic stop.
I'm prepared to address that, Your Honor. I do note on the court's list, the state's motion regarding improper death penalty comments is actually next in order, but we'll take it in whatever order the court prefers.
Let me, if you want to address that, let's do that first. I apologize. I should have included that within the group because I think it kind of falls within the same category. I think you understand what my rulings are, but I can address it specifically if counsel would like me to.
Ms. James was going to handle that. We're happy to just submit to the court.
I think it's the defendant's motion, so if they want to argue it, they can.
Your Honor, it's the state's motion.
Oh, is it the state's motion? I apologize. Oh, that's right. I was thinking of it in the opposite terms. That's fine. If you want to, Ms. Jennings, address that briefly, you may.
Thank you, Your Honor. I will.
And this relates to the concerns that the defense may say something like the state's trying to kill Mr. Coburg or something of that nature, as I understand.
Yes, Your Honor. There has been a history in this case of that mischaracterization of 18-4004A. We're just hoping that that mischaracterization is not made in front of a jury. But considering the court's comments this morning, as well as defense counsel's comments that there shouldn't be statements made whose sole purpose is only for an emotional appeal, I think that this is settled. And the defendant replied basically saying the same in their response, that they suggest you use phrases that comport with existing language and statute and jury instructions, and that's what the state is asking for. Thank you.
Any response?
Briefly, Your Honor, we're satisfied using language that's already spelled out by statute, by jury instruction, and that sort of thing.
Right. So with respect to this motion, I think the ruling is really sort of encompassed within my, for lack of a better term, ruling or instructions about argumentative comments or statements of counsel. The example spelled out by the state, I think, would fall within that category of being argumentative and would be improper by counsel. And so obviously that shouldn't be done. And so they should comport with the language and at the appropriate time and in the appropriate way that is not argumentative to address that issue. And so they are so ordered. All right. let's take up 404.
Good morning, Your Honor.
That's all.
Your Honor, as it relates to the unnoticed 404B evidence, I understand what's been the discussion on similar verbiage and concerns earlier. However, one of the things that I think it's important to note about this is that although the state has agreed that they will comply with the rule, what we do have so far in self-authenticating records, it's our position is already two mislabels of the evidence. And the specific examples are that technically the DeSales paper, the way that the state wants to use that, would fall under 404B as other act evidence. It's a 2020.
It's a bad act?
It's the rule says other acts to show knowledge or plan. And so the state has expressed that they plan to use
how you
that
can use
paper.
it. It's,
I'm sorry, I can't hear you.
That's how you can use it under 404. The way you can't use it is a prior term of colloquial term is a prior bad act to show that the party acted in conformity with that, they have a propensity to commit bad acts. For example, as it relates to the traffic stop, I suppose the concern is, well, he committed a bad act of not wearing a seatbelt or following too closely, and therefore he's likely to commit murder. I mean, that's how the rule works. I'm confused about your statement about the prior academic paper, how that would possibly fall within 404.
Well, when in the self-authenticating pleading that the state filed about the DeSales document, they indicated that that shows that he has knowledge of cleaning up a crime scene. So our position is that we don't want to make sure that there's not some sort of in run. The same example that I will give you has to do with the Amazon records.
I don't think that we're reading the rule the same is the concern I have. And so I want to make sure I understand your position. Because what you're saying is the state's trying to use evidence to show the defendant had knowledge of how to sanitize a crime scene effectively. And that's one way that you can use evidence of a prior bad act that might otherwise be concerning in terms of propensity evidence. 404B doesn't exclude evidence of plan, knowledge, intent, et cetera, that's not anchored to a bad act. And so I don't see how 404 relates at all to the DeSales paper.
Well, it's our position that the way that the state is putting this in is, in essence, trying to anchor it to a bad act without giving notice of that.
Well, I just don't think your understanding of the rules comports with my understanding of the rule.
All right, well, I appreciate that we have a misunderstanding of the rule. Nonetheless, that's my position. And another example of that is the Amazon records, where they're claiming that those are self-authenticating relating to purchases. And that also has not been noticed.
But it's not a bad act to purchase things on Amazon.
But the state is using it, Judge, to show, using it as other things to show a plan or knowledge or intent.
But that is not what 404 precludes. 404 precludes a bad act, a prior criminal act, a prior, the best term is bad, something that would suggest that it is in your character to commit a bad act, to commit the crime because you've committed another bad act, right? You abused your significant other on one occasion, and therefore you have a propensity to abuse a significant other on a later occasion. That's 404B. Evidence that somebody has knowledge or has a plan not anchored to a prior bad act isn't covered by 404. It's not precluded by 404.
It's our position that the state is trying to do an in-run on that with this evidence. And that's why we raise the issue of 404B, anything that's unnoticed, not coming in as a bad act. One of the ways that we contemplated drafting this motion was because there were simultaneous filings of motions in limine, was to come up with a list of things that we were concerned they may call prior bad acts. But because we didn't know what they would raise, we raised it in this form, which is without notice, they should not be able to argue evidence is a prior bad act or do make any attempt at an in-run on that rule.
So I'm not understanding what you mean by an in-run on that rule in this context.
By saying that the argument about the Amazon purchase is that that was prior to November 13th, 2022, for the purpose of making a plan. And that's the argument that the state will make about that.
I think I understand what you're saying. I just think we're missing each other's understanding of the rules of evidence.
Well, I still stand by my position that the state should not be able to in-run that, and I'm hearing the state say that they have no intention of doing that.
Well, I'll hear what they intend to do in terms, because I think that your reading of the rule puts requirements on them that doesn't exist under the rules of evidence, but I will listen to their
Okay.
response.
Do you want me to go to the 404B on the video or keep it separate?
On the video of the traffic stop.
Okay. First of all, there's a pleading that was submitted to the court yesterday, and I have 3 copies of the video marked as Defendant's Exhibit D1 that I'll provide to the court for your review at your convenience. One for the court, one for you, one for Ms. McLaughlin. It occurred to me that it would be much easier for you to determine what you thought about this video if you actually got to see it in full. We don't need to play it in court. You can review that at your convenience. It's not our position that the traffic stop equates to a crime that makes someone capable of murder. It's our position that the traffic stop video brings in other acts that the state is trying to end run on. And I want to give you examples. In this video, things that make it more prejudicial than probative are that it provides presence in Moscow. It is at night. It is a visual of the car. That is not just the make and model. It is Mr. Koberger's statement that he doesn't think state seatbelts provide much in the way of safety. Mr. Koberger's question about why they need his phone number. Mr. Koberger's question about how the officer reacts when people lie to him about wearing a seatbelt. If the court allows this evidence in, the state has the ability to use this to make many other points beyond identity. And the jury would have the ability to potentially seek to ask to rewatch the video and draw other conclusions that we are worried about, such as I mentioned, him being at night, not wanting to, it being at night, him not wanting to give his phone number, which could be construed as he wants to hide his identity.
Date of this traffic stop?
Pardon?
Remind me of the date of the traffic stop.
It is on August 21st. So it's
What year?
Of 2022. So it's remote. It's
before the murders.
Yeah, yes, before. It's clear video of the car as opposed to the videos that are used at 1122 King Road.
Why is that a problem?
Because I think that the state, again, can use this video as an example of where you can see a white sedan clearer than you can see it on 1122 King Road in those videos.
Why is that a problem?
Because there's an argument, the argument could be made that the cars look similar.
Isn't that the whole point of it?
Exactly, and so it's different.
The point of it being, as I understand it, is to show that the defendant owned a white, I can't remember the name, the maker.
Hyundai
Elantra, and that he, as opposed to others, drove that vehicle.
Correct, Judge. And so when this video comes in, it's much more than a witness saying, you know, I looked at registration records and registration indicated that he owned a Hyundai Elantra. When you see it on a video, and then there's going to be other videos that are put into evidence, there's a different argument to be made as opposed to someone verbally reporting a make and model. The state
Sounds like that makes that evidence of, I guess I'm just not tracking again under 404 how that particular issue. Now, there may be the ability to cross-examine the FBI specialists about, well, this video is grainy, how can you make this determination of what the automobile is, et cetera. To me is different than, okay, that's what their conclusion is, which you can attack. The evidence that he has a white Elantra within the years and that he drives it, it's prejudicial in the sense that it doesn't help your case, but I don't see how it's unfairly prejudicial, which is kind of what you were talking about, which is 403. I haven't heard anything that's 404, but.
Okay, well, they've noticed it as 404B evidence, so I'm arguing it in that context and what other things can be drawn from this video that make it overly prejudicial. The other thing is that the state's expert disclosure by Special Agent Nick Balance lists August 21st as one of the dates that they claim that Mr. Koberger is near the 1122 King Road residence. And so the date of this traffic stop is relevant to the state for that, their ability to argue that. That also makes it overly prejudicial.
It makes it relevant. It doesn't make it necessarily overly prejudicial.
Judge, the combination of these things is that this video has the ability to be much more than what the state is claiming. The state is claiming that it proves who he is, what his phone number is, and the type of car that he was driving. It's our position that when you watch the video, there are other arguments to be made that make it more prejudicial and therefore excluded when there are a myriad of other ways that the state can prove his identity,
You don't get
his
to,
phone
and I don't
number.
get to tell the state how to try their case unless they're violating the rules of evidence.
Of course I don't get to tell the state how to try their case, but I do get to tell this court what our position is regarding that evidence, and when we think that evidence is overly prejudicial and can be construed to do things that the state is otherwise saying the evidence is meant to do. And that's the point of this argument. We ask that you exclude this video, which I will ask that it be, that the marshal provide that to you, and that the state use a different method of proving identity.
Thank you.
I think after what we just heard, we can cut to the chase. The defendant doesn't seem to understand what the balancing test under Rule 403 is. There's no question that the video with the evidence, the defendant's admission of his identity, with his admission and the evidence showing it was his car, the description of the car, the registration of the car, his address, his telephone number, that's all incriminating evidence. That's why the state is offering it. The defendant doesn't like the fact that it's incriminating, but that's not a basis to exclude it. Under Rule 403, in order to exclude relevant evidence such as that, the defendant has to be able to demonstrate to the court's satisfaction that the relevance evidence, that its probative value is substantially outweighed by a danger of unfair prejudice, confusing issues, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. Just because it's prejudicial, and just because the defendant doesn't like the fact that we can prove who he is, that we can prove what car he's driving, that we can prove what his phone number is, that we can prove his address. I mean, those are all things that tie together to connect the defendant to the homicides. Just because they don't like that isn't a basis to object to it. And so, Your Honor, we would ask that the court deny the defendant's objection to the admission of this evidence.
What about the concern within the video, as I understand it? First, you have what is a 404 issue, which is a prior bad act, though one I'm sure everybody probably in this courtroom has committed at one time or another, of violating the traffic laws in some way, including by not wearing a seatbelt. And so, can you address that part of it, the prior bad act, and how the court should deal with that? And then also, I am concerned with the issue raised about the communication between the officer and Mr. Koberger, for example, his asking why they need his phone number. That could, I think, be unfairly looked at as if he has something to hide, which would be, I think, unfair. And so I am concerned about that.
And I appreciate Your Honor's comment. I think when you review the video, you can the court will be able to put it better into context. The state certainly doesn't intend to argue or suggest that the colloquy or the discussion between Mr. Koberger and Deputy Duke somehow showed that Mr. Koberger was a bad criminal type of person. We certainly are not suggesting by any stretch of the imagination, although the defendant alleges it in their response to the state's filing, that the fact that the defendant was apparently speeding without wearing a seatbelt somehow means that he is guilty of murder. I mean, that's a preposterous concept. And the defendant seems to have backpedaled from that before Your Honor just a little bit ago. The state's purpose is to elicit the vehicle and connect the defendant to the vehicle, the description of the vehicle, the defendant's name, of course, his phone number, his address. That's what the state's interest is. And the state, as it views the entirety of the relatively brief traffic encounter, we don't see anything incriminating or making the defendant a bad person out of that. Now, of course, Your Honor will need to see that and decide if its view is different. But we don't see that as being prejudicial. We certainly are not trying to argue some sort of propensity that because he questioned about, why do I need to give you my driver's license, that all of a sudden that makes him a murderer. I mean, that's beyond a stretch of imagination. Does that answer Your Honor's question?
Thank you.
Thank you, Judge.
Response?
Judge, there is a way to, clean this up with regard to this, and that would be to not allow the jury to see the video, to have the officer who made the stop, testify about the stop, testify about the identification, the make and model of the car, and the phone number. The argument that the defense doesn't like troubling evidence could be said about every single thing that the state wants to proffer in this case. This is a highly circumstantial case. And so every little fact that is circumstantial is going to be relied upon by the state. And so we have to look at a critical eye with everything that's coming in before this jury to see what the cumulative effect is going to be of that. And so it's not that we don't understand that his identity is going to be proven. As I argued, there are a myriad of ways for them to bring in his identity. But to add all the other components that you will see in the video do much more than just prove that he's Brian Koberger with a phone number in a Hyundai Elantra. Thank you.
right, with regard to this motion and the 404 issue in general, the standard for the admission of evidence that falls under 404 is that the court determined that there is a factual basis by which a jury could find more probable than not that the prior act, if you will, occurred, that the prior act is relevant for a purpose other than propensity, such as identity, and that a balancing test under Rule 403 would not otherwise preclude the evidence, i.e. that the unfair prejudice does not substantially outweigh the relevance. When it comes to 404B evidence, and that's how this was noticed and brought to the court's attention, which is the framework that I'm looking at, 404B does not apply to just any prior act. It applies to prior bad acts, other crimes, other wrongs, not other acts of benevolent or of a type that doesn't implicate propensity. And so I don't see the concerns that were outlined by the defense, for example, related to the DeSales paper and things like that, that's a 404 analysis. That's simply a 403 analysis, which is there unfair prejudice or other concerns that substantially outweigh the relevance? And there isn't the same notice requirement for that issue as there is for 404B. And so I don't see this as the examples raised as a quote unquote end around at all. And so the state does have a notice obligation when it does come to prior bad acts that it may seek to introduce. At this point, they've only identified the one, which is the traffic stop. The Rule 404 requires notice in advance or during trial when the state is aware of the need for it. And so, I don't think we can say that the shot clock has run out on that at this point, but certainly as soon as the state is aware of the likelihood of the need for that, they have that obligation to seek that. And at some point, the prejudice to the defendant in terms of lack of notice will upend the state's ability to use it if not properly noticed. So as a general matter, the state is required to provide that reasonable notice set forth in 404B. With regard to the traffic stop, the concerns identified by the defense related to, well, let me go through the 404B analysis. It is technically a prior bad act, which is the sort of colloquial terms used by the courts in describing 404B evidence, in that the defendant was stopped for violating traffic laws and ordinances. I think there obviously is evidence by which a jury could conclude that that conduct occurred. The next question is it relevant for a purpose other than that he has a propensity to violate the laws? I think in this case, there clearly is a other purpose besides that, which is identity, which is ownership of the automobile that is alleged to be a suspect automobile and control over that automobile. And so I think there is a relevant purpose for it. And the next question is that relevance substantially outweighed by unfair prejudice? The fact that it is more powerful evidence than perhaps a simple description by somebody of DMV records doesn't make the evidence unfairly prejudicial. It just makes it more effective. And that is not the type of unfair prejudice that the rule contemplates. And I don't, frankly, track the defense's argument with respect to that. And so I think as a general matter, the traffic stop is relevant. It's not I think there is zero danger that the jury will conclude that because he didn't wear a seatbelt or sped, that he therefore has a propensity to commit murder. I just can't imagine any reasonable person coming to such a conclusion. And certainly the jury will be instructed that they may not use that evidence as propensity, may only use it for the relevance of things like identity, ownership, and control. There are concerns that were raised, however, and so while as a concept, I think the video is appropriate under 404, or notwithstanding 404B and 403, I do want the video potentially, I'll look at it, and it may change my mind, but just from the description, I am concerned about some of the interactions with the officer that was mentioned that, that Mr. Koberger questioned why the police needed his phone number. That the officer said something about how he views people that don't wear seatbelts. I don't think any of that is relevant. And it does potentially create some unfair, some danger of unfair or unnecessary prejudice. So I think it needs to be redacted to exclude those kinds of things and have the video that shows his vehicle, that he gives the registration, that identifies it as his, that his answer to what, not the stuff leading up to what his telephone number is, but if he gives the telephone number, the answer, what the telephone number is. I think that's what we ought to see and probably not much else. So I'd like to see that before it's played to the jury, and you can work on redacting that and showing it to counsel, and within the confines of my rulings, they can raise any concerns they have.
Thank you, Judge.
All right, let's talk about who is going to be in the courtroom amongst the victims and the defendant's family in general, in terms of a reserved seat. I'm not as concerned about the reserved seat part. We can address that at the pretrial conference down the road. I'm more concerned about the ability to be in the courtroom, notwithstanding an exclusion order of the court of witnesses. So let's address that issue.
Your Honor, the state filed this motion in order to seek clarification of the court's definition of immediate family member pursuant to Idaho Code 1953-061B. As you know, that specific code section doesn't give us a definition of immediate family member. The state has given a proposed exhibit, State's Exhibit S1, which we think are justified as being immediate family. It's my understanding that defense has stipulated to that list, and we would just ask the court to issue an order to that effect. This takes care of the issue that the state raised. I don't know if you have any further questions.
Well, there is the issue of the defendant's family, but that's, I think, the defendant's motion, so I'll let them address that first.
The state submits that by simply placing our client's family on its witness list, that is enough to warrant exclusion, and further, that they may call family members. I want to note that they have not subpoenaed them, the state's attorneys have not interviewed them, and they know that Mr. Koberger's family does not have any interest in helping them. They also know from watching all of Mr. Koberger's video visits how much his family loves him and supports him, and that he is absolutely dependent on them, having been in isolation for almost 2.5 years, and by the time we get to trial, it will be almost 3 years. His parents attend every court hearing, and the only reason that they are not here in person is that they do not have the money to fly back and forth from the East Coast. If they had the financial resources, they would be here in person every single court date. Sequestration of witnesses under IRE 615 is discretionary. The language in the statute is that they may be excluded by the court. This means that there's court discretion in that decision, and there's a reason for that. The reason is that the court must balance Mr. Koberger's constitutional right to a public trial with other needs of the case. In the United States Supreme Court in Ray Oliver in 1948, the court stated, "Without exception, all courts have held that an accused is at very least entitled to have his friends, relatives, and counsel present, no matter what offense he may be charged." The Tennessee Supreme Court recognized the same precedent in State v. Sams in 1990. In that case, the prosecutor subpoenaed all of the defendant's family to keep them out of the courtroom. In reversing the case over this issue, the court held, the assistant district attorney's blatant abuse of the trial court's subpoena power for the exclusive purpose of removing the relatives from the courtroom constituted egregious prosecutorial misconduct. The state action violated the constitutional right to public trial, as well as the constitutional right of the relatives to attend the trial. In a more recent case in Iowa in 2022, State versus Bremer, a conviction was overturned when the accused family was excluded from trial due to COVID-19. The court pointed out even the defendant's mother was excluded. The purpose of the witness sequestration is to prevent a witness from tailoring his or her testimony. In this case, all of Mr. Koberger's immediate family were interrogated in the middle of the night when he was arrested. All of their interviews are videotaped. There's no tailoring of testimony to be done. Add to that the evidence that the defense has disclosed to the state in discovery and expert opinions, which the court has had the ability to review. Those provide an even more narrowing, who it would be even rational probably for the state to actually call. At best, there's one potential family member that they may see a reason to call. The state knows that Brian's family has no desire to be used as witnesses against him. From the minute this trial begins, the jury is going to study Mr. Koberger, and they are going to figure out who is in this courtroom sitting behind him to support him. Weeks into the trial, the jury is going to know who's in the gallery. That's why there is a constitutional right to a public trial, so that what happens here is not done in a star chamber. And for our client, the jury will know that he has people there to support him. Mr. Koberger needs his family to support him. As the court knows, we have several motions that we will be addressing regarding his autism spectrum disorder. He needs to have his family here to support him, and they need to be in the courtroom supporting him. These needs are constitutionally protected rights. We ask that you enter an order making it clear that the state does not get to put his family members merely on a witness list and keep them out of the courtroom. If they want somebody in court, there needs to be an out-of-state subpoena issued. They need to provide witness travel funds to be here and make their intentions very clear. And then this court, we ask, exercise its discretion and allow whoever of those family members the state may actually subpoena to be in the courtroom, because there's no need to worry about how they may tailor their evidence, because it's their testimony, because it's all video recorded. And the court could also order the state to make it those witnesses, if they do intend to call them, immediately call as witnesses early on in the case, so that if there is for any reason going to be exclusion, that exclusion would be there for a very short period of time. But we do ask the court to consider how important in opening statements, when that jury walks in and they're making that immediate first impression assessment, how important it will be for Mr. Koberger to have his family sitting behind him. We've also asked in our motion that the court address decorum, since the court's going to be issuing an order. As we pointed out, there's been some history in this case with clothing being brought into the courthouse that's pro-death penalty and pro-firing squad. There's no place for that in this courthouse at all during these proceedings. There's no place for that in this courtroom, and we'd ask that the court issue an order that spelling out very clearly that that will not be allowed. Thank you.
Your Honor, the state trusts that this court will enter your own standards of decorum for the courtroom, and the state will advise our witnesses and immediate family in accordance to those instructions, and we expect that they will be followed. Regarding the defendant's family, in no way is the state intending to use its subpoena power in order to exclude Mr. Koberger's family from the courtroom. The state's not aware of any authority to support this argument that the defendant has a Sixth Amendment right to have his family in the courtroom. He, of course, under the Sixth Amendment has the right to a public trial, but that's not his choosing of who is in that courtroom. Totally understand it's within your discretion to allow certain immediate family members in the courtroom to support Mr. Koberger.
The reason you can't simply take up whatever family members you may need to testify in your case in chief right at the beginning. Other than, obviously I know you have a narrative on how you want to lay these things out, but what I will tell you is both sides ought to get used to the idea that with a 3-month trial, the trial schedule will not be held hostage to your narrative. In other words, we'll be taking things out of order, stopping witnesses to put another one on to make sure we get them through them and picking them up again. And so is there a reason you couldn't call whatever family members you need right away?
Well, I will say, we have no intention of calling all the family members. We have the intention of calling a few of the family members who serve certain purposes. I can't think of a reason that we couldn't. Obviously, it's not ideal. It's completely out of context. It's out of order.
This is like a gumbo. You are going to put all the pieces that go into the pot. And at the end of the day, the jury's going to decide whether it's a good soup or not from the state's perspective. And so I think we get too obsessively stuck on the idea of exactly the order these things need to come in, right? And so I'm not sure why you couldn't call the family members you need up front, and then we take away this concern. I can certainly understand from the defense perspective the need and desire to have the defendant's support family here in the courtroom.
I do too. And I guess my preference would be for that, even though it would be out of context and interfere with the state's preference of how to present its case. And I think I do take issue with the defendant being able to direct how the state presents its case to a jury. However, if our options are the immediate family members staying in the courtroom and hearing all the testimony of other witnesses versus calling them out of order, it would be our preference to call them out of order. Thank you.
Judge, I knew that the state's position was that there's no case law to support our position, which is why I just went through several cases where it is his constitutional right, one, for it to be public, and there are cases, as I referenced.
Constitutional right is not absolute and bends to, for example, rules of evidence and other rules. And I'm not aware of anything that says a court can't use the exclusionary rule where, in good faith, a person who was otherwise entitled to be there, including family members, have to be excluded for some period of time.
And that is why I specifically talked about the point that it is discretionary for you. And there's also, Judge, a level of humanity that I hope that you take to serious heart for his family, who is absolutely devastated and dealing with things like headlines that they're going to be called to testify against their son with these types of communications that are happening. And so we're asking that you use that discretion and that you find that humanity. Thank you.
Thank you. I'm going to take this matter under advisement. The defense raised some cases. I want to read those, though I don't think they were precedent on this court setting. I haven't reviewed the U.S. Supreme Court opinions cited, but in terms of other states, I'll look at those. I do think, and I'm asking the state to think about to use counsel's word, the humanity. I think that, I can only imagine the family of Mr. Kohlberger is devastated by these things. That's nothing that they did. And I think their ability to be here to see the trial is important. And to the extent possible, while also preserving the state's right to a fair trial, should be something that we seek to do. And I think calling them out of order is one way. Now, I know that there is, I don't know why the state would want to call them. I haven't reviewed their interviews. I don't know anything. I do know there's been an issue raised by the defense relative to purchases on an alleged family account that could be an issue. And so I do see some issues where family members may be important. And so I think there may be some need for exclusion. But I think the best way to handle that is to get them on and off as quickly as possible at the beginning to deal with that. I'm reserving ruling on that. I want to look at it, and I will issue a written order on that in due course. All right, let's talk about the defendant's motion regarding conditions as an aggravator, and this is the concern about using the defendant's alleged autism disorder diagnosis as an aggravator during the penalty phase of the trial, if there is one.
Thank you, Judge. You summarized exactly where I was going to start. This motion is brought in case there is a penalty phase. If there is a penalty phase, Mr. Kohlberger has a right to present mitigation evidence. That is State versus Payne, and Roper versus Simmons tells us that mitigation evidence cannot be used as aggravating evidence. This is something that we talked about several months ago when we had our motion to strike the death penalty and ask for trifurcation with the death penalty, and that was denied. But we're bringing it back up because it's really important to make a distinction between things that exist in this case, Mr. Kohlberger's autism, something that he didn't ask for. It's a condition that he has, and it'll need to be addressed, but also to prevent the state from using his characteristics of autism as aggravating evidence against him. The state has, and the court has, our expert analysis from Dr. Orr that talks about how autism manifests in Brian, the things that people might see. And these are things that we've read a little bit about in the media over the course of the case. Brian's physical body is more stoic, how he sits in one place. And he will look at for a long time. Sometimes he'll hold his hands in a rigid position. And that means nothing. That's just how Brian is. We seek to prevent the state from using those kind of characteristics against Brian. We seek that in the way of testimony they might bring. Sometimes Brian will talk longer than maybe other people want to listen, and that doesn't mean anything.
Well, I assume he's not going to be talking in court unless he's testifying, so.
That's exactly right, Your Honor, but that doesn't stop the state from bringing a witness and using that as aggravating evidence against Mr. Koberger, and that's what we don't want. We want to be able to present, if we get to a mitigation phase, his autism and how that works and how he's learned to live with the conditions that he has and to prevent the state.
Reading the the state's response, it doesn't sound like they disagree with you that it shouldn't be used as an aggravator. And so I think that in terms of what counsel's arguments are, we can control that. I think apart from a jury instruction, I'm not sure what we do with how we deal with that with the jury in terms of the penalty phase, right? If you present evidence of the disorder.
Your Honor, the court can do what we've requested and prevent the state from using Mr. Koberger's conditions of his autism as aggravating evidence. I think a jury instruction helps the jury to understand how to use mitigating evidence. Our purpose here is to ask the court to take the step of an order. I don't think the state opposes it.
What would that order say?
That order would say that the state would be prohibited from using as aggravating evidence Mr. Koberger's autism characteristics.
How would they use it as aggravating apart from arguing to the jury that, well, because he has this condition, it means that he is, I'm just making this up, obviously, is inclined to not follow the norms of society and presents a greater danger or something like that?
Your Honor, the order would prevent the state from, on the front end, in presenting their aggravation case, from using the conditions, the way autism works for Brian, against him, to say that he does things that are consistent with autism and that that's an aggravating circumstance.
I'm just having a hard time envisioning what that would be, how it would be presented in a way that is making it an aggravator.
Well, I would hope that it wouldn't be presented that way. But, Your Honor, when I look through the mounds of discovery, there are probably 100 hours of interviews of people that Mr. Koberger went to school with at WSU. And of course, those interviews come just hours and days after the headlines hit that Mr. Koberger's been arrested in this case. And people that he went to school with, that he interacted with, had unkind things to say about him. And a lot of their unkind things, when you understand them in the context of autism, the way he may stand in a room near a doorway, the way he may look too long at a person, their interviews are different when you know he has autism and you know the characteristics he displays. But those awful comments, those mean comments about him, if the state uses those as aggravators, that's using his autism characteristics.
How do I, though, and I don't know that this is a real thing, right, in terms of actual evidence. Let's say there's evidence that he harassed other young females. Okay, and I'm aware of no evidence in that regard. I just want to make that clear. I'm just using this as an example. And let's further assume that that in and of itself is somehow relevant to in a mitigation aggravation penalty phase. Your position is that's due to his spectrum disorder, whereas the state's view may no, that's not. That's his view of women and goes to motive, etc. And goes to his aggravation of the crime in some way, not because of Asperger's, but because of his views, his dislike, and how he responds.
That's exactly the problem, Your Honor. If the state and
Do you want me to,
I want
you
to
want
be
me to weigh in
clear.
and say what the factual findings are, that it's this and not that? And I'm not sure I can do that short from a jury instruction that, you cannot use mental health conditions as an aggravating factor.
That's an appropriate jury instruction, and if we get to that phase, my guess is that we'll have one of those jury instructions. But if it's an appropriate jury instruction, how is the jury to understand and properly respond to that instruction if the state has been allowed to run over the top of that during the presentation of their aggravation case? It's that I want to limit. Once we present mitigation...
There may be a dispute about the reasons for his conduct, a factual dispute. And that then ultimately is for a jury to determine, not for me.
Your Honor, I believe the court is envisioning a problem that does not exist.
I hope so.
I think that the court will not find that that comes up. I think the court can issue an order to the state that would be not to use his conditions of his autism as an aggravator, his diagnosis of autism as an aggravator. That's going to be very similar to the court's jury instruction, and that keeps the trial process clean, and it allows the jury to draw the distinctions and properly use mitigation as it's supposed to do. This is a protective measure to be sure that case law is complied with and that Mr. Koberger's constitutional rights are protected.
Thank you.
Morning, Your Honor. So the court is correct that I don't think there's a whole lot of room between the state and the defense in terms of what the law says here. But there are maybe some practical problems in what the defense is asking for from this order. And the court has already nailed this, if the court is to issue an order that says the state can't rely on his autism as an aggravating factor, then anything we try and present, they're going to argue, well, that's a symptom of his autism, and therefore the court's order says you can't use that. I don't think that's an appropriate approach. What I can tell the court is the state has no plans whatsoever to use the autism during the penalty phase as any kind of aggravation whatsoever. There is no plan to put on students from the university to talk about their personal views of this individual. To be quite frank, if we get to a penalty phase, we have a lot better aggravating evidence than the fact that he has level 1 autism. And frankly, it's just not a persuasive argument to ask a jury to impose the penalty of death because someone has autism. So from the state's perspective, this falls largely into one of the categories the court mentioned earlier in a different motion, that it's just really not necessary here. We understand the law. We understand that we're not to use his mental condition as an aggravator. We do, however, reserve the right to present argument as to, if the defense chooses to present it as a mitigating factor, how much weight should the jury give it? And I think we have quite a bit of flexibility there to put on our own evidence as to what exactly this autism means. And so that if the defense tries to say this is the reason that you should not sentence him to death, then we should be able to argue this does not make up for the proper aggravation evidence that we put forward. I think not only is that the state's right, it's what the statute requires. It's what the Idaho Supreme Court has been very clear that a juror in this situation has to be able to do. It's their duty. That was the Dunlap case. It's their duty to weigh the evidence, including any mental health or mental illness evidence, and make that ultimate determination. And so the state does not believe that this order is necessary or appropriate, but also has no plans of using this as aggravation. Thank you, Your Honor.
We understand that the state can argue the weight of the mitigation evidence. That's not why we brought this motion. As far as what the conditions of autism are and the way it works in Bryan, the state has received, through our expert disclosures, reports that describe that. So there's some guidelines for the state there to understand what we are talking about with Bryan's autism. The state will present its aggravation evidence first. The protective order that we're seeking from the court, the order to say you can't use his autism and the conditions thereof in your aggravation case, is easy, it's protective, and if we get to a penalty phase, it is imperative that we protect the rest of the trial. Certainly, if the state thinks it needs to present something in aggravation and there's a question, they could ask the court to revisit the order. This is just a very good, clean way to protect Mr. Koberger's constitutional rights, and we ask that you enter an order.
Thank you. Right. I don't, again, from a legal perspective, I don't think there's a disagreement about the use of the autism spectrum disorder as an aggravating factor in the penalty phase. The state certainly shouldn't make those arguments. And are instructed not to do so. But how that comes up factually, the fact that your expert says that this is one of the symptoms of this, that the state can't put on some evidence that they may disagree about, I'm not in a position to make that sort of blind statement or blind ruling. I think we need to get closer to trial and see specifically what we're dealing with. And so I'm not inclined to issue such a broad order in terms of the actual evidence, the presentation of evidence. I think I can certainly say don't make that argument that the fact of the diagnosis is somehow an aggravating factor. And we can deal with the symptomology that the defense contends is part of the diagnosis that the state may take issue with or believe that there's some other relevance of in the penalty phase. And so we'll deal with that on a case-by-case basis as we get there. So the extent of my ruling is simply that the state should not make the general argument that somehow the diagnosis is an aggravating factor. Right. Why don't we take the morning break? We'll take 10 minutes, and be back at about 20 till. All right. Let's talk about what I hope we have come to an agreement is not an issue, which is the IGG stuff.
If I may start, and they're battling.
Yeah, I think there are three motions. One is the improper expert testimony of Middleman, who's related to the IGG. The defense, and that's the defense motion. Defense motion regarding IGG evidence generally, and then the state's motion regarding IGG.
Yes, good morning. You're right, Your Honor, that we have essentially, I think, an agreement with the state as to their position and our position being equivalent at this point for different reasons. And I believe that the state is willing to proceed without Dr. Middleman, therefore making that motion moot, and that they will proceed with using the generic term or the generic evidence of a tip leading to the identification of Mr. Koberger. The only issue that we have is how that tip will be presented to the jury. The one thing that the defense is concerned about is exactly the testimony and the witness who will be testifying to the tip. And we want to make sure that nothing that is said by that witness implicates another source. And by source, I mean someone like a witness who called with a name or some other way of identifying Mr. Koberger by name as the possible suspect. The state, in their response to us, said, well, we have lots of other evidence, and they have lots of other evidence they intend to produce. But the only thing that identified Mr. Koberger that set them on a train or a trail to charging him was the genetic genealogy. So we just asked.
Well, I don't know if that's a fair statement. I think the thing that led to them investigating him was the investigative genealogy. I don't think that's what led to, the only thing that led to charging him.
I apologize. You're true, right? It was what they led them to investigate him and ultimately charge him. But I think that the court could issue an order or at least require the state to make a proffer is exactly how they're going to do this. The reason I'm here is because I've done a lot of cases with DNA evidence. And the last thing I want is a repeat from a case I tried many years ago, which was a cold hit, where the state simply introduced a quote tip through testimony of a police officer. And the first question the jury asked was, what was that tip? And that is not, we do not want the jury to speculate. It's not our job to tell them how to do that, but I think the court has to be vigilant.
Well, I certainly could anticipate that being an issue in terms of the jury's curiosity, right? Depending upon how compelling or not compelling the other evidence may be viewed by them. And so it may be that you want to come up with some instruction to the jury that basically says, you know, we're not going to tell you what that tip is and you don't need to consider it or something like that.
Is that an invitation?
It's an invitation for you two sides to work together to try to solve this conundrum in a way that you both can live with.
Okay, well, I accept that invitation, and I assume the state also will be willing to do that. I don't know if anybody has any comments.
I mean, we see this sometimes, not in the context of DNA, but we will have, as an example, a probation officer who does a home visit and searches somebody's property without a warrant or other right, because they have that ability on probation, because the defendant will have waived their Fifth Amendment rights as a condition of probation. And sometimes then we want, we'll have to have the probation officer testify in a way that doesn't necessarily tip the jury off that the defendant was on probation, which would be a 404B issue. And I have seen, without some explanation to the jury, when we use those sort of generics or whatever regarded the search, that can cause curiosity with the jury and they can get sidetracked. And so we will frequently use an instruction to the effect of, law enforcement's search of the backpack has been found to be lawful and you should not consider or concern yourself with that, right? And so it's basically telling the jury, don't speculate about this point or how we got to this point. It's not important and you're not to do it. And I think that generally causes them to back off that. And so that's what I'm suggesting that you try to work through.
Okay, will do. Thank you. That's all I have to say.
I didn't mean to cut you off. If you have
No, that's all I have to say. That was the only concern that was left for us.
Sure. All right, thank you.
Judge, I think that fairly states where we are. I was curious what the defense meant in their reply where they said that the testimony about the tip should not falsely suggest other evidence, and I still have no idea what that means. But we are happy to engage in discussion about a jury instruction like the court outlined. I will comment that it seems like it took a long time to come full circle because we're right back where the state started a long time ago with a lot of court effort invested in dealing with hearings in the interim. I appreciate the court's diligence with that. And I think also for the record, there were some pretty serious allegations, ethical allegations made by the defendant in its motion in limine number 11. Those were factually rebutted very clearly in the state's response. And I just want the record to reflect that the state maintains we did nothing ethically wrong with this, but we're satisfied with where we are right now.
Well, you know, sometimes we litigate issues for purposes other than evidence at trial, right? We do it in terms of constitutionality of searches and other things, and that's all okay. And I certainly have not made any finding that the state has done anything inappropriate, and so nor have I seen anything to suggest to me that that is the case as of this moment right now, at least, as it relates to that. To me, this is a practical problem. Regardless of the reasons you are in agreement, the important part is that you are in agreement. I suspect what the defense is suggesting, I think, trying to read the tea leaves, is they don't want an implication that there was some other evidence related to a tip or specific to Mr. Koberger that put him on the radar, right? And so I think that's just where you come. I don't think for those purposes we're suggesting that the state can't present its evidence about the car, suspected car, about the defendant's whereabouts on the night, et cetera. Those are things that were discovered and put together after the fact, right? I think it is important to develop a narrative that doesn't suggest, for example, there's some fact witness who may have heard a confession from the defendant or have witnessed the defendant that led to the tip, right? And so I think it's important how that's presented, and hopefully you can work that out, and if you can't, we'll revisit how to address it.
Yes, Your Honor, I appreciate that. And the state's intent, we've already spoken with the investigators to develop this, is to have probably Detective Payne, who is one of the leaders and lead investigators, to simply testify that they received a number of tips, that around December 19th, they received a tip. Following that tip, they took these steps. That's what we're contemplating at this point. Thank you, sir.
And so we have a pretrial in next month, and so hopefully you can come to an agreement on how this is going to be handled specifically by that time.
Yes, sir. Thank you.
Anything to respond to, Ms. Barlow?
No, nothing on that.
Thank you. All right, that leaves in category A by my score sheet the alternative perpetrator evidence, which is a state's motion in limine.
It's the state's motion. Do you want to sit here? Oh, I didn't see that one. Why is that one in there?
I just forgot it.
Thank you, Your Honor. And this is actually a very convenient transition. We're looking at the history of this case and investigation. Of course, we, the investigators, and the state went probably some 6 weeks following the homicides, and during that time received thousands of tips and tried to substantiate or discount whichever we could. Where we ended up is the investigators were unable to substantiate any tips until they received the tip regarding Mr. Koberger itself. The state's concern in bringing this particular motion is that the defendant is going to try to offer alternative perpetrator evidence based on what we would call mere inferences that another person could have committed the crime, and the case law in Idaho says they clearly can't do
So
that.
for purposes of your motion, are you talking about the defense's allegations of specific individuals? I mean, obviously, the defense claims the defendant didn't do this,
Yes.
which would suggest that there was an alternative perpetrator.
Yes. And the state's concern is about the defense focusing on specific individuals without meeting a threshold showing of connecting that individual to the homicides itself. And our concerns actually are reinforced by the defendant's response to our motion. When we're looking at pages 2 and 3, at the bottom of the page, the defendant says, "This case is full of alternative perpetrators. There are many alternative perpetrators." That suggests to us that the defendant is going to shotgun any variety of people's names, and we think that they can't do that without making the threshold connection first. Based on case law, based on rules of evidence 401, 402, and 403, State versus Meister is the most applicable case. We're seeking an order prohibiting the defendant from offering specific alternative perpetrator evidence without first having an offer of proof to the court that specifically connects this third party, this alternative perpetrator, to the crimes themselves. And then we would also ask that the court set a reasonable deadline for the defendant to give the state and the court notice, make their offers of proof so we don't have to encounter this in the midst of trial, that we can prepare adequately for it. So that's the nature of the state's motion, Your Honor. Thank you.
That's all.
Your Honor, we do, as the state indicated, plan on providing offers of proof regarding alternate perpetrators. There's nothing about our approach that would be a shotgun approach, throw a bunch of spaghetti at the wall and see what falls. We understand that it requires the conditions of Meister and that we need to provide that information to you. We are still in the process of doing investigation, as you know, with the amount of evidence in this case, and there's been a lot of briefing. There's going to be a motion argued about that. We are working as quickly as we can to put pieces together that make sense under the terms of Meister to present to you for that consideration with an offer of proof. So we understand the obligations. We won't be taking a shotgun approach. I would hope that the court would see that we are calculated and thoughtful in everything that we're doing in this case, and we wouldn't treat alternate perpetrator any other way.
I don't believe the state has anything further on that point.
All right. I think the parties are both correct in that State v. Meister is controlling here, where the court has spelled out that if the defense intends to present specific alternate perpetrator evidence, they have to make a factual showing that would, in fact, connect such a person, rather than just throwing names out or arguments or theories out without evidence to support that. I don't want to do that at trial. I think that's not enough time for the state then to investigate that. And I don't think there's enough time for the court to respond to that. And I think we'll waste a lot of time where we are not having trial as a result. And so what I would like to do is to look at a date shortly around the time of the pretrial to hear those proffers. And go from there. Now, things may, I'm not discounting the fact that things may unexpectedly happen after that, but in terms of what we are or should be aware of at this point, I think we need to flesh that out before we go down that road. And so I will I'll probably reach out with your calendars and set a date sometime around that pretrial, maybe even during that pretrial since you're here to take care of that.
Thank you, Your Honor.
All right. And I want to be clear, I don't view Meister as controlling. For example, I know this defense has suggested that they believe the evidence suggests that there was more than one perpetrator. From presenting that sort of generic, unknown, unsub, to use the part of the craft involved. But this relates more to allegations of somebody more specific, identifiable. All right. Let's talk about DNA, which is the inconclusive data, the statistical analysis, and the reference to touch and contact DNA. Let's take up the first two, and then we'll take up the third. I think the first two relate to kind of the same thing to a degree in terms of the science of statistics and probabilities and all that. There are really three issues, as I understand it. One relates to how to convey the statistics that DNA analysts use to more real world comparisons to, for example, planetary population. The second deals with DNA that was found under one of the victim's fingernails and by the DNA analysts as to whether or not Mr. Kohlberger could or could not be excluded. And then the third really deals with more sort of this labeling problem that we've already addressed in some fashion in different contexts of what labels should, can, and must we use as it relates to the quote-unquote touch DNA that was found on the knife sheath.
Yeah, yes, thank you. That's a great summary. And I'd like to start with the first the first point that the court noted, which was motion in limine number 14, which was the relationship of the world population to the statistic generated from the sheath evidence with Q 1.1. And I think we are in agreement that the state is not going to address that kind of question in front of the jury because their own analysts during the grand jury essentially told them that you can't do that given the statistic that we have generated.
I understand the state's response is that they will present the testimony consistent with the way that the witness presented it at grand jury.
Correct, and it was my understanding.
Not in a way in which the question was asked that the witness sort of corrected the attorney about.
Correct, and the objection from the defense was simply, and I think the witness explained this very well, was that the statistical analysis that the state's experts have engaged in does not allow that kind of comparison. It's not the standard statistic that we're used to anymore, and so by asking that question, you're triggering, you're conferring, or not conferring, you're speculating essentially, put in front of the jury. It's a question that presents a false premise to the witness. And so we just ask that the state refrain from that and simply ask the questions that elicit, the testimony as laid out in the grand jury proceedings.
Okay.
Excuse me. The inconclusive data, I don't know if the court has seen that late, I apologize, all of a sudden my voice is just disappearing.
Some water.
I don't know if the court has seen the latest filing from the state.
I did see it.
Okay, so they filed a new expert disclosure on Monday from an expert who went through and analyzed the data at issue. So as
response to the defense is having retained an expert who discussed whether or not you could exclude Mr. Kohlberger from the DNA found under the fingernails.
Yes, and what triggered that was the grand jury testimony where questions were asked of the analyst regarding the meaning of a conclusive versus an inconclusive data result. And the analyst testified as to 13.1, the fingernail swabs, that their data was inconclusive. And to the defense, and that means that you cannot draw any conclusions. So the defense retained cybergenetics, which uses a different statistical tool than the lab here, and generated a statistic which is strongly exclusionary of Mr. Kohlberger from that particular sample. And while that doesn't preclude the evidence from the state lab, it adds additional information to the picture, the overall picture. And it's
just a question for the experts to testify about and the jury to make its conclusion.
Well, I think that allowing the type of questions and apparently now the new conclusion that was in the state's response to our motion would be inappropriate and prejudicial and should be excluded under and you have to.
You want me to believe your expert and not their expert?
No, I'm not asking you to believe anyone in particular. However, what I am saying is that the amount of time and energy it will take to explain what inconclusive means is essentially far greater than
Sorry, there's movement in court. I don't know what it is. I think it might be just to dismiss the jurors for the day. Oh, both of the sons are there, I think. So you guys can hear me, all right? So let me just adjust this 1 second. Yeah, so we are back in court. I don't know what it is. I don't know if it's a verdict or anything. I don't know. I don't know what it is. So all the three boys are there. Everything is fine. Everything is fine. Well, so yeah, I think they are gonna be just dismissed for the day. I don't have heard of a verdict or anything. I haven't heard anything whatsoever. I just saw the court start moving. It might be just for the simple fact that they are gonna go home. Sound is on, everything is on, so we'll just see what's happening. I think it's they're gonna be dismissed for today. I think they are gonna come back Monday for it. So yeah. So what do you guys think? Do you guys think we have a verdict? Do you guys I think they're gonna come back on Monday. So I think it's gonna be they are gonna go home. I think for sure they are gonna go home. I don't think they are. Yeah. So yeah, I know, isn't it? So it's I'm already creating the live stream for Monday, and still with like for this one, I'll still continue the verdict watch. So, I will stop once the jury comes back on the system. I'll stop the clock. Or should I stop now? I'm gonna write it now just in case. 7 hours, 15 and 37. Obviously Monday it resets. So I same Cowboys, same, absolutely. Uh, huh? Someone just You know what, Paula? I read that just someone just robbed your son's arm, the son's arm, and I was like, huh? What? Yeah, no, never mind. Yeah, I don't think there's no verdict, Paula. Yeah, I know, right? The prosecution side is packed and no one is behind the defense. Well, not yet, but the data should be coming soon. I think, and that oh, I did not notice was that the pillows of the courtroom in the courtroom. So there is the sons. They are both in court. Um, I think that's the spouse of one of them. I know, but there is no word of a verdict. There's literally I got no notifications whatsoever. I think it might just literally be home time. So oh, I honestly don't know. No, but the oh my god, that is great. I know they are actually quite cute. I'm not gonna lie, they are quite cute. So I don't know. Well, they might not know that it's dismissed. I don't know. Paul, Stephanie. Sorry, I'm confusing people's names now. Um, like she's yeah, I know. I get that. I honestly get that. I still don't know. They are not saying anything on TV or court TV or LNC or anything. Don't worry. I've already pointed out. A child. Oh, I did not see that. I haven't seen anything. Okay, so we are told that they are gathering for an update. Not sure if it is a verdict. Um, I don't want to put like verdict out there when it's not a verdict, but I absolutely have no clue. But um, I don't want people to miss it, so I don't know. Um, Yeah, I agree. Like, why is there a kid there? So, yeah. No, Paula. No. Like, not right now. It was still trying to confirm if there is a verdict or not. I still don't know. So I'm not gonna play the song, the verdict song, because I am not sure. So, and I don't want to give you false hopes. Um, I honestly don't know what's going on. All I know is I am freezing. I don't know why. I don't know why right now I'm absolutely freezing. Uh, yeah, I know. Be safe. Yeah, definitely, Paula. Please be safe. Make Lee drive. Make him drive. He needs to drive you if he can. It's possible verdict time. We don't want to lose that. Why am I not listening in? Well, it's normal. Oh, he isn't going. Make him go just to drive. Uh, sorry. Um, but stay safe for sure, Paula. I'm so sorry, my friend. Um, oh my days. It might be just an update for them to go home to be dismissed for the day. I don't want to get hyped up for it because it might be just literally an update. I feel bad for mom. She's gonna have to go probably for another weekend of pain and everything, and thinking and wondering if her son is ever gonna get justice. Um, so I do feel bad for Todd's mom. It's not easy, that is for sure. Um, well, it could be even a hung jury. They could just say that they cannot come to a conclusion. Well, defense side is starting to fill up a bit. There's a few people there, and we're back at the seal event, and I'm back to the seal. I guess maybe people are coming in. I don't know. There is definitely a lot of movement. There is definitely something happening. That is for sure. So we'll just have to sit and watch what's happening. Who thinks verdict? Who thinks going home? Oh, you have to put you on my phone plugged in and on my. Well, no, we don't want that, Paula. I will be mindful of the music because I don't want you to be scared with the music if there is a verdict, if it is a verdict or not. I'll definitely be careful with that. Oh my days. This has been one of those crazy days, crazy long days. I mean, if we had a trial, that probably would be okay, but with no trial and been going like jumping into hearings and everything, it's cool and all, but I prefer trials. Um oh my days, what's up? What's wrong? What happened? Wait, no, do you know anything, Lewis? Tell us. Sorry. Going on, yes, I think so. Well, yes, I was supposed to take today off. That one out of the window. Well, I will have some sort of early night compared to the time I've been finishing. I'm gonna have an early night. Woohoo! Oh my days. Um, will Linda come back in for the last time in a courtroom and get out in handcuffs? Or will she come back on Monday and have her last weekend of. Oh, you are imitating me when I say oh my days. Okay, all right, fair enough. I do say that a lot, don't I? But it's literally an English thing because God and Bot does the same thing. So, we want to see Linda. Come on. Oh, sorry. I have like in front of me. I have the meter thing of the electric because I like to keep an um a meter of the electric in front of me, and at 10 p.m. it goes off, and it just scares me because it turned off. Sorry, there was an update, so we're not sure what is going on for certain. They are gathering in court. It could be a verdict, but we have no information or confirmation on that. Could be a verdict, could be not, could be just a dismissal. We don't know, but I mean, I think they would gather everybody because they would not say to everybody what it would be. So it's just, I'm a little bit anxious actually. I don't know. I don't think it is a verdict. I think it's just dismissal, like they're asking to go home or anything. So, but to be fair, if it was a jury question or asking to go home, they could have said that. So, not clear. Well, we can speculate all we want, really, because it's one of those things that we do in here is speculate about what could be or not. I just really want to see Linda coming in to see her face because literally today could have been her last freedom day. And that goes back to what we were talking earlier about the mentality of um, a defendant in the deliberation day. Um, but, so yeah. So, quick question, because I've had several people telling me, has anyone had problems finding the chat for the stream when I'm live or anything? Ooh, the daughter is dressed up all nice. Did you see that? Wow. Was she at somewhere? Like, she was. Which daughter is that? Well, like, because we have only seen one of the daughters, I think, right? That she was dressed up nice. That was very, very nice. I mean, that dress was eye catching, definitely for thing. So, oh, you find me just fine, yeah. yeah, maybe fancy later, maybe court now, and then it was like goes to the date later. Very fancy. Oh, okay. No, it's just because I had a couple of people telling me that they struggle to find. Oh, okay. All right, that's cool. Thank you. No, it's just because I've had several feedback from people saying that they've been struggling finding the chat, even on replay or anything. So, oh, okay. Thank you, everybody. You guys are amazing. I don't know. Sometimes YouTube is just different for people, for different people for some reason. I don't know why they do that. It's absolutely crazy that YouTube for one bus it could be just fine, and for another one it's absolutely crazy. um oh, I think the bailiff might be looking for some. Oh, asking for Linda to come in because she can go. I think they are going home. Yeah. Ooh, here we go. Sound.
Court calls the case of People versus Linda Stermer. Counsel are present. Ms. Stermer is present. I've been advised by the jury that they've reached a verdict. And to members in the audience, please, I know there's a lot of emotion involved, but when the verdict is read, please remain silent. And also, the jury has indicated a desire to leave immediately after their verdict, so we'll all wait in the courtroom, give them 5 minutes to clear out of here. The record should reflect we only had one question from the jury, which was a request for exhibit log. Everybody agreed to provide that to them. And other than that, anything else, counsel, before we bring in the jury?
No, Your Honor. Oh, I do believe there was maybe a potential question where they asked if they could open a piece of physical evidence.
Oh, I forgot about that.
But I believe that,
Right.
I think that was the only other thing.
Okay, yeah, thank you, I forgot about that one. Anything else then, before we bring in the jury? No, we'll bring in the jury for verdict. Okay, jury, I am advised that you have reached a verdict, and the clerk of the court will now accept the verdict. We'll have the foreperson please rise.
Has the jury agreed upon a verdict?
Yes, we have.
What is your verdict, please?
We, the jury, find the defendant guilty of first-degree premeditated murder. We, the jury, find the defendant guilty of first-degree felony murder.
Members of the jury, listen to your verdict as recorded. In regards to count 1, guilty of first-degree premeditated murder. Count 2, guilty of first-degree felony murder. Is this the verdict of the foreperson?
Yes, it is.
Is this the verdict of the jury?
Yes, it is.
Okay, you can have a seat, sir. We're going to poll the jury now.
If you could pass the microphone to juror in seat number 1, please. Juror in seat number 1, is this your verdict?
Yes.
Juror in seat number 2, is this your verdict?
Yes, it is.
Juror in seat number 3, is this your verdict?
Yes, it is.
Juror in seat number 4, is this your verdict?
Yes, it is.
Juror in seat number 6, is this your verdict?
Yes, it is.
Juror in seat number 15, is this your verdict?
Yes, it is.
Juror in seat number 14, is this your verdict?
Yes.
Juror in seat number 13, is this your verdict?
Yes.
Juror in seat number 12, is this your verdict?
Yes.
Juror in seat number 11, is this your verdict?
Yes.
Juror in seat number 10, is this your verdict?
Yes.
Juror in seat number 8, is this your verdict?
Yes.
Thank you. Counsel, if you can approach to review the verdict form, please. comport with the verdict we just received in open court? Yes. Comport? Okay. I've now received the verdict and confirmed that it comports with the verdict received in open court and confirmed by polling. So, verdict having been received, I now thank you for your service. This was a very significant and time-consuming case. We were worried we would not get a jury to stay through it all and work through it all, and it was a lot of work. I've never had a jury ask as many questions as you did. So on behalf of all of us here, I want to thank you for a job well done as far as listening to the evidence and paying attention to everything and taking the serious time to deliberate the case as well. So thank you, and we're going to have everyone here wait in the courtroom a bit. I'm told the jurors want to get out of here and go, so we'll stay in the courtroom and give you guys the space to get out of the building, and thank you. And you're done. You can watch the...
Oh wow, I still have the clock there. Sorry, never mind. I forgot to take the clock out. I'm professional. I'm just all over the place right now. But wow. So Linda got guilty across the board. Justice indeed. Okay. Yes, indeed. Across the board, felony, unaliving, and the arson. So, yeah. So. We chat about the
council will need to schedule a sentencing date.
Your Honor, I've been
Okay, Law and Order was like, okay, we are out of it. I will try to find the sentencing dates at another time, but let me watch if Court TV went live, because literally they were like, okay, yeah, we got like we out of it. We don't. Hang on, is this live? No, this is not live. Hang on. I was trying to see if I can find. Nope. Law and Crime was like, yeah, no, I'm up. That's it. I'm taking it down. There's no more information about this case. It's not. They literally took the feed down. They did not show much, but I will try to find some information on it. I'll try to see if when is the sentencing, and Linda Stermer got found guilty of all counts of first degree unaliving and the arson as well. So she is gonna go. Well, her sentencing probably will be again at life in prison. So yeah, way to go, Stephanie. You got a 7 to 27 indeed. So I've got to announce that the winners of the verdict game on this round is Zizzy, Sherry, and Stephanie. So jury got it right. I feel that jury got it right. So the winners are Stephanie, Sherry, and Zizzy. So I know, Paula. I know. Denise, we need to talk. We definitely need to talk. So, well, I mean, the expert is getting it wrong again, so I don't know. No, I'm joking. Congratulations, Sherry, Stephanie, and Zizzy. Zizzy's not here with us today because she's traveling. I hope her travels is going well. Rubba, hello, welcome back. Yeah, you missed the verdict, girl. You can go back. Yes, yeah, the verdict is gone and done. Law and Crime was like, yeah, sure, bye. She gone. We're not gonna stay here anymore. So literally they took the feed down. Yeah, sorry, just rewind a little bit. I can spell it for you. But Law and Crime was like, yeah, no, we're going home. It's Friday. We're done. But yeah, so that was I was blindsided. Anyone blindsided because I was like, oh, okay, they are gonna go home. They're done for the day. It's 5 o'clock. um we'll be done, we'll go home. Nah, when they say verdict, I was like, so I was just like, oh my days, it's a verdict. It's a verdict. So, like, I'm kind of glad it's verdict because I am not gonna lie, I can take half of the Monday off. I did not expect it. I was definitely blindsided. I was like, what is going on? A verdict? So absolutely crazy. So definitely, but I am very glad that justice got served for Todd Stermer. I mean, she's gonna appeal again, but I don't think in this new one she's gonna appeal. So, um, yeah, we are to here. Keep everybody in courtroom until we are out in the building. Yeah. Um. So I did not think that the verdict was gonna come today. I absolutely was like, well, what? ¿Qué pasa? I don't know. So there you go. Have a great weekend, Robert. I'll see you around, friend. I'll see you definitely during the weekend or next week, definitely. But yeah, so that is a wrap on Linda Sterman. I am not surprised that the verdict was this. I was expecting that the verdict was going to be this. We still need to finish Brian Koberger's hearing at some point, but I think we're gonna do that another day. So the reason that she got to the second trial was she appealed her conviction from the first trial, and there was some prosecution misconduct from the first one, and she claimed that the defense on her first trial did not call a fire expert to rebuttal the prosecution one, which in this one did, but it wasn't enough. So that is what why she got a second trial in the first place, Emily. So this fish is not going to fry itself. So you guys have a great saving weekend. Have a great weekend as well too. Ineffective counsel as well. Yes. So yes, she's facing life without the possibility of parole. But to be fair, I'm not gonna be mean. I don't want to be mean or anything. But at her age, anything that she gets is gonna be life. So there's nothing. You know, I don't want to be mean or anything, but that's what she's facing. She's facing life, but whatever sentence it would have been, it's a life sentence for her. But I don't think I mean, if the first appeal took 8 years to come through and to go through and everything, she's gonna be in her well into her 70s when this other second appeal will come through. So I don't know, but I don't think in this one she can say ineffective counsel because they fought for her with tooth and nail. They literally did everything and went beyond everything to on literally on everything. So absolutely, I don't think in this one they can she can complain about the fact that she had ineffective counsel. So yeah. Oh yeah, exactly. That is very true. And she had 8 years of freedom that she shouldn't have had. Absolutely agree. Oh, William, it's okay. We're gonna have a lot of more trials to do it. See, I wanted to see them that as well, but Law and Crime was like, yeah, no, it's the weekend. We're going home. We going, guys. But so it's yeah, so yeah, I know why it took 8 years. I don't know why it took 8 years. Was absolutely crazy. But I am gonna end stream here. Garden bot is sleeping. I need to be a bit mindful of that. And to be honest, I really want to go sleep as well. It's been a long week, a crazy week, and next week is gonna be more of the same. But I'm gonna love you and leave you all. I'm gonna wish you a great weekend. Have a great time doing what you guys do. Have a great evening, and I'll see you Monday for Laurie Dingbell, Valo Daybell. I'll see you all then. Bye.
And I'm a real-time crime professional.